Public hearing for the Senate Legal and Constitutional Affairs Legislation Committee's inquiry into the provisions of the Migration Amendment Protecting Migrant Workers Bill 2021. The committee's proceedings today will follow the program circulated. These are public proceedings being broadcast live via the web and in Parliament House. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senator as a contempt. It's also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. I ask both senators and witnesses appearing via video conference and teleconference to unmute your microphone only while you are speaking. At other times, please mute your microphone to limit audio interference. Mobile phones and electronic devices should be switched off or turned to silent mode. And with the formalities over, I would like to welcome everyone here today and also explain that unfortunately I'm not in Canberra in person chairing this hearing. I am in isolation doing this from my home, so I apologise that it is a little bit clunky, but thank you very much for your patience today. I'd now like to welcome representatives of Fragaman. Thank you for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 6. Could you just confirm for the Hansard record your full names and the capacity in which you appear today, and whether you wish to make any corrections at all to your submissions?
Thank you, Chair. It's Cherie Wright. I'm Special Counsel at Fragaman, and with me is my colleague Charles Johannes, who is also Special Counsel with Fragaman, just confirming that we don't wish to make any amendments or updates to our submission.
Thank you both very much. We will now go to questions from senators, and I would like to give the call first to Senator Ciccone.
Thank you very much, Chair, and good morning to our witnesses. Look, I just wanted to start by just gaining an understanding of the size of the migrant worker exploitation in Australia from your perspective, and also how does this impact, I guess, the clients that are relevant to you, to their businesses that you represent?
Thank you. I'm happy to take that initial question. And I think certainly as it relates to our clients, we represent a sort of a range of clients, including some of the world's largest multinational corporations, major Australian corporations, small and medium-sized businesses and startup companies. I won't say that exploitation doesn't happen at all in those organisations, but certainly we don't tend to see, that to be a particular issue within our client base. Having said that, I've worked for many years, and Charles has as well, with a number of community legal centres, specifically Redfern Legal Centre, which deals a lot with international students, and there we did see a lot of work exploitation, specifically situations where those student visa holders were working in excess of their allowable 40 hours per fortnight, and were doing so because they weren't being paid the award hourly rate at that time.
And I guess what was any support that you were able to provide or advice to your clients with respect to that?
Yeah, I mean, I think particularly with respect to the work that we did with Redfern Legal Centre, one of the issues that we identified was, of course, the concern for those visa holders to come forward and report breaches, and particularly to assert their workplace rights, where they were concerned about cancellation of their visa because they had been working in breach. And I think that as it relates to the sort of current bill, that is something that still does concern us in terms of where, how the visa holders would be impacted if they were in breach of those sections 245 AAA and 245 AAB and they're reported. Where the visa holder has worked in breach of the conditions, the bill in its current form doesn't really provide any protection, in our view, to those visa holders in the event of visa cancellation, because it would still be open to a delegate to cancel their visa, even in circumstances where they're reporting employers under those provisions.
Yeah, and look, I do note in your submission you suggest a number of amendments to the bill. Which, I guess, if any of these amendments do you think or consider critical in terms of ensuring that the bill remains effective?
I think, I might kick this off and perhaps Charles may wish to add to this, but I think where we are talking about proposed sections 245 AAA and 245 AAB, and this is where it's making an offence to coerce or unduly influence or pressure a migrant worker to accept a work arrangement in order to satisfy a work-related visa requirement. As we mentioned in our submission, we recommend further clarity as to what might constitute an arrangement in relation to work under these proposed sections, really so as to avoid inadvertently penalising employers who seek to vary an employment arrangement to ensure compliance with visa conditions in circumstances where the non-citizen may be reluctant to accept the arrangement. And we see that this could arise, for example, in situations where an employer requests a non-citizen to temporarily stand down from their employment arrangements because the employer has discovered a breach of a work-related condition. So, for example, where a non-citizen's visa status has changed from a bridging visa to a student visa within the 3 months that a VIVO check has been undertaken, in that scenario, it may be necessary to temporarily stand down the student holder's employment until which time that their course of study has commenced to ensure that they comply with condition 8105 on their visa. Another scenario which, given our client base and the high utilisation of the employer-sponsored visa, we think is a fairly common scenario, could be where an employer has identified that a sponsored 482 or 457 visa holder has taken on additional duties, resulting in that visa holder working outside their approved ANSCO occupation that they were nominated under. In that scenario, the employer may amend the non-citizen's duties to ensure that the position continues to align with the approved ANSCO occupation, and the non-citizen may allege that the employer exercised undue influence in requiring them to move to that arrangement.
Because I note on page 2 of your submission, you say that there's a need to further strengthen employer sanction provisions to protect migrant workers against wage underpayment and other exploitative practices by unscrupulous employers. I was hoping you might be able to expand on that point, and I guess in your experience, how common is wage theft and other exploitative practices?
Again, talking about my experience working with in the community legal sector, I would certainly say that for international students that we do see prevalence there in relation to things like wage theft. And I think, as I mentioned earlier, a very common scenario that we would see is someone working either cash in hand or working in excess of their allowable 40 hours a fortnight because they're being paid well below the award rate. So certainly as it relates to those international students, I think it is fair to say that we've encountered that unfortunately many times, where you have a student who is in a very vulnerable situation there and they have been working in breach of their visa because they're being underpaid.
Are you able to comment on your engagement with respect to the exposure draft process?
Yes, so we did provide a submission in response to the exposure draft bill that was provided towards the end of last year. We were very pleased to see that some of the recommendations had been adopted as part of the bill. And then, of course, we did provide a further submission in relation to the bill as it currently stands.
I guess my next question goes to to what extent have your concerns raised during that process been addressed in this version currently before the Parliament?
And I think, Charles, I might hand to you here, but I think our major concern was with respect to part 3 of the exposure draft in the bill, which relates to the necessity to utilise Vivo as the single source of truth, as the department refers to in the exposure draft. And that was specifically in relation to, at that time, the exposure draft did not appear to allow for any alternative evidence to be provided as it related to evidence of Australian citizenship when checking those work rights. But Charles, I'm not sure if you might perhaps want to chime in here.
Yes, thanks, Cherie. So I think the proposed sections as they stand, they do impose a positive obligation on employers to undertake ongoing Vivo checks for all temporary visa holders, including those where the employer has a direct sponsored relationship through their employer. And we've submitted that this would impose an unnecessary additional administrative burden upon employers to undertake ongoing Vivo checks for sponsored employees. Similarly, one other scenario that kind of factors in a similar consideration is for employees who may hold, for example, a 444 visa, so a special category visa held by New Zealand citizens. So I think our main concern around this amendment is just that we want to ensure that there is a balance around that the obligations don't impose an unnecessary administrative burden on employers, but at the same time does ensure that there is a positive obligation on employers to take reasonable steps, positive steps to ensure that the individuals that they're employing do have appropriate work rights, which I think was a point of ambiguity, is a point of ambiguity in the current legislation. Currently, the legislation talks about taking reasonable steps at reasonable times, and that being a defence. However, it doesn't actually impose a positive obligation to undertake Vivo checks. So that particular aspect of the amendments, we're pleased to see that there's clarity around it. But as I mentioned, we're wanting just to ensure that it doesn't impose unnecessary administrative burden on employers.
I note you make reference to concerns with respect to a lack of flexibility in the proposed amendments with respect to Vivo. Are you able to just expand on that a bit more?
Yes, so I think in terms of the flexibility around Vivo, I think the provisions, the amendments proposed require that the employer takes ongoing steps to ensure that the individual has appropriate work rights during their employment. So the flexibility that we refer to is for certain cohorts where, for example, the visa status is very unlikely to change. So I take the example of the earlier example of the special category visa holders, the 444 visa holders, where it's very unlikely that their visa status would change while they're in Australia. I think that would be there'd be a very low likelihood of that occurring. That could potentially extend to provisional visa holders, other temporary visa holders, which are, for example, the subclass 485 graduate visa, which is a visa that could be approved for any period between 18 months and 4 years. It's very unlikely in those circumstances that the individual's visa status would change during that period. So our recommendation is that there should be clear guidelines from the department as to what constitutes reasonable steps on an ongoing basis to ensure those types of visa holders maintain appropriate work rights. And again, there's not unnecessary ambiguity or administrative burden around those cohorts that present lower risk, and particularly those who don't have such a strong connection to the employer in terms of further visa pathways as students and other visa holders, other vulnerable visa holders might.
And it's fair to say you consider this bill to be fairly important for your clients and also for the workers, I guess, that need protections. Do you have a view about, I guess, the length in terms of time frame it's taken for the government to introduce this legislation? Like, are you frustrated it's taken a long time for them to bring this bill into the Parliament?
Don't think we have a particular view on that, beyond to say that we do welcome, obviously, measures to protect vulnerable workers. In our experience, and certainly as it relates to our client base, they do obviously strive to do the right thing. It's not to say that breaches don't occur, and often they are inadvertent breaches, but I think particularly as it relates to very high users of, for example, the employer-sponsored visa program and high employers of student visa holders, I think it's important to strike that balance to ensure that they are not sort of imposed with unnecessary administrative burdens, as Charles has mentioned, and get some guidance around how often they should be checking the work rights and the frequency of those checks.
And it's worth noting that the Migrant Workers Report was released back in March 2019. It's taken, I guess, almost 3 years to get this bill, but it's good to see that you've provided a submission to us today. Chair, I might leave my comments there for now and happy to hand over to other senators.
Thank you very much, Senator Ciccone. I'm now going to hand over to Senator Van.
Thank you, Chair, and thank you for appearing today. It's most helpful. Overall, can you articulate for us how you see this bill contributing to the protection of migrant workers?
I think, as we said earlier, certainly we welcome the bill, and I think particularly identifying that non-sponsored visa holders are in a vulnerable situation, and by that I predominantly am referring to visa holders such as working holiday makers and student visa holders, whereby sort of temporary sponsored visa holders obviously have some protections under the Migration Act by virtue of this sponsorship framework and obligations that are imposed upon employers. So we believe that the bill certainly does go a long way in terms of providing those protections to those more vulnerable temporary visa holders. However, noting sort of our earlier comments regarding concerns as to whether or not the bill does go far enough as it relates to protecting those vulnerable visa holders that have been in breach of their work-related conditions, and they would still be liable for cancellation from the department. So whether or not there does need to be some guidance around those scenarios and perhaps offering a level of protection to visa holders that are trying to assert their workplace rights but have been working in breach of a work-related condition.
But you would agree that this bill will protect the most serious breaches, would you not?
Yes, we would agree. Yes, we would.
And you would also agree that as a government, we owe a duty to Australian citizens to both protect workers but also maintain law and order with regard to migration and the Migration Act?
Yes, I think we would agree with that comment.
I note in your submission you talk about the benefits of the transparency of publishing information on prohibited employers, and you recommend an amendment that would change the timeframe from as soon as reasonably practicable to a timeframe of no more than 28 days. Why 28 days? Why not, what's wrong with as soon as practicable? Because, obviously, we don't want to have an unlimited public service. We want to make sure that we're not overworking our public service. So what is wrong with as soon as practicable?
I think what we were looking for there was a definitive time frame. And the 28-day period suggestion, and again, Charles, please feel free to jump in here, but really that was to align with some of the other sort of reporting measures that the Department of Home Affairs has imposed under in particular, the employer sponsorship framework.
Okay, thank you. Thank you, Chair.
Thank you very much, Senator Van. Look, that concludes Senators' questions. I want to thank you both very much for your time today. and for your commitment to assisting us in relation to this bill inquiry and for your evidence.
Thank you very much,
Thank
Chair.
you. Thanks, everyone.
Thank you so much.
Thank you.
I'd now like to welcome representatives of the Electrical Trades Union of Australia, the Australian Council of Trade Unions, the United Workers Union. Thank you all so much for taking time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 3, 9 and 14 respectively. For the Hansard record, could you please each state your full names and the capacity in which you appear today, and also clarify whether you wish to make any corrections to your submissions at all?
Happy to start things off, Senator. Liam O'Brien, Assistant Secretary for the ACTU. I think I'm also supposed to be joined by Claire Middlemass, but I don't think she's on just yet. But I might hand to my colleagues to introduce themselves.
Thanks, Mr. O'Brien. Ms. Verma, can you hear us loud and clear?
Yes, I can. Sorry about that. I think
That's okay.
my colleague George Robertson was on mute just then. My name is Sanmati Verma. I'm an accredited specialist in immigration law, and I work for the United Workers Union. And I'll pass to George, who I think was speaking just a moment ago.
Yes,
Thanks.
apologies for that. Yeah, George Robertson, National Coordinator at United Workers Union.
Thank you very much, Mr. Robertson. Would any of you like to make a brief opening statement before we go to Senator's questions?
Senator, I think a couple of us would like to make a brief statement, if that's okay. I'm happy
Yes,
to.
Mr. O'Brien.
Thank you. And thank you to the Senate for the opportunity to provide evidence to this inquiry. The Australian Union is deeply concerned about the widespread and systematic exploitation of temporary migrant workers. They are highly vulnerable due to the power imbalance.
Mr. O'Brien, I'm sorry, I apologise for cutting in. Could everyone else please put their microphone on mute? I can hear some background interference. It's just obviously a little bit awkward when so many people are attending via video conference or telephone conference. There's someone in particular who's making lots of background noise.
Coming from the committee.
Would you like to start from the top?
Yeah, thanks, Senator. I think it's coming from the committee room, but I'll persist. Again, I'd like to thank the Senate for the opportunity to provide evidence to this inquiry. The Australian Union Movement is deeply concerned about the widespread and systematic exploitation of temporary migrant workers. They are highly vulnerable due to the power imbalance with employers. Migrant workers are not only dependent upon their employer for a job, but also for their right to stay in this country. And we believe that comprehensive reforms are required to the migration system and to workplace laws to prevent and address the exploitation of migrant workers. Unfortunately, this bill does nothing to address this power imbalance. It has two fundamental flaws. First, it seriously underestimates the scale of this problem. We're not dealing with, as some have described, a few bad apples here, as countless reports, parliamentary inquiries, media investigations have found migrant workers face exploitative practices that are systematic and widespread and are not being effectively addressed through the current regulatory approaches. This points to the need for a complete rethink on how we tackle this problem. If this monitoring, compliance and enforcement framework is not working, then simply creating new offences will not be sufficient to protect migrant workers. Secondly, this bill relies upon migrant workers to come forward and report exploitation without providing them any protections or incentives to do so, or addressing the factors that make them vulnerable to exploitation in the first place. We know that migrant workers are unlikely to report workplace exploitation due to the very real fear of being deported or unable to secure a visa in the future. And this bill fails to provide them with any protections to come forward and make a report. There's obviously a report today in The Guardian that illustrates the dire situation that this places migrant workers in. Their employer is found to have acted improperly. The workers' visas can be cancelled, meaning they have to find another employer sponsor in a time frame as short as 60 days or be forced to leave the country. Finally, we're alarmed that this bill is being used by the Morrison government to claim that workers under the new agricultural visa will be protected from exploitation. We're already seeing shocking cases of exploitation under the current visa schemes, including under the Pacific Australia Labour Mobility Program, which is regarded as one of the better regulated programs. I'm also joined by the UWU, who will discuss some of the barriers that migrant workers face in coming forward to report exploitation and why the bill is insufficient to protect migrant workers, and also the ETU, who would like to discuss 2 recent case studies through the lens of how the proposed bill will not meet the necessary protections for those workers and be ineffective in those cases. So I might hand over to my colleagues at the UWU.
Thank you, Liam.
Thank you, Mr. O'Brien. Look, before we go to any other opening statements, we have been joined by a couple of other witnesses. So, Mr. Gould, if you could just introduce yourself and the capacity in which you're appearing, and then we'll go to Ms. Middlemas, and then we'll go to any other opening statements.
Thanks, Chair. Trevor Gould, National Policy Officer with the Electrical Trades Union.
Thanks, Mr. Gould. And Ms. Middlemas?
Thank you, Senator. I'm Claire Middlemas, the International and Civil Society Officer at the Australian Council of Trade Unions. Thank you.
Thank you so much. Do any other witnesses represented today, do you have an opening statement?
Yes, we do, Senator. So United Workers Union represents over 150,000 workers across 45 industries, including thousands of temporary migrant workers. The evidence before the government, including the government's own Migrant Worker Task Force and the National Agricultural Labour Advisory Committee, confirms what we see on the ground every day, which is that the exploitation of migrant workers in Australia is both widespread and systemic across the economy, as well as particularly concentrated in those industries where there are supply chain pressures and a reliance on insecure work and labour hire contracting arrangements. And for example, in the horticulture industry, there are up to 100,000 undocumented workers who make up to 90% of the workers in some growing regions and who are some of the most exploited workers in the country. In our view, any legislative response to this crisis needs to be based on the recognition that the exploitation of migrant workers in Australia is not limited, as Mr. O'Brien said, to a few bad apple employers, but is entrenched and endemic, and it must be focused on addressing the substantial barriers and disincentives for migrant workers to take action, report exploitative employers, and it must provide migrant workers with concrete guarantees that reporting exploitation will not adversely affect their own visa status and that they can remain in Australia when they do so. And unfortunately, in our view, this bill does none of those things, and we just make 3 observations about those 3 key deficiencies. The first is that there are existing employer sanction provisions in the Migration Act that have already proved to be overwhelmingly ineffective and underutilised. And as we set out in our submissions, there have only been around 1,000 employer sponsors who've been sanctioned under breaches of the employment-related sponsorship obligations as a result of enforcement activity. And in the same period, some 270,000 visas have been granted. So despite there already being ample and broad employer sanction provisions under the Act, the exploitation of temporary migrant visa holders remains rife and endemic, and the sanction provisions are really called upon to remedy it. Secondly, the second issue is linked to the first, and that is that visa holders are placed at risk by sanctions against their employers, and the employer sanction provisions are underutilised because workers have no incentive to utilise them and in fact may harm their own visa status if they do so. And the bill before us makes no provision whatsoever to address this. Thirdly, the bill ignores the realities, the economic realities under which migrant workers live and work in Australia. In particular, there's a formidable body of academic literature in Australia which connects temporary migrant worker exploitation to rigid and inflexible visa conditions and a proliferation of temporary visas with onerous qualifying requirements and a lack of visa options, in particular for those visa holders that have been subject to exploitation. You add to this the profound economic impacts of the pandemic and the fact that temporary visa holders have been entirely locked out of federal and most state-based income support packages during the pandemic, means that workers have had to continue to do whatever they can to work in order to survive, rendering them as susceptible as ever to exploitation. We've made a number of recommendations in our submissions around how the government can address some of these fundamental challenges facing temporary migrant workers. I'd just like to highlight a couple of key recommendations. The first is that it's crucial that the government undertake reforms to the visa system to improve visa security for temporary migrant workers. Workers who've been exploited at work should have easy access to what we've called an employment justice visa. And access to a substantive visa like this would enable workers to escape an exploitative employer, remain in Australia, and pursue a cause of action for unpaid wages or other breaches of law. And this would encourage and support victims of exploitation to come forward. And in particular, in the horticulture industry, where there is a structural reliance on undocumented workers, the government needs to implement the recommendations of its own National Agricultural Labour Advisory Committee to establish a status resolution process that would enable undocumented workers to apply for a substantive visa. Status resolution would enable undocumented workers to continue their essential work in the horticulture industry while enabling them to escape their current exploitative employment arrangements and report dodgy labour hire contractors. Unless the government include reforms such as these as part of a comprehensive response to migrant worker exploitation, the proposals in this bill to enhance enforcement activities and penalties for employers will at best prove as ineffective and underutilised as the existing provisions, and at worst will harm the workers the bill purports to aim to protect. Thank you, Senator.
Thank you very much, Mr. Robertson. Any other opening statements? If there are no other opening statements, we will go to questions from senators, and I will give the call. Senator Ciccone, you're seeking the call?
I am. Thank you very much, Chair. And
Well, generally, just for the, sorry, I didn't reference this before, we'll sort of generally try to work in 10-minute blocks. And over to you, Senator Ciccone.
thanks, Chair. Well, good morning to our witnesses. Can I just start with a couple of questions to the panel? Now, you consider that without broader policy reforms, the bill's unlikely to be effective at reducing migrant worker exploitation. To what extent do you consider the bill in its current form would improve protections for migrant workers, or do you believe that there would be no improvements? Maybe if we could start off with the ACTU, perhaps.
I think the problem, Senator, is that it fails to address the real issues that temporary migrants are facing, specifically the issues around how temporary migrants rely upon the single employer sponsor, not only for their job, but indeed for their visa and the ability to stay in this country. And unless we deal and tackle with that central problem, addressing it by additional penalties is not going to improve the situation. We have to tackle this central issue, and that's why we need things like whistleblower protection that will allow workers who are facing exploitative arrangements to come forward safe in the knowledge that disclosing this exploitation is not going to put their status as staying in this country at risk. Clearly, this is the biggest concern that my colleagues have also alluded to that migrant workers face. But I might offer it up to my colleagues to supplement that as well.
Sure, I'd be happy to respond to that from the United Workers Union point of view. Our overarching view is that however much we may agree with the spirit of the bill, it really does not correspond with its stated purpose, that really the provisions will do little, if anything, to benefit migrant workers who have been exploited. And when we talk about reforms, we need to be specific about what we're talking about and what we see as being really the underlying causes of migrant worker exploitation. The first deep problem with the sanction provisions that are introduced by the bill that mean that the current sanction provisions under the Migration Act have been underutilised are that they rely upon workers coming forward to report essentially breaches by themselves and their employers sort of in concert and provide no protection whatsoever against visa cancellation. It is, unless this government intends to spend millions of dollars on enforcement actions and have thousands of ABF enforcement officers out in workplaces across the country, which we cannot really see happening given the number of migrant workers that are employed in the economy, then essentially such provisions really rest upon people coming forward to report what's happening in their workplace, and there's really just no incentive for them to do so. There's not even a contemplation of ameliorating even something simple as departmental policy settings when it comes to visa cancellation. So that's the first thing. The second reality that the bill just does not correspond with it at all is that visa conditions are rigid. There's been a long-standing concern about, for instance, the 40-hour work limits that apply to student visa holders and really don't correspond with the reality that student visa holders find themselves in. And it's, particularly concerning that the bill and all of the debates surrounding it have made no mention of the rigidity of that condition in circumstances where the government has seen it fit to ameliorate the 40-hour work limitation when it benefits the economy. So, for instance, if students are packing shelves or if students are doing horticultural work, but not when it comes to students coming forward to report exploitation. And the other deep-seated reality, of course, as our colleagues have spoken about at the ACTU, is that because of the way that temporary visas are structured and the way that permanent pathways have been restructured over the past decade, particularly by this government, temporary visa holders must transition through a series of temporary visas bound to their employer in order to access permanent residency. So there is simply no pathway. Not only is there no security of tenure, but people's very pathway is contingent upon their completion of particular types of work. The most obvious example being work and holiday visa holders and the requirement to complete 88 days of work. No mention in the bill and no mention in the debate surrounding it about if that visa holder is exploited during those 88 days, and that exploitation is rife, as we've seen from media reports over the past 5 years. What will then become of them? How will they transition to the next visa that they intend to hold? So, these are the underlying types of realities that the bill just does not grapple with, and we see it as really a very, very partial sort of tunnel-focused, enforcement-focused response to a really holistic set of recommendations that were given by the Migrant Workers Task Force. And Senator, as you pointed out, it's not as though there has not been ample time to think on how those recommendations might have been adopted into law.
Yeah, that's right, especially it's taken since March 2019. Can I just ask you touched on the 88 days. What's your view about the 88 days? Do you think it should be scrapped?
Our long-standing view is that it ought to be. Yes, that's right. And I think we're not alone in that position. But I think we'll pass to our colleagues.
I'll just add to that, Senator. You'd be aware that the recently renegotiated UK free trade agreement resulted in the British government determining that the 88 days requirement was, resulting in their citizens being put in exploitative conditions as a condition of receiving a second or third year visa, and demanded that be removed, and the Australian government agreed to do that as a condition of finalising that agreement. And so our position is if that requirement is not good enough for one set of workers under one temporary visa, it should not be required of a different set of citizens of different countries, considering that the exploitation that those workers face would be one and the same. So yes, our strong view is that requirement should be phased out for all temporary migrant worker, temporary visa holders, and that the work and holiday visa be returned to its original purpose, which is as predominantly as a tourist visa with some work ability, so that people can sustain themselves while they're here, but not used as what has effectively been a low skill visa that's operating across the economy.
What role would a national labour hire licensing scheme play in protection of migrant workers, and would the inclusion of temporary migrants in the FEG, the Fair Entitlements Guarantee Scheme, assist in addressing issues of exploitation?
I might just quickly address this one, Senator. I think what's really important to note, apologies for this. Like, can you put that for a sec? I'll be one second. Sorry, Senator. I might hand to my colleague and then I'll deal with this and then I'll come back to you.
Hands full there, Liam.
I'm happy to go first, Senator. This is, the labour hire issue is, I suppose, vexed in the sense that we do have some state labour hire regulations that have started to make some improvements. We would say that they need to go further. Our understanding to date of the proposed federal model is that it would be weaker than the state models. So if there was to be a federal system implemented, it would need to be much more robust than the strongest of the current state schemes. Even under the strongest of the current state schemes, we are experiencing ongoing issues with worker exploitation under the labour hire model. Absolutely support the the FEG, as you say, applying. We think that would be some assistance. But again, that's effectively getting taxpayers to fund employer malfeasance. So what would be better is some sort of system that actually monitors, enforces and maintains compliance of employers rather than getting taxpayers to pick up the bill at the end, notwithstanding that safety net is important.
So what other measures, just on that point, would be required to create a better bill, I guess, and having stronger protection? Like, for instance, would you like to see a firewall, salaries being paid into Australian bank accounts, whistleblower protections, etc.? What other measures would you like to see incorporated into the bill to make it better?
Oh, 100%, Senator. Those couple of suggestions you made then, I mean, let's be real, this bill barely touches on 2 of 22 of the government's own Migrant Workers Task Force recommendations. So, it is obvious how deficient it is when compared against that as a benchmark, let alone the various other inquiries. There's about one every year that's conducted. There's multiple recommendations. They're not implemented. They haven't been implemented. I mean, the Migrant Workers Task Force established by the government was established in 2016. That's 6 years. The report was handed down 3 years ago. 3 years. We shouldn't be looking at some sort of lag indicators for how we control the high rates of exploitation that are occurring. There's a whole bunch of lead indicators that could prevent issues like you say of making sure workers are paid into Australian bank accounts so that we know that they are in fact being paid. Is one of them. Access to representational rights and information prior to commencing work. The access to even be able to have a third party assist them in quick resolution of wage claims. It's extraordinarily difficult to pursue a wage claim. In one of our case studies, we're talking about Austal and a situation with Filipino workers. That was identified in January 2020. 2 years later, we are still pursuing those wage claims. And it's resource intensive, extremely time consuming. And in the meantime, those workers don't have their wages, don't have their entitlements, and are often spirited back to their originating country to make it even harder for them to seek justice.
So, Brian, did you want to just jump in now that you got your...
I did, and apologies for that. So I think the real clear problem that we've got here is that in the case of temporary migrant workers, you're compounding issues of precarity. So not only do we see temporary workers victim to this situation at the moment, apologies, please wait, I'll get you on.
Working from home.
I know, well, he's sick today too, so apologies. It really is a situation where we're dealing with an inadequate system when it comes to regulating labour hire in this country, and we absolutely need a strong, robust national labour hire licensing scheme. But as Mr. Gould just referred to, we also have a real issue with wage theft, and we do not have easy, effective ways for workers across the community, but in particular for temporary migrant workers to access justice when it comes to wage theft. And really, it's a year ago now, the government abandoned its IR reforms in relation to this, which would have provided some modest improvements when it came to the ability for workers to recover stolen wages. So really, Senator, this is a combination of factors that really gets magnified by the situation that temporary workers are facing in this country.
Yeah, indeed.
If I could, Senator, just to add in terms of that question around concretely what kinds of amendments or approaches would need to be included in the bill to make it effective. We've referenced a couple of them in terms of there being not just whistleblower protections, but a pathway for those workers who do make complaints to remain in the country, and that lack of a security of tenure and the precarity, as Mr. O'Brien referenced, that all temporary migrant workers face is a massive barrier and prevents them from coming forward and reporting exploitation. So that if the government is to rely on workers coming forward in making those complaints in order to enforce the Fair Work Act and migration laws, there needs to be incentive and support for workers to do so. More broadly, though, the emphasis of the bill on enforcement activity misses an opportunity to focus on those things that will actually empower and support migrant workers to step forward and enforce their rights. Academic studies and common sense dictates that when workers have the support of their trade union to pursue contraventions of the Fair Work Act, health and safety laws, whatever issues they're facing in the workplace, they will have a better outcome than if they were to pursue those contraventions individually. And so a large body of academic evidence is focused on, and recommendations have focused on the need for there to be improvements, not just in the amount of information that migrant workers are provided when they arrive in the country, but on who delivers that information and in what context. And if you look at the government seasonal worker program, there's a requirement that workers be introduced to the relevant trade union and educated about their workplace rights, both pre-departure and on arrival. And so our strong recommendation to the government for a number of years has been to make that a requirement of all temporary migrant workers, which would mean that we wouldn't just be dealing with exploitation after the fact, but we would be equipping workers who are arriving in the country with the knowledge and the capacity to actually enforce their rights with the support of the relevant trade union. And that's a really strong and important recommendation to deal with the root causes of exploitation before they occur, rather than waiting again and again to try to deal with cases of exploitation, very extreme cases of exploitation, after they have occurred.
Mr. O'Brien, just to pick up from your earlier comment, you would have seen over the past week, we've seen a bit of a blame game between the Nationals and the Liberals with respect to the agriculture visa. Do you think a visa scheme like this will lead to further exploitation? And also, what are the main issues with the ag visa from your perspective?
Thanks, Senator. I'll start off, but I'd like to also hand to Ms. Middlemass after this. Absolutely. What we've described today is the current regime of exploitation that workers are facing in this country. So before we even get to a situation where we start to lower the standards and deal and potentially increase some of the factors that we've described as concerns, we already have a situation where exploitation of temporary migrant workers is really out of control. And what's being proposed with the new ag visa is going to further erode those standards, and indeed why we would be moving to a situation like this when we have a better regulated, albeit not nearly sufficiently enough, labour mobility program available. Why is it that we're doing this? And I think it's a real concern that this new visa category is going to lead to further exploitation and compound.
Last question, Senator Ciccone.
But I'll defer to Ms. Middlemass now.
I'm sorry, we are going to need to move to other senators in a moment. If you could just make this your last question, Senator Ciccone.
I think Ms. Middlemass was just going to supplement mine. Yep.
Sure, Mr. O'Brien. Ms. Middlemass, please go ahead.
Thank you very much. Yes, look, just to echo what Liam has said, I think it's actually interesting. You were mentioning before, Senator, the amount of time it's taken for this bill to come about after the recommendations of the Migrant Worker Task Force. But actually, we're also seeing, on the other hand, the government is really trying to rush through this new visa, is trying to get workers here in January, was the original time frame. But we don't know at this point what worker protections are in place for this new visa. And given the prevalence of migrant worker exploitation, as we've just discussed, we're very alarmed that workers could be coming here as soon as next month, this month, without worker protections in place. As to some of the other issues with the visa, there's no independent verification of labour shortages in the industries covered by the visa. There's also a question around how many workers will be coming here, whether the scheme is capped or uncapped. And we've also had countries express concerns about the welfare of their citizens who are going to come here under this scheme, given the concerns around the prevalence of migrant worker exploitation in Australia. So, I think there's a lot of unanswered questions here, and, given the issues that we've been discussing today, the government should not be establishing a new visa system until we can protect migrant workers from exploitation.
Ms Middlemas, thank you very much. Senator Ciccone, thank you so much. We'll now move to questions from other senators, and I give the call to Senator Van.
Thank you, Chair. To Mr O'Brien or Ms Middlemas, in your submission you recommend to abolish the 88-day work requirement for working holiday visas. Can you articulate to the committee how this will help migrant workers?
Might provide Ms Middlemas the opportunity to respond to that and supplement any gaps.
Yeah, thank you, Liam. Thank you, Senator. Look, I think as has been outlined by our colleagues today, that 88-day work requirement really is fuels exploitation. It's a recipe for exploitation, tying a worker to their employer, and the promise of a future visa really means that workers are more likely to persist with exploitative arrangements rather than risking their ability to stay in this country. So we support the fact that that requirement has been abolished in the new UK free trade agreement. But of course, we want it abolished for all workers. And as I've just mentioned with the agriculture visa, the fact that has been a trade-off of abolishing this 88-day work requirement in the UK FTA, it's really trading the exploitation of one set of workers for another. So we're extremely concerned.
I'm not sure I agree, but you also stated recommendation 2 to, I believe I'm quoting, implement a firewall between the Department of Home Affairs, the Fair Work and the Fair Work Ombudsman that prevents provision of information from the Ombudsman to the Department except to facilitate the prosecution of employers for exploitation of their workers. Would that not be a detriment to migrant workers?
No, I think this really goes to, ensuring that migrant workers who come forward and report exploitation are not going to suffer any adverse immigration-related consequences. And of course, all we have at the moment from the Department of Home Affairs and the Fair Work Ombudsman is this assurance protocol, which is actually not made public, but there's just a fact sheet online which says that, gives the really not ironclad assurance that if workers do report exploitation, they will usually not suffer immigration-related consequences. Now, that's really far from an ironclad guarantee. So what we're suggesting is that there needs to be legislated whistleblower protections. There needs to be this firewall to ensure that if workers do complain to the Fair Work Ombudsman, that information is not made available to the Department of Home Affairs in an identifiable way. So all these recommendations are really fundamental to ensuring that migrant workers have the confidence and ability to come forward and report exploitation without fear of being deported or not being granted another visa.
Can you confirm for me that migrant workers are covered by the same basic rights and protections as Australian citizens and permanent residents in the workplace?
I'm happy to start with that, Senator, if that's okay. The issue, as we've described it, goes to the employment relationship and how that really compromises the power imbalance between workers and employers. The fact that you are not only reliant upon your employers for the job, but also for the right to stay in this country, compromises the ability of workers to make complaints about their employment. This is a critical feature of industrial relations systems. So to that extent, temporary migrant workers don't have the same rights as domestic workers would, who do not fear being deported by making a complaint. So that is the principal area of imbalance that this bill fails to address and must address if we are going to end the exploitation of migrant workers.
But you're suggesting that you give higher protections to migrant workers than Australian citizens, it seems.
I'm saying the
incongruous.
current situation provides less protections to temporary migrant workers than it does Australian workers because they are at risk of being deported.
But you agree with my proposition that migrant workers are protected by the same protections as Australian citizens and residents?
I accept that employers are required to pay the same pay and conditions to workers, whether they are temporary, whether they are whether they are domestic workers or whether they are temporary foreign workers. The problem is that the key feature of our industrial system, which allows workers to make complaints and indeed seek enforcement, places temporary migrant workers at a significant risk because of the risk of being deported.
Can I just add to that, Senator? If that,
Please.
Mr. Gould, yes.
So I'd disagree. We've come across, and in one of our case studies, we talk about some workers on Schneider, working for Schneider on solar farm, who were being paid their originating country's wages while performing trade work in Australia. And Schneider put it to us very specifically that they were that they'd done nothing illegal in paying the originating country's wages and not Australian wages, and that they were under no obligation to pay. We obviously reported those matters and there were no prosecutions taken as a result of that. And I'm sure my colleagues from UWU could speak to this as well. Undocumented workers don't have the same protections that Australian workers have. But I think fundamentally, we've got this situation that doesn't apply to Australian workers, that does apply to migrant workers. That is, if a migrant worker has their wages stolen, it is deemed in effect that the migrant worker has broken the law, not the employer. The employer may have broken a different law, but under the visa arrangement, the migrant worker is the person that is deemed culpable for having their wages stolen and are in breach of their visa and face deportation. Australian workers do not face that.
I don't know how you justify that statement.
Yeah.
I justify it by that's the construct of how it operates.
Mr. Gore, could you
Yes,
just
ma'am.
explain
Of course
that?
I have.
Because that's not the provisions of the law.
Yeah.
So can you just explain the basis on which you make that claim?
When a visa is issued to a migrant worker, a condition of the visa is that the migrant worker must be paid Australian wages. To not be paid the Australian wages is a breach of their visa. The relationship between the visa and the migrant worker is the relationship that's breached by wage theft. This bill doesn't address that significant hurdle.
Yeah, I'm not sure that's correct. Isn't it
Sorry,
Sorry, Chair,
Sorry.
have you got more questions?
A witness wanted to add.
Ms. Verma, did you want to just add to that answer?
Yes. I just wanted to respond briefly to Senator Van's question. It may be, Senator, that we're speaking at cross purposes. Certainly, as a matter of the letter of the law, all people employed in Australia are employed subject to the same protections. We all agree that is what the letter of the law says. But I think why we're convened here today is because there is a vast discrepancy between the protections that exist as a matter of law and protections in real fact for migrant workers. And I understand what we're concerned with here today is not whether or not the law says what it ought to say, whether or not migrant workers are subject to a completely parallel employment and industrial relations system. Of course, that's not the case. The case is that as a matter of practical reality, they are. And there are any number of examples. We can begin to speak about the situation that our undocumented members face. It's completely a parallel employment universe, whether or not the national employment standards apply to them or not. So, that's the reality that such a bill needs to contend with, and it simply doesn't. By fortifying the letter of the law with no regard to how people are going to have access to those protections or how they translate into people's real life is the problem here. I suppose I might give you a practical example if you can sort of bear with me.
Briefly.
So very briefly, say for instance, let's talk about the Paradigm case. So let's talk about the Fells Wage Theft Panel, which led to the Migrant Worker Task Force, the absolute paradigmatic example of international student visa holders who were employed in 7-Eleven franchises. At that stage, student visa holders were subject to a strict 20-hour per week condition on their student visas. They were lured into work upon two promises. One, that they would be paid in accordance with the NES and paid good rates, including penalty rates, because they were working overnights. And number two, some of them were lured on the promise that they would be sponsored for visas. Now, when those students found themselves actually in the workplace, they found a few things. Number one, that they were subject to ongoing sort of training periods during which they were unpaid that were said to be part of the preparatory screening of their employer for eventual...
Ms Verma, I was asking you to answer that question, but I'm just conscious that we've got limited time, so I'm just hoping...
Sure. If I could wrap it up in 30 seconds.
Yeah, we're just trying to keep the responses fairly succinct so we can get through as many questions as possible, please.
The point is that at the time of the Fels Wage Panel, the NES existed, and yet people were being employed on terms and conditions that fell well below.
Is it not the case that the Fair Work Ombudsman recovered a record amount of back paid wages in 2020-21? Doesn't this prove that migrant workers have remedy to the same entitlements as Australians?
Unless others would like to, I'll defer to my colleagues first, but I have some things to say about that.
Go, Ms Verma.
We keep referring to a vast body of academic literature. There certainly is. So the work of Laurie Berg and her colleagues tells us that the Fair Work Ombudsman is drastically underutilised, despite a very significant amount of its work and policy research now being pivoted towards addressing migrant worker exploitation. Whatever the achievement of the Fels Wage Panel were and the gains that were achieved through the FWA during that period, at the end of the day, they represented a very, very small percentage of the exploitation that was taking place within those franchises. And why was that? That was uniquely because even at that time, with such a high-profile case, no guarantees could be given in terms of security of tenure to student visa holders who approached the panel. So it's just a paradigmatic illustration.
But you're addressing a different question to what I put to you. You're not answering the question I put to you.
The take-home point is that the FWO is vastly underutilised by temporary migrant workers, and that is confirmed in academic research. So however much is being recovered represents a small proportion of what we say is the overall degree of wage theft that is taking place in respect of migrant workers.
Senator Van, if we could just make this your last question, then I'll hand over to other senators.
Sure. I've got a few, but I'll go with this one. Can you, either now or on notice, provide me with a list of regional towns that the ACTU, the UWU or the ETU have offices, please?
All right, thank you very much. We'll take that on notice or position to answer that now.
Happy to take it on notice.
All right, thank you.
Well, can I just clarify? Do you have any?
I think it's been taken on notice, hasn't it? I think the chair's.
Can I put a supplementary question then, please?
No, Senator Ciccone, if I could just, Senator Van is able to ask a follow-up question, a different question.
Do any of the witnesses appearing today have offices in regional towns?
From the ETU's perspective, we have dozens, and we're happy to provide you the list on notice.
Thank you.
Yes, we do.
Thanks, Chair.
Thank you very much, Senator Van. I'll now give the call to Senator Carr.
Yes, there's a couple of matters. If I could just be clear for the Hansard record, is it the submission of the witnesses that this bill is beyond repair? When I read your submission, I was just wondering, could you state for the Hansard record whether you take the view that the bill, when you say the bill falls short, despite minor improvements to this bill from the exposure draft, we remain of the view the bill is not sufficient to protect temporary migrant workers from exploitation and some adverse unintended consequences, and the other witnesses make similar points. Does that mean that you recommend to the Senate not support this bill if your amendments are not carried?
Might defer to Claire if you'd like to answer that.
Yeah, look, I think, as we've noted in our submission, there are some fundamental flaws with the bill. But given the systemic nature of migrant worker exploitation, there are actually reforms required in a raft of other policy areas as well to really protect migrant workers. So, just some of the issues we've covered today, including the simple, quick and accessible way to resolve wage theft for migrant workers, a robust national labour hire licensing scheme, reforming the ABN system and ending sham contracting would be another one, strengthening the Modern Slavery Act would be another one, and I guess fundamentally with our migration system, recalibrating the balance of skilled migration towards permanent independent migration rather than temporary employer sponsored. So, but in terms of the bill itself, I think as we've mentioned, the fundamental reforms we would like to see are those whistleblower protections for migrant workers to come forward and report exploitation. Without that, we don't think the bill will be of any use. Thank you.
The other witnesses have a view. Do you recommend voting against this bill if your amendments are not carried?
Senator, from the ETU's perspective, it's not so much a case of opposing the bill. We don't see that the bill makes anything worse. It just doesn't make anything better from the ETU's perspective.
Okay.
Yeah, thank you, Senator. From the perspective of the United Workers Union, just picking up on the key point that Ms. Middlemass made around the need in particular for there to be, whether it's whistleblower protections or as we've called for, the creation of visa pathways for those workers who've been subject to exploitation with some ironclad guarantees that workers will be able to access and transition onto those visas in order to protect and incentivise them to come forward. Unless the bill contains those kind of provisions, it's not necessarily the case that it won't make things better, but it could in fact make things worse, particularly for those workers who are working outside of their visa conditions for a number of different reasons, and we've discussed a few of the primary causes of that. And obviously, in the case of the horticulture industry, there are up to 100,000 workers who are working completely outside of the visa system. For that reason, if the government is to pursue an enforcement-only approach that targets employers and, of course, employees as a result of that, who are working in breach of their visa conditions, it won't just not make the situation better, but it will not make the situation better for those workers, and that's why it's so critical that this challenge be approached not just from an enforcement perspective, but from a worker-centred perspective about what is it necessary for the government to do to protect and to support those workers who've been subject to some of the most horrible forms of exploitation in the country, and what can the government do to create realistic and accessible pathways for those workers to stay here and actually pursue justice. And so for that reason, we do think there's fundamental problems with this bill.
Okay. If I might just comment on that discussion that Senator Van and I think others were engaging in about the nature of equality in the law. I mean, it's famously said that the law in its majesty, its majestic equality forbids the rich as well as the poor from sleeping under bridges and to beg in streets and from stealing the bread. I mean, your fundamental proposition is that this issue around temporary migration goes to the nature of power in our society, and as a consequence, these measures really can't be addressed by these minor regulatory changes. Can I say to you that my direct experience as a senator, especially in the meat industry, I've noticed an enormous number of cases over the years of the mistreatment of workers under various migration schemes, and the failure of the industry being able to come to terms with its own sort of effective self-regulation. That it's not really, I've not seen any improvement over the years about how those schemes have worked. It's most recently the case down in Warrnambool, with the meat works at Warrnambool and the Chinese workers there, where it was quite clearly, demonstrably documented that there had been gross abuse of the scheme. I'm wondering whether, and this is a question directly to the witnesses, whether or not there could be an improvement in the scheme by providing better legislative protection for outside enforcement of compliance measures by giving unions a role in the enforcement system, as such as they've got within occupational health and safety, as they used to have within the award protection system. Is there a view on that matter, that they could actually have greater legislative capacity to actually take up these questions, to actually protect temporary workers who are here on temporary visas?
Well, I might start, and indeed my colleagues can supplement. I think we would say that is the case throughout the community, that in particular when it comes to wage theft and unpaid wages, the ability for workers to easily remedy this through access to the courts via their unions is a really critical problem. We've made recommendations as part of this report, but indeed, as part of this inquiry, but indeed as part of previous inquiries into our industrial relations system, that we do need easier access to justice when it comes to workers, and they need to be able to, through their unions, use mechanisms such as the Fair Work Commission to conciliate these matters, and if need be, house an industrial court that can quickly deal with these problems. Senator Van went to the issues around the Fair Work Ombudsman. Indeed, the Fair Work Ombudsman is doing, more prosecutions year on year, but it is barely scraping the bottom of the barrel. And yet, when it comes to the real institutions in workplaces across the country, like unions, our hands are tied when it comes to trying to deal with wage theft. And it's magnified when dealing with the issues around not just insecure work, but temporary workers, because, as we've pointed out throughout this hearing, this power imbalance that exists. So, Senator, I would agree with you that absolutely unions should have more rights in relation to inspections and so on. But indeed, in particular, when it comes to temporary migrant workers, what our colleagues have talked about is the role unions play both when workers arrive in country to inform them about their rights, and indeed pre-departure as well. But I definitely defer to some of my colleagues to add to that.
Yeah, I'll just jump in here quickly, Liam. You're right, Senator. This is fundamental.
Mr. Robertson, just for that, Hansard. Thank you, Mr. Robertson.
Sorry, Senator. Yes, you're correct, Senator, that this is fundamentally about power imbalances in our society that are broader than the experience of temporary migrant workers in the workplace, and really about more powered Australian workers in general, whether they are temporary or permanent migrants, citizens, have in enforcing their workplace rights. But what we know in practice, in our experience from our very, very deep involvement in the seasonal worker program, which is one of the better regulated, not perfect, but better regulated programs, temporary visa programs that the Australian government has, that when workers do have easy access to their union, are able to join their union, and that employers are required to invite the union to participate in on-arrival briefing processes to educate workers about their workplace rights, that when those workers do subsequently have issues, that they have the power to enforce them and to deal with issues when they are small, rather than waiting until a large-scale exploitation has occurred and trying to deal with it after the fact. So if the government wants to get to preemptive solutions that will empower temporary migrant workers to enforce their own rights, then yes, it's critical that unions be enabled to meet with, as a requirement of workers' temporary work visas, require employers to invite the union to come and meet with those workers, because of course it's through the union that workers actually have the power to enforce enjoyment of rights that they have on paper. So we would agree that that's a critical reform that is obviously missing from the bill and needs to be there as a fundamental part of a proactive approach to dealing with the exploitation of temporary migrant workers in Australia.
Chair, a supplementary, if I may, just on that point. So are you suggesting that any government, makes unionism compulsory for migrant workers? Is that what you just argued?
No, what I'm saying
sorry,
is...
no, sorry, Kim, can I...
Senator Van, look, Senator Carr, the call. I can come to you both at the end.
Yeah.
Senator Cumming, you have the call.
Now, my question really goes beyond the capacity to meet with migrant workers. My capacity goes to the legislative capacity of unions to be part of the compliance regime, as is the case with occupational health and safety, as is used to be the case with the state wages boards and the like, for enforcement mechanisms, given we're relying upon public servants and the power of local employers who, in a rural community, which is immense, to be able to take action where the migrant worker is at the most vulnerable of all circumstances, because if they don't do as they're told, they get sent home. Now, I'm raising another question. Is it appropriate for there to be an independent mechanism for the compliance mechanism to be pursued?
So I might defer
Ms. Verma?
defer to our colleagues. I think Liam was about to speak there, but I might just very, very briefly. Senator, that's quite right. The independent mechanism that we certainly had contemplated is the creation of something called an employment justice visa. That there needs to be security of tenure that is specific for migrant workers who are experiencing and pursuing claims of exploitation. There is no other way. So claims of this nature come to light from the workers themselves rather than enforcement. That's what our experience on the ground shows. And so those workers need to be protected on the ground where they are. The law doesn't need to be fortified. The workers need to be met in the situations that they're in, and that's what we'd say. But I'll pass to my colleague.
I would agree with Ms. Verma. I would add what I said before, Senator Carr, is that the FWO shouldn't have a monopoly when it comes to the enforcement of wages. What we've got is a system that is extremely bureaucratic and difficult for other institutions like unions and indeed workers to access justice. The ability for a worker to navigate the small claims court and their union is much, much more difficult than the Fair Work Ombudsman. So I think you're right in saying that we need to ensure that we are making all institutions able to assist workers to remedy wage theft.
Thank you.
Senator, I'll just add, for these employers, it's entirely lawful for them to seek advice from their union, from the Employer Association during work hours. The Employer Association can attend site without providing any notice. The employer can stop work and meet with the Employer Association for as long as they choose to discuss their rights with no breach, no threat of fines, no issues. All we're simply saying is that where workers choose to join a union, then there shouldn't be obstructions in place for them joining a union. And I agree that there should be legislative provisions that the union has rights to act on behalf of workers to assist in wage recovery and enforcement of the legal provisions. The wage theft in silence in 2019 identified the huge rates of wage exploitation. The Fair Work Ombudsman, of those workers that went to the Fair Work Ombudsman for help for wage theft, 58% of those workers recovered nothing via the Fair Work Ombudsman, and only 20% or 1 in 5 of those workers actually recovered the full amount owing. And as I talked about earlier, we've had a case ongoing now with Austell that the Fair Work Ombudsman has been involved with since January 2020, and we are still not able to recover all of the money for those workers, but we're continuing to pursue it. The only way that we managed to get the Fair Work Ombudsman to take an interest and investigate this case, because those workers were immediately sent back to the Philippines, it just so happened our National Secretary, Alan Hicks, was in meetings with the Minister Christian Porter at the time around the Omnibus Bill, and managed to make representations personally and then write to the Minister, followed up by 3 weekly correspondence to the Fair Work Ombudsman. So sort of circling back to your original point, the fundamental principles of the rule of law is how accessible the law is to people. And it's already not that accessible for workers, Australian workers who are facing breaches of their workplace rights. It's even less accessible for migrant workers.
Thanks very much, Mr. Gore. Senator Carr, we are almost at time, and
No,
I've
that's
just
all
got
good. Thank you. That's all good.
happy. Thank you so much.
Yep.
I've just got a couple of questions, and I just, Ms. Minimus, I just wanted to direct my first question to you. You made some reference to there really being no evidence in relation to workforce shortages, and I just wanted to ask you to clarify that evidence, particularly in light of the fact that in regional Australia, unemployment is now well below 4%, and there are many sectors of many industries which are crying out for workers. So I just wanted you to sort of just respond to that in light of your earlier evidence, please.
Yeah, thank you. The agricultural visa covers a wide range of sectors. So, for instance, it covers the forestry sector. We've got one example where the South Australian.
Sorry, Ms. Minimus, I just wanted to. I was referring specifically to your evidence in relation to there being no workforce shortages. I just wanted you to clarify that in light of the evidence that the unemployment rate in regional Australia is now at 3.8%, and regional job vacancies are well above 70,000 people, according to the Regional Australia Institute. So, in other words, there are many employers who are crying out for workers who they can't currently secure, particularly in regional Australia.
Yeah, I was just making a comment in relation to the wide coverage of the visa, and for instance, the South Australian government has removed some key forestry jobs from the designated area migration agreement, which is an indication that there is no longer a labour shortage in those particular jobs in that industry. So that was just one example, just pointing to there is no kind of independently verified evidence that there is labour shortages in all of the sectors covered by the visa. And the other point would just be to say that, employers...
Well, I would just put to you that that's just not the case. I mean, there is overwhelming evidence that there is a workforce shortage, particularly in regional Australia, in many sectors covered by the agricultural visa. And therefore, it's incumbent on the government to strike the right balance to make sure that employers can access workers, migrant workers, in a way, of course, which ensures that they are properly protected. But this is very important, and very important for Australia's COVID recovery as well.
Yeah, I think just before my colleague Liam jumps in, I would just say that employers also need to be making sure that they're doing all they can to attract local workers. There are plenty of local workers that are looking for jobs in regional Australia, and we need to be making sure that they're offering decent pay, decent conditions, and secure jobs.
Yeah, but certainly there's, as I say, 70,000 regional job vacancies at the moment, according to the Regional Australia Institute. Anyway, we'll move on. Look, I just wanted to also put on the record. Look, we might just move on because we've only got a couple of minutes before we need to break. I just wanted to put on the record that in 2021, the Fair Work Ombudsman, the evidence is the Fair Work Ombudsman has done an exceptional job under our government in recovering underpayments or back payments of wages and entitlements, $148 million for 69,735 underpaid workers in 2021, which is 20% above 1920 and five times higher than the recoveries achieved in 2017-18. So aren't we seeing a system whereby the Fair Work Ombudsman is doing an exceptional job in addressing any exploitation of workers with respect to underpayments?
Chair, just before we go to the witness, could I ask that you table the evidence that you are referring to?
I'm just, I haven't got that to hand at the moment. I'm just looking at a report, the Fair Work Ombudsman's, a summary of the Fair Work Ombudsman, but I'm happy to do that.
Thank you very much, Chair.
I think the increasing rates of wages recovery is reflective of the increasing rates of wage theft.
Sorry, Mr. Gold?
I think the increasing rates of wages recovery is reflective of the increasing rates of wage theft.
Just a question.
And
Notice, Chair,
give
can
you
you
confidence,
provide...
though, in... Sorry, it's who was talking then?
Sorry, it was me, Chair. You go
Senator
first. I just
Van.
want to a point of clarification. I'd ask the gentleman who just made that claim to put his evidence on the table for that.
Well, I think it's
Senator,
fair, though. I mean, the chair was just making assertions and putting questions to the witness, and they've got no ability to check what it is that she's referring
Well,
to.
she said
Yeah, no,
that she'd
that's
table
fine.
that. She said she'd do that.
Well, and they don't
I'm
have
just
access to
asking
that
I'm asking
information.
the witness to do the
Sorry,
same.
if we just go... No, we'll just... Sorry, Senator Ciccone and Senator Van, if I could just ask Mr Gould to complete his answer.
I was simply going to say, Senators, that the evidence that I'm referring to is contained in all of our submissions with linkages to all of the government and independent inquiries that demonstrate that wage theft is endemic and it is growing within migrant workers cohorts.
Thanks, Mr Gould. Look, I just wanted to ask generally, the bill contains criminal penalties for exploitation, very importantly. Do you support those criminal penalties? Mr O'Brien?
I might defer to Ms. Middlemass.
Ms Middlemass?
Yeah, yes, but the point we're making in our submission is that actually the existing regime is underutilized. So simply creating new penalties won't get to the source of the problem here. So in the 6 years since the original provisions were...
So you're not supporting the criminal penalties in the bill?
We don't not support them, but what we're trying
Right.
to say is that they're not going to make a difference, a concrete difference to protecting migrant workers, given all of the evidence we just provided today about the barriers that migrant workers face to reporting exploitation and the very low likelihood that employers will get caught.
Senator,
Look, just a couple of quick questions I just wanted to, and I know we're running over time to break. We will hear from Home Affairs later today, but isn't it the case that exploited workers are protected under protocols which prevent visa cancellation? And I understand that that's a legitimate concern. So isn't it the case that in any solution, these risks confronting migrant workers need to be balanced, meaning that creating a new visa would need very, very careful consideration. Have the unions giving evidence today considered that?
Senator, I would avidly like to respond to that question.
Yes, Ms Verma.
The answer is no, that there are no protections whatsoever against visa cancellation for workers who have faced exploitation. I cannot tell you how many cases of visa cancellation in which I have acted over the past 18 months during COVID, in which visa cancellation has been contemplated because somebody has called the FWO, because somebody has ended up coming to the attention for working more than 40 hours a week, say on a student visa, and not working in one of the exempt so-called sectors, simply because they had to support themselves during COVID. Absolutely not. In fact, we offer a tiered set of recommendations in our submission. One of the recommendations that could be implemented simply by amending the Department of Home Affairs internal policy such that there would be a presumption against visa cancellation where there was prima facie evidence put forward by the visa holder of exploitation. That can be done with a stroke of a pen. It can be done with the same stroke of a pen that the Minister for Home Affairs used to insert policy that visa holders could work in excess of 40 hours and would not be cancelled if they worked stacking supermarket shelves. So if the Minister can give such granular consideration to the needs of the Australian workforce or Australian labour market, that they can give the same consideration to visa holders and the conditions that they're under. So no, there are no protections whatsoever against visa cancellation.
All right, look, just very quickly, do the unions, do each of you support the strong provisions in the bill which allow an employer to be struck out and not hire any other migrant workers if they are found to have, engaged in any serious form of migrant work exploitation, I should say?
Senator, we support it, but it's more nuanced than that in the sense that if you ratchet up the penalties against employers without equally ratcheting up the protections for the workers, then you're actually going to have the inadvertent, unintended consequence of making it worse for the exploited workers.
Mr. Gould, thank you. Anyone else want to add to that answer? All right, thank you. Well, look, we will need to leave your evidence at this point. I just want to thank you all very much for appearing this morning and for your time in making your submissions. It's appreciated, and for giving evidence this morning. We will now suspend for morning tea and return in 15 minutes. Remotely, including myself, I'm in isolation, attending by video conference from my home. So thank you for bearing with us under slightly unideal circumstances. I'm driving several computers at the one time and I'm having some challenges. So I would now like to welcome representatives of the National Tertiary Education Industry Union, the Immigration and Advice Rights Centre and Unions New South Wales, and the Retail Supply Chain Alliance. I thank you all for your attendance this morning and for your time in giving evidence. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 4, 11 and 12 respectively. For the Hansard record, could you please state your name and the capacity in which you appear, including whether you have any correction to your submission. Could I ask each of the witnesses to state their name and the capacity in which they appear, please?
Thank you, Senator. My name is Joshua Strutt. I'm a senior solicitor at the Immigration Advice and Rights Centre, and I'm here with my colleague, Mr. Ali Mojtahedi.
Thank you, Senator. Ali Mojtahedi, and I appear in my capacity as the Principal Solicitor at the Immigration Advice and Rights Centre.
Thank you so much.
My name's Thomas Costa. I'm the Assistant Secretary of Unions New South Wales.
Thanks, Mr. Costa.
Morning, my name is Stephen Crawford. I'm the Acting Assistant National Secretary of the Australian Workers Union, and I'm here today representing the Retail Supply Chain Alliance, which includes the AWU, along with the TW and the SDA.
Thanks, Mr. Crawford.
Good morning, Senator. My name is Kieran McCarran, and I'm appearing in my capacity as a Policy Officer for the National Tertiary Education Union.
Thank you very much, Mr. Karen. Would any person representing one organisation like to make an opening statement, please?
I'll make an opening statement if that's...
Yes, thanks, Mr. McCarran. Okay. If I could just ask you to limit it to 3 minutes, if possible, please.
Yes, certainly. Thank you. Hello, my name is Kieran McCarran, and I'm appearing today on behalf of the National Tertiary Education Union. Thank you for the opportunity to appear. I would like to use this opportunity to speak specifically about the vulnerability of international student workers who are taught by our members and the deficiencies in this bill in protecting them from exploitation at work. International students in Australia pay extremely high course fees, which are much higher than the cost of delivery of their courses, whether that's in public universities or for-profit providers. In this context, a majority of students undertake part-time work. An ABS study from 2016 found that over half of international students relied on work as their primary source of income whilst they're here. As you are all aware, international students are usually subject to a work limit of 40 hours per fortnight. And as we all know, this acts as a point of leverage for employers. As the Migrant Workers Task Force noted, some employers have coerced students into accepting lower wages on the threat of referring them to immigration authorities for breaching their work hour restrictions. That's a direct quote. Anecdotal experiences of our members providing pastoral care for international students confirm that this practice is not uncommon. Indeed, international students are usually employed casually and end up in a position where they work the hours that are asked of them or they do not work at all. One of the stated aims of this bill is to reduce this type of coercion. Our main concern is that the bill does not appear to provide any explicit protections for visa holders who act as whistleblowers and report coercion by their employers. As such, students who do report employers in breach of provisions in this bill may themselves be subject to penalties, including visa cancellation. As a result, we do not believe this bill will effectively reduce coercion unless explicit whistleblower protections are put in place. I'll end there. Thank you.
Thank you so much. I'm sorry, I'm having some technical issues and I've just gone on to teleconference until I sort those out. Does anyone else have any other opening statements?
Yes, Senator. I'm Joshua Strutt here, a Senior Solicitor at the Immigration Advice and Rights Centre. Just as an introduction to IARC, the Immigration Advice and Rights Centre was established in 1986 and is a community legal centre in New South Wales, specialising in the provision of advice, assistance, education and law reform in Australian immigration and citizenship law. In partnership with Unions New South Wales, who are also present here today, we have established the Visa Assist legal service with an important objective being the provision of legal advice and representation to migrant workers facing workplace exploitation. Through Visa Assist, we have provided more than 1,600 legal services to over 700 union members in under 3 years. Our work through this collaboration has provided valuable insights into the vulnerabilities of migrant workers, especially those on temporary visas. We are grateful to the committee for the opportunity to appear today and make submissions on your review into the Migration Amendment Protecting Migrant Workers Bill 2021. While IARC supports legislative measures aimed at deterring exploitation and unscrupulous practices in the workplace, the bill does not, in our view, offer sufficient protection to temporary visa holders. We consider that the protection of migrant workers' visa status in Australia is important to the efficacy of the bill because without it, we are concerned that migrant workers will not be empowered to report unscrupulous employer practices due to the real fear of visa cancellation and/or refusal. Our written submission to the committee makes a number of recommendations which we say would strengthen the stated intention of the bill. These include protecting a migrant worker's current visa status and possible future visa applications by permanently removing the 40-hour fortnightly work limit on international students, updating departmental policy around cancellations of visas to ensure that workplace exploitation is an express factor against visa cancellation, amending work-related visa conditions so that visa holders will not have breached a visa condition where there is a credible claim of workplace exploitation, amending eligibility criteria to allow certain skilled visas to still be granted in cases of workplace exploitation, and creating a new substantive temporary visa subclass for people who have experienced workplace exploitation. Thank you again for the opportunity to appear. We would welcome any questions the committee may have.
Thank you so much. Any other opening statements?
Yes, Senator. I'd also like to make a statement on behalf of Unions New South Wales, and I also thank the committee for the opportunity to participate in the inquiry into the Migration Amendment Protecting Migrant Workers Bill 2021. As my colleague has outlined, Unions New South Wales and IARC's extensive work with migrant workers through our Visa Assist program has demonstrated there is a systemic interconnection between the operations of the Migration Act and the Fair Work Act, which has institutionalised a second-tier labour market, effectively a guest worker scheme, where migrant workers are systematically underpaid and unable to enforce their industrial and legal rights. This bill before the committee purports to introduce new needed protections for migrant workers. Unfortunately, it is our view that this is not the case. While welcome the introduction of new criminal offences for the exploitation of migrant workers, as well as the inclusion of banning orders and adverse publicity orders, are welcome, they will do little to prevent the widespread exploitation of migrant workers if they are not also accompanied by new provisions to ensure migrant workers are protected from exploitation and are supported in doing so by increased measures to ensure the enforcement of the existing laws. Workers must also be provided with a safe mechanism in which to bring actions against their employer. free from adverse consequences, including visa cancellations or a block on visa renewals or new visas. Currently, employers and labour hire companies are rarely audited or monitored for their treatment of migrant workers. Further, this bill makes no provision or allocation of further resources to actually achieve its stated aims. Our submission also contains evidence that demonstrates the ineffectiveness of severe penalties as genuine deterrents in multiple submissions. And we make this in multiple submissions when these penalties are not accompanied by appropriate enforcement mechanisms. The vulnerability to exploitation faced by migrant workers does not occur in a vacuum, and it is in fact a direct result of the current visa system, which creates a relationship of dependency where migrants are reliant on their employers due to the precarious nature of their visa status. In its current form, this bill, the Migration Act, Regulations and General Immigration System, facilitates exploitation by creating an additional dependency by the employee on the employer, where the employee is practically reliant on their employer to maintain their lawful status in Australia. From the evidence that we have submitted and our experience, employers frequently use the threat of reporting visa holders to the Department of Home Affairs and consequential visa cancellation to ensure their own unscrupulous treatment of the employee is not reported. This is why Unions New South Wales believes a firewall between the Fair Work Ombudsman and the Department of Home Affairs is vital to ensure workers feel they can seek assistance and take action against those who have exploited them without fearing visa cancellation or removal from Australia. Such a measure is used in overseas jurisdictions, including the United States of America. The bill before you, which claims to protect migrant workers and punish exploitive employers, will fail to genuinely protect these workers if it does not include measures on empowering migrant workers and creating genuine pathways to permanency. Only an overhaul of this nature will adequately address the constructed detrimental dependency of migrant workers on employers. We call on the government to commit to the development of a regime that promotes compliance by enabling and empowering migrants to report exploitation by employers without consequences to their visa status. Only then will migrant workers be truly protected from workplace exploitation. We're very pleased to be able to assist the committee and welcome any questions you may have.
Thank you very much, Mr. Costa. I will now go to...
excuse me, Senator.
Sorry. Yes.
Sorry, can I just make a few brief opening points?
Mr. Crawford, my apologies. Yes. Over to you for just a brief opening statement of no more than 3 minutes, please.
Yes, no, I will be brief, Senator. I just wanted to draw the committee members' attention to the explanatory memorandum, and particularly pages 10 and 15. On those pages, there are illustrative examples of how the offence provisions apparently will operate. But if you look at those examples, you'll see that ultimately the employee agrees to the basically working in breach of the relevant visa conditions. So in that context, it's hard to see how the offence ever comes to light because the employee has agreed. Obviously, the employer has pressured the worker, so it's difficult to see, although the offence is technically there in paper, how is anybody ever going to know about it? How is it going to be prosecuted? There's reference in the offence provisions to undue influence and undue pressure, and there's reference in the explanatory memorandum to excessive pressure, but our point is any pressure or influence should really be prohibited. It shouldn't be an excessive threshold that's in there, because clearly employers or other people should not be putting any pressure whatsoever on workers to agree to work in breach of visa conditions. In terms of Vivo, we think it's positive that there is an increased emphasis on the use of that electronic system, but we would say that that should be mandatory for employers up front, that all employers should be mandated to have to use that system to check the worker's status before they engage them, and that there should be an offence attached to it. Currently, the bill deals with the issue more as a defence that employers can use, but we think it would be more effective if that, provision was at the front end, so they had to do the check up front. In terms of the prohibited employer declarations, although that is to some extent positive, we think those declarations would be better made by a court rather than the minister. That will ensure that sort of political issues don't come into it. We're concerned that the bill appears to allow an employer that is declared to be a prohibited employer to still engage their existing overseas workforce. It appears to prohibit them engaging new people prospectively, but it would allow them to continue using their existing workforce. So for an employer that's been declared to be prohibited, we would say that's inappropriate. And the final point briefly is that there's reference to the use, I think, by the Department of Enforceable Undertakings and Compliance Notices as alternative enforcement mechanisms. But our concern is that the system may become too dependent on the use of those provisions, and that will lead to matters not going to court and orders not being made against employers. And the problem is, if there are not orders being made by courts, it doesn't appear that the prohibited employer regime is going to be triggered. So we're worried about the use of those more minor, I guess, enforcement provisions could undermine the effectiveness of the whole regime. That was it. Thank you, Senator.
Thank you very much, Mr. Crawford. We'll now go to questions from senators, and I will give the call to Senator Ciccone.
Thank you very much, Chair. Look, I might just start off with Mr. Crawford, if I may. I just note the submission that the Retail Supply Chain Alliance has submitted to the committee calls for the establishment of a firewall to be placed in legislation between, I guess, the Ombudsman and the Department of Home Affairs. Do you believe that such provision is essential in order to ensure that the proposed legislation operates as it's intended to be?
Absolutely. And if I go back to the illustrative examples in the explanatory memorandum, I mean, I think what is essentially missing from those examples is what is the next step, right? Like the example is the employer has pressured the employee to work in breach of their visa conditions. The employee has reluctantly agreed, but what happens next? So we'd say there should be reference to protection for workers to make sure they're comfortable to report the relevant conduct, and they need to be protected in terms of their, work arrangement and right to work in Australia. They shouldn't be, I guess, fearful of any adverse consequences from making the report. And unless all those protections are very clearly in place, then the reality is that workers will be pressured. As per the examples, they will agree, and like I said before, no one will ever know about it. It won't see the light of day. So the provisions, may look pretty in paper, but they will actually mean nothing in practice.
Yeah, and it's been suggested that and even just reading through your submission, that the lack of a firewall prevents exploited temporary migrant workers from coming forward to report wrongdoing. Do you have any examples of which you can provide the committee?
No, Senator, I don't have any specific examples that I would
be at least take it on notice.
Able to disclose. Sorry?
If you're able just to take it on notice with any examples you might be able to provide to us at a later stage, that would be great. Your submission also raises concerns with the power to issue prohibition notices being rested with the Minister and not the Fair Work Ombudsman or other like agencies. Why is this important, and by not giving authority to exercise such as a power to the Ombudsman?
I think our position is the Fair Work Ombudsman has greater experience, obviously, in industrial matters and dealing with employment issues and with workers in an employment context. So that's why we're saying that they would be a more appropriate, bureaucratic agency to deal with these issues.
Are there any agencies other than the Ombudsman that you think might be worth consideration rather than the Minister?
I think at this stage we've indicated our preference for the Fair Work Ombudsman, and I don't think I could really add to that at this point.
Okay. It appears that the government's also sought to exclude domestic work from this bill. Can you articulate the level of exploitation that occurs in domestic work?
Personally, I've seen media reports around nanny-type situations. I couldn't offer much more than that personally, but I think the point we're making in the submission is that there is no reason why those workers should be excluded from the protections. All overseas workers in Australia should be protected.
So what type of workers are we talking about here?
I think au pairs are the example used in our written submission.
Have you had examples about au pairs?
Again, I believe I've read media articles. I couldn't give you a reference right now, but that's all I can refer to at the moment.
All right. And reading, I guess, the EM of the bill and other material, I mean, the government seems to argue that this exclusion is necessary in order to allow prohibited employers to continue to engage trades people and the like. Assuming you agree that the provision should be made for this, how might the bill be amended or improved to allow this to occur without stripping temporary visa workers from engaging in domestic work?
Look, I mean, that's potentially quite a complex drafting issue. I don't have a set of words that I could provide you right now, but I suspect, if there is a will, there would be a way.
All right. Are there other broader, and this is more an open question for the other members of the panel as well, the witnesses that we have here today, but in considering the bill in its current form, what other aspects could we as a committee look at recommending to government to improve the protections and for workers? I mean, what are the most critical reforms that you believe that we should be recommending to government in order to pass this bill in the Parliament? And if others want to jump in, please feel free.
Mr. Costa, you've got an answer you'd like to provide?
Yes, Senator. And
thank you for your hand. That helps.
Yes, it's a bit hard over the video. Thank you, Chair.
It is a little bit hard also to hear you over the rain at my place at the moment. But I also agree with Mr. Crawford's recommendation of a firewall between the Fair Work Ombudsman and the Department of Home Affairs. Going to some of your questions of Mr. Crawford, Senator Ciccone earlier, there is extensive research already in place that has shown that migrant workers are very reluctant to report exploitation because of fear that any information given to the Fair Work Ombudsman will be shared with the Department of Home Affairs, and for that reason there is a chilling effect on them coming forward with issues of exploitation. Some of that research has been done by us and is attached to our submission, but other research by academics Laurie Berg and Basina Fendelbaum from UTS and UNSW has also covered that in quite some detail, including, I believe, a survey of 6,000 migrant workers in which they were able to show extensive underreporting of exploitation because of that chilling effect. Other measures that would also assist migrant workers are ones that would go to removing their dependency on their employer. So, for example, someone who is in Australia on a student visa is required to only work 20 hours a week during their school term or their university term. If they work an additional hour to that 20 hours, they are in a technical breach of their visa. That includes if they work for free or they do unpaid overtime. Many employers are aware of this situation, and so when workers have been underpaid and they go to report that or they raise that issue with their employer has said to them, and we know that this has happened, that if you report this, I will let Department of Home Affairs and
Seems like we may have lost our witness.
Yeah, we have lost some audio.
Could I, Chair, just while
Senator Ciccone, if I could just ask you to, Mr. McCarron, do you want to add to that answer?
Yes, thank you.
Yep, sure.
Send this hand up. Just kind of to echo Mr. Costa's point there, we certainly know that the application that employers are leveraging the 40-hour work restraint as a kind of something that they can hold over employees. And while the NTU doesn't necessarily advocate the kind of removal of this, there needs to be some kind of acknowledgement in the law, in the legislation, that acknowledges the fact that students in precarious work situations don't set their own work hours. They are price takers, as we say. they're taking the jobs that they can get, and they're doing the work that the employer gives them. And so there's a real difference between someone who's working 9 to 5 in a continuing job that's always 40 hours a week, and someone who's in a precarious, casual job where the hours are chopping and changing, and they get called in and they go. And there needs to be some acknowledgement in the legislation about the reality of the situation, the reality of the precarious work that these people are in. And it can't be so rigidly applied in these cases where people are in insecure employment.
And look, just on that point, Mr. McCarron, while I've got you, I also note in your submission, you go at some lengths about talking about the power imbalance, I guess, the power imbalance between the visa holders and the employers. But I was wondering, how could the bill better address this power imbalance?
Well, certainly the biggest issue, and I mentioned in my opening statement, is the fact that the bill seems to rely on employees coming forward to report their employers. And this is where the power imbalance just really comes into play, because if the employee doesn't report the employer, who will? And so the powerlessness of the employee is absolutely pivotal here in allowing the department to identify these employers who are breaching these proposed provisions in this bill. So there needs to be a protection for employees who come forward to give them the power and to restore that balance.
I think we've got Mr. Costa back on the line, but Mr. Costa, in the submission from Unions New South Wales, you refer to evidence suggesting that in the case of exploitation committed by corporations rather than individuals, increasing the severity of penalties is not an effective deterrent. Could you expand further on this evidence and your concerns regarding the effectiveness of the bill's proposed increases to penalties?
Yes, Senator. While we welcome the increase in penalties, there is extensive evidence that just increasing penalties without increasing enforcement provision and protections for victims does not increase deterrence. And that's where we're concerned with this bill, that although the penalties have been increased, the lack of enforcement already that exists amongst offenders of workplace exploitation, and particularly migrant workplace exploitation, is so high that merely increasing the penalties will not go far enough to deter the bad behaviour.
Yeah, and I know the Immigration Advice and Rights Centre provides much needed advice to unfortunately many exploited workers. In your submission, you suggested the department considers amendments to vest courts with powers to make additional enforcement orders, including adverse publicity orders and banning orders, as mentioned on pages 6 to 7 of your submission. Could you please, for the benefit of the committee, expand on your concerns regarding the bill's proposed new offences and the need for courts to have such powers?
Thank you, Senator. We might actually pass this question to Mr. Costa, as we wrote this submission jointly with Unions New South Wales as well.
Okay.
Mr. Costa?
Sorry, Senator, could you repeat the question? I missed that question.
So in the submission that's been provided to the committee, there's been a suggestion that amendments should be made to vest courts with the powers to make additional enforcement orders, including adverse publicity orders and banning orders. And I guess the heart of my question really goes to, why do you think, and could you please explain in greater detail, why that the courts should have these extra powers? Clearly, it's something that you believe that the bill needs some improvements, and I'm just curious to know about that particular aspect of your submission.
Certainly, and Mr. Crawford touched on this earlier today, in that as it is at the moment, we enable as unions and representatives of these workers to enforce those orders that are proposed in the bill, which means it is very, very difficult to ensure that the people who are on the ground representing and speaking to these workers can ensure that they are getting the protection they need. And it is reliant on effectively complaints of exploitation going through a number of hands before those orders would be issued.
Can I just add to that?
Sure.
Sorry, Senator, I just wanted to add that recommendation 7 of the report of the Migrant Workers Task Force does specifically refer to giving courts banning powers. So at the moment, the bill only permits prohibited employer declarations to be made largely on a discretionary basis by the minister, albeit subject to challenge in an administrative tribunal. So we think it would greatly enhance the bill if there was an ability for applications to be made to a court for an employer to be banned either in substitution for or in addition to the ministerial declarations.
Yes, I mean, I do note, I think the government's only selectively used, I think, 2 or 3 of the recommendations out of that report from 2019. But look, my next question, and I'll maybe then hand over to other senators, there's obviously been suggestions that the bill include a legislative guarantee that workers who report exploitation will not face visa cancellation. And again, this goes to the witnesses here today. Why do you consider legislative guarantees necessary, and how could this be included in the bill?
Thank you, Senator. In terms of that recommendation, there's probably a number of ways that visa cancellation could be avoided. The simplest way would probably not require possibly a legislative amendment, but an amendment to policy around visa cancellation, which could be done quite easily. Under a section 116 of the Act is where most temporary visas are cancelled for breach of a visa condition, and there's policy that sits behind that section that the department has regard to when considering cancelling someone's visa. And if that policy was amended, it could possibly weigh in favour of not cancelling someone's visa. The other ways could be looking into amending certain conditions, i.e. Schedule 8 of the migration regs, so that certain conditions have carve-out provisions if there is credible claims of workplace exploitation and things like that. That could be another way in terms of making it a bit more legislative, an amendment to the regulations.
But what about changes to the assurance protocol?
Sorry, Senator, do you mind explaining that a bit further?
Changes to the assurance protocol between the Department of Home Affairs and the Fair Work Ombudsman?
I might let Mr. Mochiletti take this.
I think the difficulty, and I think my colleague, Mr. Strutt, just spoke about the exercise of Section 116 of the Act. No policy can offer guarantees around non-cancellation. No policy can fetter the discretion to cancel or to not cancel. Including I think the term you used, Senator, was insurance or some sort of firewall between the two. That would offer some comfort in allowing individuals to come forward with, particularly I think those who are in current employment, being able to come forward and express their concerns about what's going on. We should not forget, though, that employers themselves, in some circumstances, have an obligation to report, the ceasing of employment, or may, in other circumstances, just write to the department, either anonymously or otherwise, informing the department about a breach of condition. So I guess our position is that for this bill to achieve its intended purpose, it needs to be a package that includes not only the deterrence aspects, which are included in the bill, but also include the protection mechanisms that we've suggested in our submission.
I'm happy to leave it there for now, Chair.
Senator Ciccone, we might just, if you could just make this your last question, and then we'll move to...
For now, Chair. Happy to hand over to other senators.
All right, terrific. Thank you very much, Senator Ciccone. Look, I just wanted to, I'm just going to ask a few questions and then hand over to Senator Van. I want to really, I guess, just run through some of the new offences provided for in this bill, because my concern is that really hasn't been reflected in the evidence that we've heard to date. So there is an important number of new offences that are being created in this bill. One is to coerce or exert undue influence or pressure on a non-citizen work arrangement that would result in breaching a work-related visa condition. Can I just ask, do you support that new provision? I know it's tricky in a panel, but if I could just ask each of you if you could indicate your support for that provision.
I'm happy to go first if that suits.
Yes, Mr. Crawford.
Senator, I think our position would be it's better than the status quo, so a step in the right direction. But
okay.
I've already alluded in my opening statement to concerns about the threshold for undue influence or pressure, and that there seems that the bill seems to contemplate that the pressure or influence, I think the EM refers to that being excessive. And again, I'll just reiterate that it shouldn't be a matter of excessive. There should be a protection or, a prohibition on employers or other people providing any pressure or influence on people to breach visa conditions. Aside from that, I think I'd just refer to my earlier statements, but I do accept that the new offences and the higher penalties are a small step forward. I accept that.
So just before I ask for others to respond, just in more general terms, the bill creates new offences for coercion, for undue influence, and for placing pressure on a non-citizen. These are significant new powers which carry quite significant penalties. So in the case of the coercion or exertion of undue influence, there's a criminal penalty of up to 2 years imprisonment or 360 penalty units, $79,000, or both, or a civil penalty of up to 240 penalty units or $53,000. So we're talking about some very dramatic increases in penalties which are embedded in this bill. Can I ask each of you to respond as to whether you support those penalties?
Yes, Senator. And as I said in my opening statement, we do support any additional penalties that will go away to stemming exploitation. Our concern is that you could have all the penalties in the world. If you don't have someone enforcing them, they're not worth the paper they're written on. And so you can't have one without the other. We do support increased penalties and penalties like this, but only if there will be also additional support for enforcement to ensure that they are enforced and that that those employers who are doing the wrong thing comply with them.
Can I ask other witnesses to question also?
Yep, I'll go.
Thanks, Mr. McCarron.
Yes, Senator. We do support the increased penalties provision, and we do think that is the right direction to take. I suppose we do echo the other panelists in our concern, not so much being with the penalties, but being around who will detect these breaches and how it will be enforced and how often it will be enforced, and if these new powers are really going to be used and have an impact. And that goes back to the protections, whistleblower protections I was talking about earlier.
Thanks, Mr. McCarron. Anyone else want to make a contribution on that question?
Yes, Senator. Just from IARC's point of view, we do support those penalties, and we do believe, as other panelists have said, it is a step in the right direction. Again, our issues are more about how these penalties will be enforced if people aren't empowered to step forward and report unscrupulous conduct or workplace exploitation.
All right. Well, look, I just want to run through a couple of other new powers that have been included in the bill. There is a new power to prohibit certain employers from employing additional non-citizen workers, excluding permanent residents. And I alluded to that earlier in the hearing. And that means that a person can be declared a prohibited employer where they are then convicted of a work-related offence under the Migration Act and required to pay a civil penalty or a remuneration-related breach of the Fair Work Act. And they can also be subject to a sponsorship bar under the Migration Act. There's also a new positive obligation for employers and third-party providers to verify a non-citizen's visa status and conditions using the relevant departmental system before they are allowed to work. And that, of course, goes to one of the reasons why a firewall between Home Affairs and Fair Work would not be a good idea. And then there are other increased financial penalties for work-related breaches and also new regulatory powers for concerning compliance notices and enforceable undertakings. So where a person breaches a work-related provision, an ABF officer can issue a compliance notice requiring them to take specified action to address the breach. And this is very much modelled on the power available to Fair Work inspectors. So when you look at the scope of additional powers in the bill, there's some very, very strong remedies available and strong protections for workers. Could I ask each of you to comment in relation to these particular provisions, please?
Senator, I'm happy to go first. I have already touched
Mr.
on...
Crawford, thank you.
Sorry, Senator. I have already touched on several of these issues already. In terms of the prohibited employer regime, again, that we accept that could have some positive effects, but as I've previously indicated, we would like to see an option for applications to be able to be made to a court rather than leaving those discretionary powers just in the hands of a minister. And in terms of
Mr. Crawford, can I just challenge you on that one? I mean, can you imagine the burden on an exploited worker if there was a really bad egg employer treating workers badly, and you're saying that the minister could not step in and intervene using his or her powers immediately to take immediate action, that basically migrant workers will then be required to go through the courts? I mean, that is an enormous barrier to getting any sort of justice in any sort of reasonable and cost-efficient way, surely.
Well, Senator, my understanding is the bill, as it currently stands, allows the minister to make a declaration that an employer is prohibited in certain areas, but they generally rely on court orders being made on a finding that a breach of the relevant provisions or the Fair Work Act has occurred. So my understanding is that that would already be the case.
Well, but what you're putting to me is that migrant workers who are exploited and who are needing to ensure that an employer grossly breaching the law would be required to go to a court. I mean, that sets up really a terrible barrier, and a terrible barrier to getting quick access to justice, surely.
Well, like I said, Senator, I believe that barrier is largely already there in relation to the current bill, but I think I did allude to earlier that the court power could be in addition to the ministerial declaration power. So you could leave that ability for the minister to make declarations there. We just think there should be scope for an independent court to also be able to make the banning orders or declarations as well.
All right, thank you. Any other responses to the earlier question I put in relation to the additional powers in the bill?
Senator, I would like to take some of those questions on notice, but I do want to say that I support the submission of Mr. Crawford in relation to the Minister's power to enforce. And I'd also like to add, currently the Minister for Employment Relations does not have the ability to enforce similar type orders for citizen workers. And so I think the comparison to say that these workers are so exploited that the minister should be the only person responsible for the use of these types of orders is not really a correct comparison. By asking for us to be able to take these matters to court, what we're actually asking for is the ability to enforce these types of orders in the same way that we do for citizen workers when they're exploited. But with taking into consideration the unique circumstances of migrant workers. Without our ability to do that, the traditional representatives of workers who are unions, and particularly Visa Assist, which represents migrant workers, is a union program, we would be cut out from being able to represent those workers with these types of orders.
Yeah, but can I put it to you, Mr. Costa, that unionism in this country is not compulsory. all workers.
No, I agree with you.
Yeah, all work. So just if I can just make this point, all workers have the choice whether they want to engage someone to represent them, and it may well be that there might be someone other than a union that a worker may wish to represent them.
I agree with you, Senator Henderson, and likewise, migrant workers don't vote in this country either, and they don't elect the minister who you're proposing should be the sole person to enforce these orders.
No, I'm not proposing that.
Yeah, well,
no, Mr. Costa, I'm just raising the question about the barrier.
Yeah.
In resorting to the court to get a remedy in relation to a rogue employer, that could set up a situation where it would be very difficult to get cost efficient and immediate access to justice. That's the point that I'm making.
Thank you, Senator. That clarifies it somewhat, but I do continue to agree with Mr. Crawford in that it doesn't need to be an either-or situation. If the minister is to have this power, there's no reason why we shouldn't open the access to the courts for migrant workers who aren't being represented by the minister in those matters.
All right. Any other responses on the earlier question that I raised?
I'll just jump in quickly, if I can.
Yes. Thanks, Mr. McCarron.
Thank you. Look, we generally agree with Mr. Crawford and Mr. Costa about expanding access to those prohibition orders. Our understanding is that the minister cannot make a prohibition order unless the employer has already been subject to a court order. So it does seem like there is a barrier there in the bill. A proposal perhaps would be to lower that bar so that they could be subject to an order from the Fair Work Ombudsman, which is a bit more of an accessible institution for workers who can kind of individually go down that route if they're not a union member. And potentially another comment, putting that aside, would be having a bit of transparency around the minister's powers or a bit of openness for parties to make submissions to the minister, perhaps in favour or against a prohibition order, would be another suggestion.
Look, just to clarify that the bill doesn't require a court order for the minister to prohibit an employer, and the Home Affairs Department, and we'll obviously hear evidence from them later in the day. They've sanctioned extensively many employers, 156 employers in 2018-19, 166 employers sanctioned by Home Affairs in 2019-21, and obviously they're able to do that quickly and efficiently when serious issues arise. Look, I just want to generally raise one other issue, and look, I will say respectfully that Labor senators have had a few, and even witnesses today have had a few cracks at our government in relation to this bill. But isn't it the case that this is a huge step forward in terms of the protection of migrant workers compared to what we have seen previously, and including under the former Labor government?
Senator, may I go first?
Yes, Mr. Crawford.
Just on your previous answer, I'd refer to the committee to section 245 AYA, subsection 2 of the proposed bill, which appears to list 4 criteria whereby an employer could be declared to be prohibited, and they seem to operate with reference to a separately imposed bar or otherwise court proceedings. So that's why I was making those comments earlier. Again, I'd reiterate that there are some positive elements in the bill, but I think the points we're making pretty clearly are that most of the provisions on the bill will have no practical effect whatsoever unless workers are able to report the instances of bad behaviour, and that, like I said before, they may look pretty on paper, but if nobody is finding out about the relevant contraventions or the relevant conduct, then they are effectively useless. So that's why we're reiterating that that element of workers being able to safely make reports of bad conduct is so critical, because the whole regime doesn't really get activated. The prohibited employer stuff, the offences, none of that arises or gets activated unless people are finding out about the conduct. That's why it's so critical that workers have protection and feel comfortable to report the conduct. In relation to like I said, the bill is a small step forward. I think a bigger step forward for the horticulture industry in particular is the AWU's recent success in getting a minimum wage guaranteed for all workers under the Horticulture Award. Effective 28 April this year, there will be the Horticulture Award will be varied to guarantee that all workers, including peace workers, paid by the piece, not by the hour, will be entitled to receive the minimum award wages. So for the horticulture industry, we think the AWU's success there will be far more beneficial than this bill in improving compliance within the horticulture industry. But despite that, we do accept there are some positive elements for the bill.
Yeah, and just to sort of clarify this matter in relation to the prohibition of employers, Mr. Crawford, the Home Affairs has pointed out in its submission that it's sanctioned a number of employers, many hundreds of employers, in fact, in recent years. But under this bill, the minister then has the ability to step in and prohibit an employer from engaging migrant workers. And that's a very substantial step forward in the protection of workers, surely.
Well, I mean, on the spot, to be honest, we might have to agree to disagree about the illegal effect of the provision, because as I read it, it still operates the grounds on which the minister can declare an employer to be prohibited. On my reading, as I've previously articulated, that section 245 AYA subsection 2 specifies 4 grounds where the declaration can be made, and they are activated by either a bar imposed by the minister, or the other 3 criteria relate to court orders, so whereby a court has already made orders in relation to the employer. So I may have misread something. I apologise if that's the case.
Well, we can actually ask the Department of Home Affairs. That's not my understanding, but we can certainly ask the Department of Home Affairs to add to its submission and clarify the point that you've raised.
And I also believe the way the bill is drafted, it only covers prospective contraventions or breaches. So all these past, notices or whatever that the department is referring to, my understanding is none of that can be taken into account by the minister in determining whether to make a prohibited declaration against an employer. It only covers effectively orders or bans, whatever it is, imposed after the bill commences operating.
Okay, thank you. Any other comments in relation to these matters?
Yes, Senator, I'd just like to make a quick comment as well. From our point of view, the bill is a small step forward, and echoing what Mr. Crawford has already said about that and the need to protect migrant workers. And the only way we think that can truly happen is through protecting their lawful status in Australia and their visa status. The other concern we have as well is possibly flow-on effects from the punitive nature of the bill in terms of the way it affects sponsors and employers. And by that I mean, and I guess I can use an example, Senator, you were talking about sanctions earlier and the Department of Home Affairs putting sanctions in place. We've had a number of clients who've been subject to almost slavery-like treatment in Australia by employers and have been sponsored by those employers for permanent residency. But then before that permanent residency can be approved, the sponsor is then sanctioned for their treatment of their employers. And then with that sanction comes the loss of that visa. So they're no longer eligible for the visa because they've lost their sponsor. Whereas if they got that permanent residency, the next day they could have left their employer, but instead they're left in the lurch effectively. And then they appeal those decisions. And, the appeal doesn't have any basis because they don't have that employer sponsor. So while we appreciate that the bill does, hope to act as a deterrent, there could be real flow-on consequences for visa holders and visa applicants when these enforcement measures are taken.
Right, anyone else want to make any further comments in relation to these matters? And look, in doing so, I just think it's helpful and for the record and for those who are listening, and just to spell out as set out in the Home Affairs Department's submission, and I understand it's obviously we're not going to hear from Home Affairs until later in the day. This bill includes 5 key measures. So I just don't want there to be any misunderstanding as to the importance of the bill in terms of what it actually does do. It includes new criminal offences for using a person's migration status to exploit them in the workplace. It provides a mechanism to prohibit employers that have engaged in serious or repeated non-compliance from accessing temporary migrant workers for a period of time. It provides positive obligations on employers and third-party providers to ensure the status and work-related conditions of all migrant worker employees is verified using specified departmental systems prior to any employment. It increases the pecuniary penalties for existing work-related breaches and offences under the Migration Act, and it includes new compliance tools to better support the ABF, Australian Border Force, to respond proportionately to cases of compliance. So, look, on that note,
Can I make one comment before?
Yeah, sure. Yes, Mr. Strutt?
At Mojtahedi.
Mr. Mojtahedi, yes, please.
I think earlier on, Senator, you made a remark to the effect that the witnesses, presumably those before you now, or even perhaps before us, were not bringing an open mind to the intention of the bill. If I could just address that. Speaking for ourselves...
Mr. Mojtahedi, just to clarify before you go on, I didn't use those words. I expressed concern that some witnesses had reflected on the work of our government in relation to these matters without acknowledging that under the previous Labor government, none of these protections were in place for migrant workers. So it's obviously a partisan point, but it is also a point made to balance some of the earlier evidence that we've heard today.
Chair, I mean, just on a point of order, I mean, I think it's fair to let the witnesses answer the questions that are put to them. And the constant interrupting is not allowing them to answer your questions.
Senator Ciccone, there is no point of order.
I mean, the government's been in power for almost a decade, and we're continually having the government attack our witnesses. So could you let them at least answer your question?
You don't have the call, Senator Ciccone. So look, I just wanted to, when you put that to me, Mr. Mojtahedi, I just wanted to clarify that I didn't use the words that you suggested that I used, and so that's why I clarify what I said. But please go ahead.
I didn't mean to mislead the comments.
No, that's fine. No problem.
But I just wanted to make the point that that certainly for our part, and having read the submissions of the others, the general consensus is that we support the intention of the bill, and what we are hopefully attempting to achieve by giving evidence today is suggest what measures can be put into place to help better achieve the intention that the government is seeking.
Thank you very much.
I didn't mean to just disturb the process.
No, I do very much appreciate that. Thank you. Look, on that note, I will now hand over to Senator Ciccone. You're seeking the call?
Look, Chair, no, I'm not. But
okay.
I think we've got other witnesses here on our program. But it is worth just noting that, since 9 years of this government, we've had half a dozen reports on this issue. And it's taken you 5 minutes to midnight to finally present a bill to the Parliament.
Senator Ciccone,
but thank you for the call.
That's really inappropriate. You don't have the call to run that sort of commentary, and you know that. You're an experienced senator, so I please just respect the rules of the Senate in relation to this hearing today. Look, we will now conclude, therefore, our evidence from the witnesses before us. Thank you so much for your time and for your evidence today. We're most grateful.
Thank you, Chair. Thank you, Senators.
Thank you.
Thank you.
Thank you.
Thank you, Senator.
I would now like to welcome representatives of the Salvation Army of Australia and Uniting Church in Australia Synod of Victoria and Tasmania, the Migrant Workers Centre and the Migrant Justice Institute, and AIMS Australia. Thank you all very much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 1, 5, 8 and 15 respectively. For the Hansard record, could you each please state your name and the capacity in which you appear today, including whether you wish to make any correction to your submission?
Thanks, Senator, and thanks, committee. My name's Matt Kunkel, or Matthew Kunkel with 1T. I'm the CEO of the Migrant Workers Centre at Victoria.
Thanks, Mr. Kunkel.
Good morning. My name is Catherine Hemingway. I'm the Legal Director at the Migrant Justice Institute. Thanks for having me today.
Thanks, Ms. Hemingway.
Good morning. My name is Tanushree Kankananke, and I'm the Senior Registered Migration Agent for AIMS Australia.
Thanks very much, Ms. Kankane. Do any of you have an opening statement of no more than 3 minutes?
Chair, there's someone from the room.
Oh, I apologise. Someone's in the room.
Yes, Heather Moore, Chair.
I'm sorry, that one more person who needs to introduce themselves.
Yeah, sorry, I'm actually here in person. So Heather Moore,
Yeah, thank you.
Senior Advisor with the Salvation Army Australia.
That's a radical concept.
Yeah, I know. Well, I was very excited to be able to come in person, see everyone.
Good to see a real person.
Yeah, I know, it's great. I give my apologies, I offer my apologies on behalf of my co-submitter, Dr. Mark Zernzak. He unfortunately is otherwise engaged. Thank you.
Could you please introduce yourself and the capacity in which you appear?
Sure, Heather Moore, Senior Advisor for the Salvation Army Australia.
Thank you very much, Ms. Moore. Now, does anyone wish to make an opening statement of no more than 3 minutes?
Yes, thank you, Senator. We've done a bit of a straw poll and I'm heading off the batting this morning or this afternoon.
Right, so just you're the only one making an opening statement, Mr. Kunkel?
No, I think there's some very short statements from each of us, but very, very briefly though for the committee. The Migrant Workers Centre is a not-for-profit centre located on the unceded lands of the Wurundjeri people, and I pay my respects to their elders past and present. Our primary purpose is to assist migrant workers by educating them about their rights and collaborating with them to see those rights respected and enforced. We, like many others today, have made submissions during the exposed draft stage of this bill. I'm very grateful to the members of the committee for providing us the opportunity to expand upon our concerns about the consequences of passing the bill without further additional measures to support migrant workers wrapped around it. Critically, from our perspective, the lack of whistleblower protections in this bill means that instead of improving the situation for many, this bill could push migrant worker exploitation further into the shadows. And when the Migrant Worker Task Force handed down its report in early 2019, it cited a study that 50% of temporary migrant workers were being underpaid. And now, 3 years on, our own research suggests that the prevalence of wage theft and other workplace abuse continues to be systemic and across all corners of our economy. And our report showed 65% of those surveyed are actually reporting being paid less than their legal entitlements. And I would draw the committee's attention to figure 1 on page 3 of our submission, which shows some of the other issues faced by those on employer-sponsored visas. At the core of this, for many temporary visa holders, their employer is not only the source of the money that pays their rent, but also their right to remain in the country. And for many, because of our visa system settings, their employer sponsorship reflects possibly their very last chance for a pathway to permanent residency. And speaking out about issues in the workplace brings the very real risk of the breakdown of that employment relationship and the disruption of their pathway to permanency and the setting of a 60-day window to either find a new sponsor or to leave the country. So central to addressing exploitation of migrant workers is a shift inside our visa system that provides more secure and stable pathways to permanence. And unless migrant workers can be assured that they will not face adverse migration outcomes for their current, and this is very important, any subsequent visa applications, the introduction of this bill in its current form will only create an additional barrier to reporting workplace wrongdoing. And we know this because we see it. Many come to us and don't end up raising their industrial issues for fear of losing their pathway to permanency. The intersection of our migration and industrial laws structurally bruise the conditions for exploitation, and our national response to this issue requires a wider rethink of our visa system and a more fulsome set of protections that would genuinely incentivise as migrant workers to ventilate their industrial issues, and we're very happy to expand on any of those things today.
Thanks, Mr. Kunkel. Any other opening statements?
Am I going next or Thanushki?
Yes, you may go next.
Okay. Heather Moore, Salvation Army, thanks for the opportunity to appear before you today. And I'd also like to pay our respects to the traditional owners of the lands on which we meet, the Ngunnawal people, and extend those respects to any Aboriginal Torres Strait Islanders who are present today. So some of you may be aware, some on the committee may be aware that the Salvation Army operates programs to protect victims of criminal labor exploitation, including modern slavery and human trafficking. And we also work in the area of prevention. Through this work, we engage regularly with migrant workers who are in Australia on a range of visas, who are experiencing a range of various forms and degrees of exploitation at work. And we have seen cases where immigration authorities have actually visited workplaces on immigration, on compliance checks. And because the victims were too afraid and mistrustful to say what was happening, they basically missed the slavery and trafficking were actually occurring. And as a result, that pathway out of exploitation was closed and an opportunity to hold that employer accountable was missed. Now, I'm not blaming the authorities for that. I'm simply pointing out the impact of the fear. This example really illustrates the challenge before us, and what I think many of the witnesses I've heard so far are saying is that while there is fear, unlawful conduct thrives. So we don't oppose this bill, but like others you've heard this morning, in its current draft, we are concerned that it will have limited effect. And this is for three primary reasons. First, as again many have already said, there are, in our view, inadequate safeguards to enable workers to come forward and to cooperate with authorities. And this is necessary, of course, not just to detect non-compliance, but also actually presumably to prove this element of undue influence. The second concern we have is that limitations of current enforcement practice, namely what appears to be an underutilization of available penalties within the Migration Act, and what we see to be a relatively high threshold for non-compliance, which we would respectfully suggest is contributing to entrenched unlawful conduct. The third reason is that the bill excludes an entire group of highly vulnerable workers. Senator Ciccone, you were asking about this in the previous section. I'd be very happy to expand on that for you. We're talking about the exclusion of workers in the domestic context. Salvation Army has extensive experience supporting private domestic workers who have experienced some of the worst forms of exploitation that I've seen in Australia. And this bill would exclude them from protection, including au pairs, which I think there are an estimated 10,000 in the country before COVID lockdowns began. More broadly, we do have reservations about expanding the remit of the department in this space, given the known fears migrant workers hold. And we think there are other ways to deter unlawful employer conduct, which we also speak to in our submission. We also have questions about the feasibility for the department to actually enforce the ban preventing employers from hiring temporary visa holders outside the formal sponsorship arrangement. It's unclear to us how the department would be able to monitor banned employers' hiring practices. In our view, this responsibility sits more naturally with the Fair Work Ombudsman, which where there's some successful precedent from New Zealand, which of course we also expand on in our submission. So in conclusion, we do see this bill as an opportunity. We really appreciate and welcome the intention behind the bill, but we see it as an opportunity to look beyond incremental reforms to how the broader system can be improved and more responsive to those factors preventing swift detection and effective deterrence. Thank you.
Thank you so much.
I'll go next. Thank you, the committee, for the opportunity to be here today. On behalf of AIMS Australia, we would also like to acknowledge the traditional owners and custodians of this land on which we are meeting today and pay respects to their elders past, present, and recognise their continuing connection to country, land, waters, sky, and cultures past and future. So AIMS has a 70-year-long history of working with new arrivals to Australia, and that's through both the permanent and temporary migration pathways. The overarching purpose of the work we do is to support migrants and refugees as they move from early settlement to independence and greater social and economic participation in Australia. So we also have a migration advisory service, which is a certified social enterprise. And through that, we also provide migration advice and visa application assistance to a lot of temporary migrants in Australia. And it is in this context that we're making our submission to the committee today. While we welcome the legislative reform to address migrant work exploitation, we also want to ensure that the bill in its current form adequately protects migrant workers. Our position is that further work and further changes are required so that the stated intent can be effectively implemented. And some of the changes that we think should be included is introducing measures to support and encourage migrant workers to report exploitation without fearing consequences for their visa status, removing visa conditions that are likely to make migrant workers more vulnerable to exploitation, and providing appropriate and accessible information on workers' rights to empower and educate them. We're pretty much echoing what I think the other panelists are also saying today. And why we think this is important is that without the safeguards for migrant workers who report workplace exploitation, there's a strong likelihood of exploitation going undetected and unreported, which will affect the efficacy of this bill. And a solution, like everyone has stated, could be potentially providing visa pathways to allow affected migrants to remain in Australia through the creation of a new substantive visa and ensuring that pathways to permanent residency will still be available through alternative means if their employer that's sponsoring them is either sanctioned or their sponsorship is cancelled. And we all know that temporary migrants have low awareness of workplace rights due to language, literacy and cultural barriers, and migrant workers rarely contact mainstream agencies for help. A solution could be ensuring that migrant workers are empowered by providing them with in-language information on workplace rights upon the grant of their visa, while also improving the culture and responsiveness of government agencies. And I thought I'll conclude today with a case study that recently AIMS assisted with. A Tibetan refugee family living in Australia for 5 years moved to regional Victoria, having found agricultural work on a farm that offered shared accommodation. Upon relocating, they found the employer was exploitative and abusive to workers, and when the family complained of underpayment, they were immediately dismissed and told to vacate the property, rendering them effectively homeless. While they found alternative accommodation, their precarious situation meant that they moved to a dilapidated, unhygienic building on a new farm without running water and electricity. While the family had good understanding of the workplace rights, standing up for their legal rights meant they were immediately dismissed and rendered effectively homeless. And this pretty much highlights the importance of centering experience of migrant workers and ensuring that there are sufficient safeguards and protection in place for those who report exploitation. Thank you.
Thank you so much. Now, you're also joined by Ms. Demadiak. I don't think Ms. Demadiak has introduced herself.
Yes, Tess?
Yes, so could I just ask, if possible, Ms. Demadiak, could you turn your camera on and just introduce yourself and also the capacity in which you appear today, please?
Thank you. My name's Dr. Tess Demadiak, and I'm a colleague of, I'm the Senior Manager of Research and Policy at AIMS Australia. I'm supporting my colleague here, Thanushki.
Thank you very much, Ms. Demadiak. I appreciate that. Do we have any other opening statements?
Yes, one more.
Sorry, I know it's a bit tricky when so many of us are appearing remotely, so thank you for all managing so well.
No worries. Thank you very much for having us. I'd like to open by acknowledging the traditional owners of the land from which I'm dialing in on today, the Wurundjeri people of the Kulin Nations, and pay my respect to elders past, present and emerging. Today, I'll introduce the Migrant Justice Institute, build on my colleagues' statements to outline our key concerns with the bill, and suggest an alternative approach. The Migrant Justice Institute undertakes strategic research and legal action to achieve fair treatment, enforcement of rights and access to justice for migrant workers. We bring together legal academics from the University of Technology in Sydney and the University of New South Wales with Melbourne-based employment and equality lawyers and policy experts. Our research shows that the exploitation of migrant workers is widespread and endemic. Our survey of over 4,000 migrant workers found that at least a third earn less than $12 an hour. The overwhelming majority of these workers suffered wage theft in silence. Fewer than 1 in 10 took action to recover wages that they were owed, and workers cited concerns about their visa and implications for their visa as a significant reason for not taking action. As we've heard today from many people already, for many vulnerable workers, challenging unlawful employer behaviour is an impossible choice. Workers face language and literacy barriers, limited access to legal support, insecure work and insecure visa status. Bringing a wage theft case to court is complex, expensive and slow, and reporting other exploitative employer behaviour may cost a migrant worker their job and their ability to stay in Australia. For many, it's just not worth the risk to complain. The Fair Work Ombudsman is under-resourced and runs less than 100 court cases a year. Employers know this and exploit workers with impunity. This exploitation not only harms migrant workers, it also drives conditions down for Australian workers and undercuts businesses who are trying to do the right thing. And we really commend the government for attempting to address this significant problem. However, unfortunately, this bill will not protect vulnerable workers and it will not stop exploitation. The bill fails to address the structural drivers of exploitation or the barriers to migrant workers reporting exploitative conduct. The bill ignores the evidence on interventions that would have an impact on reducing and addressing exploitation. And the bill focuses only on employers. It doesn't provide any additional rights, protections or assistance to exploited migrant workers. The bill focuses on a very small subset of exploitative employer conduct and is a piecemeal response. The bill in its current form represents a missed opportunity. For our labour law and migration law systems to effectively protect vulnerable workers, we need a whole of government response that shifts the risks and enforcement burdens off those who are most vulnerable. We make 15 recommendations in our submission, and I'll just briefly draw your attention to a few now. Regarding the bill itself, we recommend that the new employer sanctions not be introduced. If they are to be introduced, we suggest that the sanctions be moved to the Fair Work Act and enforced by the Fair Work Ombudsman, who will need dedicated resources and a tailored enforcement strategy. Further, as the Migrant Worker Centre explained, amendments must be made to ensure that migrant workers are protected if they complain and not penalised for unlawful employer conduct. And we'd be happy to provide some sample drafting on this on notice. The definition of arrangement in relation to work must be broadened to capture egregious employer conduct that might fall outside typical understandings of work arrangements, including demanding sexual favours in return for visa sign-off or requiring workers to endure appalling accommodation to get their visa forms filled out. Prohibited employer declarations should also be made by the Fair Work Ombudsman, and all types of unlawful employer activity should be covered. It's too slow and impractical to wait for a court order for an employer declaration to be made. We recommend that declarations should occur when an enforcement agency forms a reasonable belief that a contravention has occurred. But even if all these recommendations are adopted, the law will still fail to address the problem at its heart. Within the Migration Act, we need to ensure that workers who complain are protected now and for future visa applications. We recommend removing the 40-hour fortnightly work condition on student visas. We recommend the introduction of bridging arrangements for all temporary visa holders and visa overstayers to pursue meritorious claims. And we recommend that a firewall be established between the Fair Work Ombudsman and Department of Home Affairs. Beyond the Migration Act, we need to introduce a raft of legislative reforms to the Fair Work Act to incentivise employer compliance. We need a simpler, fairer and faster dispute resolution process for unpaid wages and entitlements. We need a more accessible and better resourced enforcement agency with a dedicated unit for migrant workers and increased access for unions and community legal centres. We need a whole of government response to this issue, not a piecemeal or narrow focus. Only then will we begin to protect vulnerable migrant workers and so all workers in Australia. Thank you very much for having me today.
Thanks very much, Ms. Hemingway. That completes all opening statements. We will now go to questions from senators, and I give the call to Senator Van.
Thank you very much, Chair. First to Ms. Hemingway, because you were the last off the mark, so freshest in my mind. You referred to some offences, sexual exploitation and the like, that employers might visit on workers. They're already illegal, are they not?
Yes, I'm just talking about in terms of the context of the employer sanctions. Currently, the definition of working arrangement is not specified to be that broad. So I guess we just want to make sure that there's a clarification in the bill that specifies that work arrangements is broad enough to capture, for example, if a worker is told that they need to perform some sort of sexual act in order to get their visa sign-off, that the definition of arrangement in relation to work is broad enough to capture that. And I think that in the explanatory memorandum for the bill, the government has expressed a desire to have a broad understanding of work, but that was more in respect of the employer declaration section. So I guess it would just be a small amendment that I could provide some drafting on if that would assist.
Thank you, but my point is that activity or that offence is already covered under this bill, because that would be seen as coercion or many other things that would fall foul of this bill. Isn't that correct?
So under the proposed bill, I'm just getting the section in front of me, sorry. So a person will contravene the subsection if they coerce or exert undue influence to accept or agree to an arrangement in relation to work. And we just want to make sure that that definition of an arrangement in relation to work is broad enough to capture awful accommodation or a requirement for sexual favours. So it's not just about wages and entitlements or things that are more typically considered to be arrangements in relation to work.
Sure. To my mind, I think it is captured very well under that, but I'll move on. You talked about a better resource enforcement agency. Recommendation 10 of the task force suggested significant new resources to the Fair Work Ombudsman. Are you aware that $180 million has been provided to the Fair Work Ombudsman to conduct this work? Sorry, and that is since 2016.
We would welcome any further allocation of resources to the Fair Work Ombudsman, but I guess our research is just
So how much more than 180 million would you suggest? Isn't 180 million dollars a significant amount already?
It is, but it's not enough based on what we found from our research. For example, in a recent survey that we undertook of thousands of migrant workers, only 3% of underpaid participants contacted the Fair Work Ombudsman, and well over half of those workers who contacted the Ombudsman recovered none of their unpaid wages. And I guess it's apparent that there is much greater need for dedicated support and assistance for workers to be able to bring claims effectively. It's a complex system, and with all of the barriers that are faced by migrant workers, more support is needed.
I'll put that question on your behalf to Fair Work Ombudsman later today. I'll see whether they say they're not doing their job properly or not. You also made a recommendation of a firewall between the Ombudsman and Home Affairs. In what other legislation does such a mechanism, a firewall, exist?
Thank you for that question. In a recent report put out by my colleagues Laurie Berg and Bettina Farbenblum, called Access to Justice for Wage Theft, a global study of promising initiatives, we document examples where such a firewall exists. So, for example, in Israel, there's a complete firewall separating immigration enforcement authorities from labour enforcement agencies and labour courts.
Sorry, I should
as
have
well
been clearer. We are the Australian Senate. In what other Australian legislation does such a mechanism exist?
I'm not sure. I would have to take that on notice, but I can outline some international examples specifically relating to firewalls between labour and migration departments that are working effectively.
Just for time management, you feel free to put that on notice. If it was you or, sorry, I think it was you also said an expansion of the 20 hours or 40 hours per fortnight for student workers?
We might need to make that the last question, Senator Van.
Sure. Let me put the question. I'm just making sure that I'm putting it to the right person. If if students were allowed to, and I say this as a current student who struggles with my student workload and my work workload, when are the students going to study if they're working full time? And isn't that the point of their visa?
Also, as a student who struggles with my workload and family load and studies, I think that's a welcome question. And I guess what we say is that the conditions 8104 and 8105, which are the 40-hour per fortnight limit, really all we see of them is that it presents a barrier for migrant workers to be able to bring claims for fear of loss of visa, and that there are other conditions on that student visa that serve to ensure that students are doing the right thing and that the primary focus of being in Australia is to study. So, for example, condition 8202 requires that international students maintain enrolment in an approved program of study and maintain satisfactory attendance in their course, as well as course progress for each study period as required by their education provider. And there's no evidence that condition 8105 serves any additional protectionist purpose in that regard.
Well, it certainly does. It allows them to conduct their studies. Otherwise, they're using a student visa basically as a cover to come here and work. Wouldn't you agree?
I can see that my colleague Matt Kunkel also has his hand up, but I guess we would say to that 8202 is serving that purpose in ensuring that people are here to study. They'll have their visa cancelled if they don't comply with that condition.
But they're aware of that condition when they accept that visa. I'll leave it there, Chair.
All right, thank you very much, Senator Van. I'll now give the call to Senator McKim, who is appearing also by video conference.
Thanks very much, Chair, and thanks very much to all the witnesses for their submissions and their appearance today and their opening statements, which were very helpful. Could I just start by asking Mr Kunkel whether he has any observations regarding the resourcing of Fair Work Australia or the Fair Work Commission, and in regards to the issues that Senator Van was just raising in relation to student visas?
Thanks, Senator. The Fair Work Ombudsman has increased its investigations over the past few years. That is true. They're doing a very difficult job in very difficult circumstances. To raise a point that Senator Van made, and I think perhaps Senator Henderson too earlier in the day, about the record recoveries, I think it would be a question for the Ombudsman about whether $100 million of that is actually from self-reporting from large corporate businesses over the last period, which is in the same report that was quoted this morning. So we can't rely on small and medium businesses who are sponsoring one or two migrant workers to self-report malfeasance. So there's always going to be a need for a combined approach, including the Fair Work Ombudsman, including unions, including community legal centres and other advocate organisations. So it's a very difficult set of circumstances there. And in terms of the international student visa, I think as Senator Van knows, people just make it work. You have to work full time and you have to study full time as well. And the reality on the ground is that people are already breaching this visa because wages are so low. It's almost impossible to survive on 20 hours a week of work. The challenge, as Ms. Hemingway said, is that working in breach of your visa makes it very difficult to then raise that issue and have it heard, because many bosses are saying, well, I'll just report you to the department. And the key thing there is workers know, and international student visa holders know, that they are looking for another visa in the future, a more permanent visa, and they are unlikely to get that if they have to tick the box that says, I've breached a condition of a previous visa in the country. So that's why we say there must be provisions wrapped around a bill like this that allow workers who have been exploited in the workplace to report without fear of an adverse outcome for this visa or for any subsequent visas in the future.
All right, thanks. That's really helpful. Thank you. And I wanted to, I guess, there's just two areas I'd just like to explore briefly. I know we're under some time pressure here, but firstly, in regards to, and I acknowledge that some of you have raised these issues in your submissions and or your opening statements today, but just specifically in regards to the circumstance where migrant workers would quite understandably have concerns about speaking out, in particular if they've been coerced by an employer to breach their visa conditions, whether you think that the current assurance protocol between Home Affairs and Fair Work is fit for the purposes of the bill within that context that I just outlined, and if not, why not, and how could it be improved as it could? And I'd particularly be interested in hearing, I guess, from Ms. Moore on this, but I'll throw it to any of the witnesses. Perhaps we could start with Ms. Moore.
Oh, I'm sorry. I thought you were putting that question to Mr. Kunkel.
Oh, I'm sorry. I was actually putting it to everyone, but I'm happy to start with you, Ms. Moore.
Oh, sure. Thank you for the question. Yeah, well, look, you would be aware in our submission that we cite the Senate Select Committee on Temporary Migration, where evidence was put that while a small number of people have come forward under the current protocol, assurance protocol, that the committee concluded that assurance protocol does not actually provide sufficient protection for whistleblowers and temporary workers who report wage theft or exploitation. And I think, and probably Ms. Hemingway would probably have more to say from their research, but in our observation, the assurance protocol just doesn't go far enough. We also speak at some length in our submission about the need to address how the assurance protocol is explained to people. The language that's used is quite vague, and I think would lead some visitors to the website looking at, weighing up their options about whether or not to avail themselves of the assurance protocol, would be left wondering whether or not they actually would face any adverse outcomes as a result of making their issues known. And then, of course, also, as Ms. Hemingway pointed out, the assurance protocol is quite limited, so it doesn't actually it doesn't protect all visa holders.
Thanks, Ms. Moore. Ms. Hemingway or Mr. Kunkel or any of the other witnesses wish to make some observations on those issues?
Just quickly, thank you for the question. From a recent Freedom of Information request that we put in, we can see that there's only been 76 referrals made by the Ombudsman to the Department of Home Affairs under the Assurance Protocol between 1 February 2017 and 30 November 2021. And that number has actually decreased in the last 2 financial years. It's gone from 9 to less than 5. And we say this data shows that the number of visa holders that have sought protection, that's clearly ineffective at the moment. And I guess we've got a few key concerns around it. Firstly, it affirmatively requires the Ombudsman to pass on the workers' information to Department of Home Affairs, and that's a significant barrier. And like my colleague Heather was saying before, in terms of fear, I mean, knowing that your details are going to Department of Home Affairs is a significant barrier. It's also not clear from the protocol that the protection around visa loss extends to future visas. So we'd say the protocol could really be greatly strengthened if there was a commitment there that it's not going to affect an international student who later applies for permanent residency, for example. And until that happens, people are going to be too afraid to use it. And also, we say that it's not clear that a worker who's identified as a victim under 245 AAA in this new bill would be eligible to access the protocol if they hadn't sought advice or support from the Ombudsman and helping them with their inquiries. So if someone just approaches the Fair Work Ombudsman and then doesn't proceed with a claim, it's not clear that the protocol would protect them either. So there's some serious deficiencies in the current system.
Thanks, that's really helpful. And Chair, I will make this the only issue I now raise. I just wanted to give a couple of the witnesses who haven't had a chance to respond that opportunity now. So perhaps Mr. Kunkel, I think I can see you drawing breath there.
Thank you,
Yeah,
Senator.
thanks. We'll just ask if witnesses can respond reasonably succinctly. Thanks, Senator McKim, because we're running a little bit tight for time.
Thanks, Chair. I would just say that I align myself with the comments of Ms. Moore and Ms. Hemingway and really drive home that issue of the need to protect subsequent visas, because the lack of a pathway to permanent residency for many is the issue here. International students are here on, we say, de facto work visas, the extension of or the relaxing of the 40-hour fortnight rules during the pandemic, I think showed that. We rely on their labour, and the challenge for us is to find pathways that they can safely move to permanent residency if that's what they wish to. And we need to reduce that barrier to reporting by ensuring they have the confidence to report without fear of that adverse effect for subsequent visas as well.
Thank you. And lastly, just if anyone from AIMS Australia wished to respond to those issues.
I echo the comments of my colleagues. In terms of the student visa conditions, like Catherine pointed out, there are existing conditions that require the students to ensure that they attend classes and meet all the coursework requirements. So the core purpose of the visa is met through that. And as Matt said, during the pandemic, we relaxed the work rights condition and have relied on the labour. So it is possible, as evidence, to both study and work and ensure those requirements are met. So removing the work restrictions and the unnecessary limitations will only give them the ability to actually report these exploitations without fear of jeopardising their current and future visa status.
Thanks, that's really helpful. Thanks, Chair.
Thank you very much, Senator McKim. Senator Ciccone.
Thank you very much, Chair. I might start with the Salvation Army and Uniting Church. You suggest greater use of sanctions for workplace non-compliance that do not require participation of migrant workers in your submission. Can you expand on the need for such sanctions and how these might be included in the bill?
Sure. So the point we're trying to make here, at the heart of this is actually, I mean, we talked a bit about the limitations of the bill, and I wanted to point out that my read of the bill was the same as Mr. Crawford previously, that the prohibition would require some kind of court order. So I'd be interested to know if my reading of that is wrong. But knowing that the limitations of relying on court proceedings happen so rarely, but more importantly, there's a real difficulty in actually proving coercion. There are not many areas, I should say I'm not a lawyer, but I'm quite familiar with this part of the law. There are not many parts of Australian law that actually criminalise coercion. One place where it is criminalised is in the Commonwealth Code Divisions 270, 271, which are the trafficking and slavery offences, and we have about 20 years of experience seeing how difficult it is to prove coercion. So knowing that difficulty, with respect to the current drafting, we're encouraging the government to explore other ways to hold employers to account for unlawful conduct, where you do not necessarily have to rely on a victim or a victim's testimony. One example, you could do meshing with other government data. There are available employer sanctions provisions within the Migration Act that, to my understanding, are not being used. Specifically a 5-year imprisonment penalty for employing an unlawful worker and exploiting them. And in my understanding, there's never been a conviction under that sanction. So I think there are other opportunities here that we can be employing.
You also made comment on the enforcement efforts between the Fair Work Ombudsman and the Australian Border Force in investigating and responding to instances of non-compliance. Could you expand about the concerns of existing enforcement approaches, particularly by the Border Force, and how these could be improved?
Sorry, I missed just the first few words of your statement or your question. Could you?
In your submission, there's comment there about the enforcement efforts by the Ombudsman and at Border Force in how they investigate and respond to instances of workplace compliance on pages 6 to 7. I was wondering whether you or the other witness might be able to expand about how we could make improvements to the bill to deal with that issue. And maybe whilst you're looking at that, I don't know if you also wanted to touch on the domestic worker issue as well.
Yes, certainly. I'm just trying to find the reference that you're making to enforcement. I've touched on the... I have just briefly touched on the point about underutilization of available penalties, and I think that is a question for us in terms of why, if we're going to expand penalties through this bill, and we certainly support that, I think there remains a question about why we're not using the penalties that are available to us now. Maybe a resourcing issue, I don't know, but I'm
Look, in light of time, maybe just take that one on notice, but did you want to expand on the domestic worker issue?
happy to. As I said before, look, I guess I'll just get to the point here. We think this can be fixed and still provide an exclusion for employers to ensure that they're able to hire tradespersons for, non-ongoing work in the workplace. We're concerned with the exclusion because, as I said before, we've got close to about 10,000 au pairs in Australia. Ms. Hemingway's colleague, Laurie Berg, we cite her report on au pairs in Australia in our submission, and that provides volumes of evidence of the exploitation of au pairs. And as it stands, employers employing temporary visa holders within their home for ongoing work would not be subject to any bans from hiring additional temporary workers.
Now, for AIMS Australia, you raised concerns about the narrow scope of what's considered a migrant worker sanction for the purposes of declaring an employer prohibited. Could you expand on the concerns and suggestions for how the prohibited employer provisions could be amended?
Sure. In our submission, we highlighted the fact that currently, an employer could be subject to multiple compliance notices issued by a Fair Work Ombudsman, but that might not in itself be a reason why they would be considered a prohibitive employer. And that there might be instances where there's a pattern of exploitation, but the requirement that most of these require court orders mean that the scope of who will fall under a prohibited employer will be relatively limited. So that was a proposal that we made, perhaps expanding those provisions.
Okay. For the Migrant Justice Institute, you raised significant concerns about the new offence provisions that are proposed in sections 245 AAA and 245 AAB, and on page 3 of your submission. Could you please expand further? And what amendments do you think that we should consider to be necessary?
Sure, thank you for that question. In terms of just criminalising the conduct under those two provisions, the bill assumes that a problem to be addressed is the use of immigration requirements, and it assumes that just by criminalising that conduct, that alone will deter the conduct and give migrant workers enough confidence to come forward and give evidence against their employers that they've been coerced. And I guess that doesn't, based on our research, accord with the reality of migrant worker experience. Really, there's a much bigger problem in terms of migrants feeling safe enough to come forward and give evidence that this has been their experience. And coupled with that, if there's no detection or enforcement of these provisions, just criminalising the conduct alone is not going to bring about any significant change. Our research has shown that the fear of conduct with immigration authorities is pervasive, as my colleagues have already pointed out. For example, a recent survey of over 6,000 temporary visa holders showed that in COVID lockdowns, nearly a third of them who were reporting financial distress still didn't even seek emergency support because they were worried it might affect their visa. So the fear is really deep. And without providing any additional protections, and as I suggested, we could provide some drafting around that to show that a person's visa, if there is a genuine case of exploitation found or believed to be held, won't affect their visa now or future visa applications. We think that would go some way to addressing our concerns with those sections.
Okay. And look, just finally, for the Migrant Workers Centre, you suggest in your submission that the bill should include greater measures to promote migrant workers' rights in the workplace. What are the gaps in protections, I guess, more broadly, and are you concerned that the government has acted too slowly to implement the recommendations of the Migrant Worker Report from 2019?
Thanks, Senator. I think there's a real gap in the fact that we don't provide information in language to people before their arrival or at the point of arrival. We find, and I'm sure unions do too, that it's like trying to chase smoke when workers are on farms or out in regional areas or even inside metropolitan workplaces. So that's a real gap. There's a real gap, I I guess we would say, of services like ours that do hold in-person sessions to educate migrants about their rights. But really the key thing here is our Lives in Limbo report really showed the I guess, low levels of industrial literacy about very basic industrial terms and conditions, which we can provide to the committee if it doesn't already have. To the second part of your question, I'll try and avoid being too inflammatory here, but there are a number of things inside the Migrant Worker Task Force report that we would be welcoming a bill that dealt with certain recommendations in exclusion or in separation to others. This is probably not one of them. Without wrapping around protections for visas, making more offences for employers isn't, as my colleagues have said, going to stamp out the exploitation. Things that we could do very quickly, we could introduce the National Labour Hire Licensing Scheme. We could introduce national laws to address wage theft in new ways. We could expand, as the task force said, the Fair Entitlements Guarantee to make sure when employers do the wrong thing, it's not migrant workers who pay tax who are missing out. So there are a number of things, and I think that the Migrant Workers Centre position on this is that we need a more wholesome rethink. We need a bigger omnibus of measures to genuinely stamp out exploitation of migrant workers. And at the very core is also a rethink of the visa system that has become too reliant on temporary forms of migration, eschewing those types of permanent residency and permanent migration streams, which we know have better, again from our report, have better outcomes for those migrants that hold those visas.
Mr. Campbell, thank you. And Senator Ciccone, thank you so much for your questions. That brings the time allocated for questions to the Salvation Army, Migrant Worker Centre, Migrant Justice Centre and AIMS Australia to an end. I want to thank you all very much for your submissions, for your time and for your evidence today.
Thanks to the committee.
Thank you very much.
I now welcome representatives of the National Farmers Federation. Thank you so much for taking time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission 17. Please, if you could state for the record your full name and the capacity in which you appear today. And I think we're just getting you up online in your at the table as we speak.
Sorry, my name is...
I'm chairing remotely, so thank you for your understanding. I can't see everything that's happening in the room. So if you could please indicate your name and the capacity in which you are appearing and whether you have any corrections to your submission.
So my name is Ben Rogers. I'm the General Manager for Workplace Relations and Legal Affairs at the National Farmers Federation. Appearing with me is Nathan Panetta, who's a Policy Officer at the National Farmers Federation. And no corrections to our submission, Senator.
Thank you so much, Mr. Rogers and Mr. Panetta. Do you have an opening statement before we go to questions?
I do. As the peak national body representing the whole of the agricultural sector across Australia and a strong supporter of those migration programs which allow overseas workers to work on Australian farms, the NFF thanks the committee for the opportunity to give evidence at this inquiry. The demand for Australia's clean and green agricultural produce is growing both domestically and overseas. Based on its current trajectory, the industry is forecast to reach 84 billion in farm gate output within the next decade, but the NFF believes we can do better. We believe the Australian farm industry can exceed 100 billion by 2030. The goal is achievable but ambitious. In order to make it a reality, we will need a reliable workforce to harvest the produce, shear the sheep and milk the cows. And although there are a number of reasons to prioritise permanent Australian residents for farm work, the experience of many farmers is that not enough of those workers are interested in the jobs. The reality is that the sector is more or less reliant on temporary migrant workers. Depending on the commodity and the season, overseas workers make up anywhere up to 80% of the farm's workforce. This comes as little surprise to us, given that a significant proportion of our labour demands are seasonal, remote and in unskilled and semi-skilled roles. Visa workers tend to be geographically mobile and are able and willing to go to the work. The reliance on overseas workers has obviously created significant problems in these years of the pandemic, with the international travel grinding to a halt. Now, as borders start to open up, we need to do all we reasonably can to ensure the world sees Australia as a welcome destination, not just to visit, but to work. As such, we support the Protecting Migrant Worker Bill as a step in the right direction. However, as our submissions to the committee noted, the bill will only be as effective as its enforcement. While it would be ideal if everyone complied with the law as soon as it was on the books, the reality is that those people who break current laws are, without more, unlikely to comply with new ones. Regulation without enforcement is largely window dressing. We also note in our written submissions that enforcement is unlikely to have a measurable impact if it is exercised in relation to labour hire companies who can simply dissolve into the ether or phoenix to avoid the consequences. It is for this reason we continue our call for national labour hire regulation. Ideally, any licensing or registration process would take into account enforcement outcomes under the terms of this bill. Our submissions also note that given the heavy reliance on migrant labour, the exercise of a discretion to prohibit an employer from engaging overseas workers may have a disproportionately greater impact on farms than on other businesses. This is certainly not to suggest that the power should not be used in relation to farms, just that the power needs to be exercised fairly in a way which is mindful of these factors. Another significant issue in the farm workforce at present is the frequency with which workers in the Pacific labour programs abandon their employment in circumstances where the employers have spent many thousands of dollars to engage them. The Approved Employers Association of Australia estimated in April 2021 that more than 1,000 workers had abandoned their employment in violation of their visas at a cost of well over $1 million. Most of these workers are being induced to break the laws in response to misleading promises made in bad faith by rogue operations. We would strongly encourage the Australian Border Force to use its new powers to pursue those operations. In short, provided they are backed up by rational enforcement, the NFF supports the laws which will address problems with current labour migration arrangements. To that end, we encourage the committee to endorse the passage of the Migration Amendment Bill. Thank you.
Thank you very much, Mr. Rogers. I'm going to start off with a couple of questions. From the NFF's perspective, how important are migrant workers in agricultural businesses and Australian farms?
I think it would be difficult to overstate the importance, Senator. As I said in my opening statement, we are more or less dependent on migrant workers, particularly for those unskilled jobs, particularly for seasonal work. The last 2 to 3 years, while the COVID pandemic has shut down the borders, has had a crippling impact on farms and made the situation quite desperate. We've seen, fruit rotting on the trees. We've seen grains unable to be harvested. It's been a difficult 2 to 3 years. It's almost impossible to overstate how important migrant workers are to the Australian agricultural sector.
And what role does the NFF play in ensuring that migrant workers are employed fairly and that there is no exploitation in terms of their work conditions and the circumstances which may arise when exploitation does occur?
We are obviously great supporters of programs like the Fair Farms program, which is a certification program which the federal government supports, which enables growers to demonstrate best practice. We encourage the retailers to use reliable supply chain reporting requirements. We call out mistreatment when we hear it. We decry it. We encourage workers to come forward to contact the authorities. We encourage the use of programs which are controlled, like the seasonal worker program, which has recently seen a bit of unfortunate press, but is generally should be a relatively highly regulated program and ensure these sorts of things don't happen. And also things like the Harvest Trail service, which enables workers to join up with employers who demonstrate best practice.
Mr. Rogers, I'm not sure how much evidence you've heard this morning, but there's been a fair bit of opposition raised in relation to aspects of the bill. What do you say in response to the concerns which have been raised?
Sorry, the only concerns that I've heard were those of the previous witness, and they expressed concerns that migrant workers who've been mistreated might not feel free to speak out and report to the authorities because they think that might have a bad outcome for them in terms of future visa applications or the current visa arrangements. Mm-hmm. And again, our point is that this bill needs to be enforceable. It needs to be enforced, it needs to be enforceable. It's not going to be enforceable if migrant workers don't speak out when they are being mistreated. So as a general statement, we would support those sorts of concerns. We would suggest that mechanisms be built into the bill which enable those people to speak out and speak freely where they have been mistreated.
And so what sort of mechanisms are you suggesting?
There are people who are better qualified to speak on that, but I mean, I think some of the previous witnesses were talking about building in mechanisms whereby there can't be negative outcomes. Or the decision makers can't have reference to the fact they may have been in breach of their visa conditions, if in the circumstances they were in breach of their visa conditions because of sort of illegal activity of the employer. Those sorts of things we would encourage and support.
And how, from your perspective, from the National Farmers Federation, how efficiently do you believe rogue employers or other employers which have engaged in exploitation of workers, how efficiently are they currently being held to account? And what do you think the difference will be once, assuming that this bill is passed with these additional powers?
How efficiently? Well, I mean, there's still talk of mistreatment. There's still talk of exploitation. So any claims of that nature are just abhorrent. So how effective they are, not effective enough, I guess, is the answer that I would make. But I don't think that's for a lack of effort. I mean, there has been a concerted campaign on the part of the Fair Work Ombudsman to target mistreatment within the horticulture sector, education and enforcement activities. So there has been a lot of energy in that regard. In terms of Australian Border Force, we have some misgivings about whether or not they are being as effective as they could be. A lot of our workers obviously are remotely located, a lot of our employers are remotely located, so they can be difficult to identify. And there have been some, sort of operational efforts to target those remote locations, but I think it's fair to say more could be done. I'm not unsympathetic to the fact that some of this stuff can be difficult to prosecute. I mean, evidence can be difficult to come by. If our workers are afraid to come forward, then it's going to be difficult to enforce or prosecute misconduct. So changes like the compliance notices seem like a really good idea to me, because obviously a breach of the compliance notice is something that Border Force issuing a compliance notice is something that Border Force can do without going through those sort of court processes. So that should make the whole procedure a lot easier. So, I mean, it's an open question. It remains to be seen. But our hope is that once these changes come into effect, there will be a greater enforcement and a crackdown on these sorts of practices.
I just wanted to reference a number of the measures that the government has implemented. They include establishing an interagency group chaired by the Attorney General's Department to maintain whole of government oversight of work to implement the recommendations in relation to protecting migrant workers. There's also initiatives to enhance migrant workers' awareness of workplace rights and entitlements. There are also issues of coverage of migrant workers under the Fair Work Act, and there is a JobMaker compliance and enforcement working group. There's improved and expanded education materials for migrant workers, new resources for the Fair Work Ombudsman, and other related issues like a central register of data and research to inform future policy development. So there's a whole range of work being undertaken to provide the supporting structures to better protect migrant workers and to combat any exploitation. Do you have any particular comment in relation to those measures?
Well, there are quite a range of measures, so it sounds quite impressive, but the reality is that we are still hearing these allegations of mistreatment and exploitation. So, whether or not the degree of exploitation, underpayment, mistreatment has decreased as a result of those measures, I don't know the answer to that question. I don't know if any research has been done into it. But as long as we're still hearing complaints, more needs to be done.
So what can the NFF do in relation to these complaints? Can you also take more action in relation to your membership and those who you represent in the agricultural industry?
Yeah, well, I mean, as I say, we can promote things like the Fair Farms Initiative. We can encourage people to speak out when they are being mistreated. There's a concerning trend of, it would seem to us, going to the press or going to other bodies to complain about mistreatment rather than going to the actual regulator. So more encouragement in that regard, and certainly we're doing that. We are trying to drive a dedicated ag visa, which, despite what you might hear in the press, would have really robust protection mechanisms built into it. It would also be a visa which would enable workers to leave an employer if it's designed the way that we intend or we hope, would allow workers to leave an employer if they're being mistreated. That's something that we call portability. There'd obviously be requirements around that in terms of reporting to the department and so forth. But there wouldn't be these sorts of claims of workers being tied to an employer who's not doing the right thing by them and who are afraid to speak out. So we think that would be a step in the right direction. But the most that we can do really is just take a stand publicly and say this is not acceptable. We don't stand by it. We decry it, and when we hear about it, we'll speak out.
So you're taking this issue very seriously. How seriously do you think this has been taken by those who you represent?
Those who we represent, so our membership, I think it's been taken very seriously. I think the people who take a stand on this stuff will take it very seriously. The people who do the wrong thing will continue to do the wrong thing, which is why we encourage enforcement and cracking down on them. But I think within the industry itself, it's taken extremely seriously. If you can't pass a press report without an industry body saying this is unacceptable. We can't allow this, and we're going to do what we can to stamp it out. I mean, Grocom is a good example, who took on board this issue themselves and then started the Fair Farms initiative off their own bat, which is, and that's a program which is developing and growing again with government support, but they took that initiative on their own because they recognised how serious and important this was.
Mr. Panetta, do you have anything to add to Mr. Rogers' responses?
No, thanks, Senator.
Okay, thank you. All right, well, that concludes my questions. I'll now hand over to Senator Ciccone.
Thank you, Chair, and good to see Mr. Rogers and Mr. Panetta. Just to follow on from the last question, so in terms of the exploitation and the role of the industry, as you sort of just touched on earlier, but what they're trying to do to address the issue, how is the industry more broadly trying to address the issues of the underpayments, of wage theft, of exploitation, apart from this Fair Farms initiative? What is that the NFF and its members are trying to do to actually tackle the issue once and for all?
Well, I mean, we try to promote education enforcement. When we talk to these sorts of bodies, we talk to the Fair Work Ombudsman, we sit on their committees, which try to help them, guide them in how they can better exercise enforcement. We engage with the departments. I mean, we are a national representative body. We're not a police officer, so we can't go out there and actually crack down on the farms ourselves. The best that we can do, as I say, is to speak out and try to provide leadership and demonstrate the way these things should go and support these sorts of programs like Fair Farms, like the dedicated ag visa, like the horticulture showcase, which the Fair Work Ombudsman is.
How have you found the role of the Ombudsman in terms of actually tackling the issue of exploitation?
Well, my sense is that they take it very seriously, and as I've said, there are still certainly allegations, and I would dare say that there's a lot of substance to some of those allegations. So as long as there's still exploitation out there, there's an issue, and so more needs to be done. But I know that my sense is that the Fair Work Ombudsman is taking these sorts of things very, very seriously, and that's why they're running things like the Horticulture Showcase, why they've run the Harvest Trail program, why they've published reports on the issue. My sense is they're taking it very seriously. Are they well resourced enough to do everything they need to do? I don't know, perhaps not. But my sense is they're taking it very seriously.
I guess it must be frustrating, especially in the last decade, we've seen about half a dozen different inquiries or reports come out about the industry and some employers doing the wrong thing and bringing the whole industry down. Are you frustrated that the government hasn't done enough, and maybe that some of these issues that we address in this bill could have been done some years ago?
I think it's fair to say yes. I mean, a lot of this stuff, yeah, if it could have been taken into account previously, we have been dealing with this issue for a long, long time. So, if more can be done, more should be done. And this is an example of what could be done.
Yeah.
I mean, there is frustration, not just for myself, but within the industry of the lack of movement on national labour hire licensing or some sort of national labour hire regulation. That was first raised in the Fells report. It was raised again in the National Agricultural Workforce Strategy. It's something that needs to happen. At this point, as far as we can tell, there's just been talk.
Which is something that I think the NFF and its members have been advocating for some time.
Yes.
I guess you'd also be frustrated, or fair to say you have been frustrated in the lack of an agriculture visa, which was promised to your community some years ago. I think as far back as 2018. Are you frustrated to see some of the blame game of recent times between the Ag Minister and the Minister for Foreign Affairs?
I'm not inclined to get involved in those sorts of discussions, Senator. I mean, they have their own they have their own opinions on things and the way they should operate.
And I raise in the context that, I mean, the Ag Minister promised that the scheme, the program, would be up and running by the end of Christmas or the end of last year. And again, we still have a situation where a number of migrant workers are losing out. A number of migrant workers are not be able to have, I guess, the ability and the opportunities to come and work in Australia. But surely you must be frustrated the government's handling of these type of issues.
Well, I mean, we have never encouraged the government to rush an ag visa through. I mean, yeah, we want it as soon as possible, and we're encouraged by the way it's been prioritised by the government, and we have been in close contact and with Department of Foreign Affairs and Trade, who are developing and designing the visa, but it's a complicated thing. So the sooner it comes on, the better. Do we wish it had been up and running by Christmas? Absolutely. But at the end of the day, it's important to get it right. We don't see it as a short-term solution. It is a long-term structural change to the way that industry addresses its labour needs. It shouldn't be rushed through. We need to get it right.
Do you think the scheme should be capped?
Ideally not. I mean, demand-driven is what we've always told it's going to be. But on the other hand, we understand that it needs to be introduced in a controlled way so that we can make sure that we get all the settings right. So if that cap is a level of control and a way of assuring that it's done properly, then that, so be it.
So that's something you would welcome?
I'm not saying we would welcome it. It's for people who are introducing the scheme, and yeah, a controlled sort of introduction of the scheme makes sense to us.
You raise concerns that the bill disproportionately affects farmers in the ag sector, I think on page 7 of your submission. Could you please expand on the concerns and how your concerns may be addressed in the bill?
Well, it just goes back to our point that we are very reliant on migrant labour. And so a business which, and it may be fair enough, let me be clear on that, but a farm business which loses access to migrant labour may be a business that can't actually operate any longer. So if they deserve to have their business shut down as a consequence of whatever they've done, then so be it. But that kind of consequence, that kind of result needs the decision maker, the minister or his delegate, will just need to bear that in mind, as opposed to, for example, perhaps a restaurant in Sydney. And I don't represent that sector, but I can imagine it's a lot easier for them to find workers. Although they might use migrant labour, they might be able to, to rely on other sources of labour.
You also raise concerns about the, I guess, the risk of labour hire companies, and I guess what they're doing to the reputation of the industry, especially when they're subject to prohibitive sanctioned phoenixing, I think on page 7 of your report, of your submission. Could you please expand on that point for me and the benefit of the committee?
The concern and what we hear about is that labour hire companies who get found out for doing the wrong thing. I mean, there are labour hire companies, again, this is what I hear, that operate out of a van with a mobile phone. They are very, very fly-by-night type operations, and it's very little loss to them if they shut down that operation, close down the ABN or the ACN and shut up and start up another one. The sanction which is imposed has been imposed on that business, on that corporation. So if they can shut that corporation down and open up a new corporation, then the consequences for them are fairly insignificant.
So what's the impact of, I guess, the lack of having a labour hire scheme?
Well, our hope is that a proper labour hire scheme, and I need to qualify it in that way, would mean that those sorts of operators, the ones with the white van and the phone, the ones that can phoenix, would be shifted out of the market. They wouldn't be able to operate, and the consequences for using that type of operation, that type of unlicensed operation, would be such that you just wouldn't use them any longer.
And given that a number of states, as you know, have their own scheme now, is there having a lack of a national scheme is causing issues for your members?
We hear that there's a lack of consistency, and so if a farming business operates on the borders or operates in different states, it's difficult for them to actually coordinate their needs and set up their business so that they can comply with the schemes. So I would say yes is the answer to that. And ideally, if we're going to have labour hire licensing or labour hire regulation, whatever form it takes, which is nationwide, then it just makes sense that the nationwide scheme should be the same from state to state and jurisdiction to jurisdiction.
And also, would you like to see more robust anti-phoenixing provisions included? Phoenixing.
It's not something I've given a lot of thought through, but that makes a lot of sense, yeah.
I mean, again, on your submission you talk about that on page 7, so I was just interested to see if you'd like to see more of those provisions built into the bill.
Again, I'd need to think it through in detail, but in principle, it doesn't sound like a bad idea. I haven't thought it through at length, but yeah, it's a concern.
Are there any other broader reforms that you'd like to see the government implement?
Well, we've talked about the ag visa, so we'd like to see that come in. There is a streamlining process to the seasonal worker program that's being underway right now, so we're curious to see how that rolls out. But yeah, I mean, labour hire licensing, proper resourcing to the regulators, they're the key ones for us, the ag visa.
I mean, how do you see the ag visa addressing some of these exploitation issues? That's been the main criticism of the visa. It sort of lacks the protections that I think under the palm you would actually receive.
But it doesn't. This is the misconception that's out there. It would be very similar to the palm in terms of the way that those protections. There would be an approved employer type arrangement. So the employer would sign a deed. There would be a whole raft of sort of regulatory oversight. The department would monitor it very closely. The key difference for me is that the employee would be able to leave an employer if they're not being treated right, or indeed if they're not being paid the way they think they should be paid, or what they could earn. There would be what we've called portability, which is that's sort of limited. They can't go and work anywhere, but they can, and they have to sort of engage with the department and make sure the department knows where they are and what they're doing at all times. But they would have the opportunity to depart an employer who's not treating them correctly.
But isn't the case there's no training?
Senator Ciccone, sorry, Senator Ciccone, can I just ask you to make this the last question because we're over time?
Isn't it the case that there's no, I guess, English requirements, no skill testing, no visa-specific minimum salary requirements?
That's not right. Visa? I mean, again, DFAT would need to answer you, and I'm concerned about discussing things that I've been sworn to confidence about, but no, that's not correct, Senator.
Confidence by the government?
Sorry?
Confidence as in
terms of our engagements with the department and how that might compromise some of the negotiations, particularly they're having with the foreign nations, the sending nations. Okay. But no, there would be minimum. There would.
When do you expect the visa will be up and running then, from your point of view?
Well, our hope as soon as possible. Not confident saying
Senator
anything more
Ciccone, we will need to
so what was that?
questions with that.
Not confident saying anything more than that. Sorry.
All right. Thank you.
Sorry, it's a bit difficult when I'm attending remotely. Thank you very much, Senator Ciccone. I'll now just hand over briefly to Senator Van.
Thank you, Chair. Mr. Rogers, thank you. You mentioned the Fair Farms initiative. Can you tell us a little bit more about that, particularly the use by, I think you mentioned Woolworths as one of them. But what I'm keen to hear is how these sort of corporate schemes where you've got moral suasion or market mechanisms can help with the enforcement of legislation, because we all know it doesn't matter what legislation is in place, people can and will breach it. So a mechanism like this is a strong initiative. Can you talk a bit more about that?
Yeah, so the Fair Farms is a certification program whereby an employer goes through a robust audit process. There's an audit criteria which looks at their WHS, their IR, their human resources and management and training programs, inductions, all the rest of it. They go through that audit process, and once they pass the audit process, then they can say they've got Fair Farms certification. If they don't pass the process, then there are training options available to them, so they can train and learn about what they could have done better or should be doing more of. That's Fair Farms. There's also SEDEX, which is not a program I'm intimately familiar with, but I understand is very similar. And there are at Global Gap, there are a couple of certification programs. I mentioned Fair Farms because it is the one that's been developed by the industry in response to this particular issue,
sure.
Particularly in the horticulture.
And is it being taken up by the end users, the supermarkets and markets and the like?
Yes.
Is there more that you or we could do to encourage that take-up?
Yeah, so the big retailers, as I understand it, your Coles and your Woolworths, they require farms to demonstrate that they have one of these types of certification processes before they can supply to those big retailers.
So that's a blanket requirement?
I'm not familiar with the details, Senator. I'm happy to take that on notice, but yeah, as a general statement, I think that's correct.
If you would, and I might make some inquiries of the supermarkets and the other chains, etc.
Yes, well, I'm happy to do that, Senator.
Thank you, Chair.
Thank you very much, Senator Van, and a thank you to the NFF for your time and for giving evidence today. That concludes the committee's examination of matters concerning the bill with the NFF. We again very much appreciate your submission and your commitment to our work in relation to this bill.
Thank you, Senator.
We're going to move to the lunch break. We will suspend and turn in. Many thanks. And I welcome the Australian Fresh Produce Alliance. Thank you so much for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submission as submission number 10. For the Hansard record, could you please state your full name and the capacity in which you appear, including whether you wish to make any correction to your submission?
Michael David Rogers, CEO, Australian Fresh Produce Alliance, and no corrections to our submission. Thank you.
I'm sorry, I'm just having a little bit of issue. Apologies, I've just got my audio down. I should be able to hear you loud and clear. Would you like to make a brief opening statement of no longer than 3 minutes before we go to questions?
Yes, I will. Thank you, Chair.
Thanks, Mr. Rogers.
Thank you. Thanks for the opportunity to appear before the committee today. From our perspective, the objective for our industry is to develop a productive and returning workforce. Fruit and vegetables are highly variable crops that are subject to the effects of weather and nature more broadly. From year to year, production may increase or decrease, start and finish at different times, and be affected by rain, hail, drought, or wind. Harvest times are often relatively short periods of time, and crops are usually hand-picked. This means that there is significant demand for people to harvest and pack fruit and vegetables for relatively short periods of time across the length and breadth of Australia. This seasonality of the crops, coupled with the production variability, creates a challenge for all horticulture production, and the solution is the development of a long-term, productive and returning workforce to harvest those fruit and vegetables. From our perspective, this means dedicated workforce programs that align the needs of industry with strong standards for people working in our industry. In the past, Australians have worked in our industry. However, in the last 20 years, the number of Australians has declined at the same time that the national unemployment rate has also declined. Our data has shown that the inquiries for work from Australians declines very significantly, with anything more than half an hour travel time from a major city, and most of our farms require travel, typically more than half an hour. Our industry has become increasingly reliant on visa holders, and this is not unique to Australia. For example, New Zealand has similar challenges and implemented a Pacific program for harvest workers before Australia. Other countries have similar programs in place. Critical to the success of visa programs is alignment between the needs of employers and the standards and conditions that support those visa holders. The breadth of Australia's visa framework reflects this. The Pacific Australia Labour Mobility Program is a key pillar of the development of a productive and returning workforce for our industry. The proposed agriculture visa will be another key element for the fresh produce industry, which complements the Pacific programs by offering additional flexibility while maintaining standards. We hope to see an agreement reached with an ASEAN country soon. There are ongoing media reports about the mistreatment of people in our industry. So what are we doing about it and what can be done? High standards which are enforceable provide a way forward. The skilled visa arrangements, the Pacific program, the agriculture visa will have standards and conditions that can be enforced. We, along with others in industry, have been reporting employers, usually dodgy contractors, who are employing people in breach of their visa conditions and otherwise treating people poorly. We know that the Department of Home Affairs, the Fair Work Ombudsman, the Queensland and Victoria Labour Hire Licensing Authorities are actioning these reports, but we need regulators to continue to prioritise these reports and address non-compliance. Given the delays in implementing national labour hire licensing, we wrote to state and territory ministers just prior to Christmas about the need for a nationally consistent labour hire regulation across the country. Queensland and Victoria have already implemented labour hire licensing arrangements, but we need all jurisdictions to implement regulations. We have received 4 responses so far, and all are supportive and outline the work on a nationally consistent approach. Importantly, industry is taking these issues seriously. The AFBA position that if any employer is intentionally doing the wrong thing, they need to leave the industry. Good employers intent on supporting people and paying them well are being undermined and undercut commercially by employers doing the wrong thing. The AFBA supports the proposed amendments to the Migration Act, which will protect migrant workers and provide more significant penalties and measures to address employers who are intentionally doing the wrong thing. Thank you, Chair.
Mr. Rogers, thank you very much. I'm going to hand over firstly to Senator Tony.
Thank you.
Thanks a lot, Chair. And hello, Mr. Rogers. Good to see you again.
Likewise, Senator.
Can I just start off? I just note in your submission that you support the bill and its intent, but you also have concerns around the visa entitlement verification online system, specifically about how the requirement to use this system may interact with labour hire arrangements. Could you please just articulate those concerns in a bit more detail for us?
I think what we were going to, Senator, was to the heart of the responsibility to protecting those workers. So, for example, if a visa holder is employed by a labour hire company, which may be an approved employer under a specific program, that the responsibility for the visa check is clear and that there's not a misunderstanding on where that responsibility lay or lies. So specifically, with some unscrupulous operators, they may assure farmers that they have conducted the VIVO check when in fact they have not. And it is just ensuring, I think what we're going to there is ensuring that the implementation of the proposed measure was clear, or it will be clear, and ensure that the check is done and that there isn't any misunderstanding on whose responsibility it is.
Yeah. I note page 6 of your submission, you argue that the care must be taken to quote to ensure that the host employers in a labour hire arrangement are able and encouraged to also determine, verify or spot check the working rights of temporary visa holders on their property, end of quote. Were there any sort of practical examples or thoughts you might have about how we achieve that?
You know, it's something that needs further consideration. I think what we were going to is it might not necessarily be the same number of workers or the same individuals on a farm day to day. There may be some change, and it really goes to the practical measures. And I think it goes to enforcement around what is the expectation and how might employers do that. I think for mine, there's been conversations in industry around if you have a contractor, a plumber or a tradesman on your property, that you have legal obligations to those contractors to ensure that they are inducted, et cetera, et cetera. So from our perspective, depending where the bill lands, it's making clear where the responsibility is, which should rest with the employer, but the host property, if you like, will also need to meet an obligation. And I think making that clear, either in the bill or probably more so in terms of enforcement and the communication of that, would go a long way to avoiding confusion. So happy to explore separately, Senator, but it's a matter of implementation from our perspective.
Yeah, and on the issue of enforcement, are you concerned that power to issue prohibition notices rests with the minister or their delegate as opposed to the Fair Work Ombudsman or some other government agency?
Senator, I think, you know, what we are working with governments on is that there are a number of regulators with a number of different powers. And from what I understand and the way this bill is written and the Migration Act, that it would sensibly sit with the minister. It is quite a serious decision to be taken. And if it's consistent with broader government approach and legislation of this kind, from our perspective, we think it appropriate that it would rest with the minister because it is a significant decision, and it also, you know, protects the independence, if you like, of the Fair Work Ombudsman to undertake that broader regulatory approach. So they would be our reflections, but matter for Parliament on how these types of things are implemented more broadly.
Yeah, and I guess how do you assess the performance of certain agencies like the Fair Work Ombudsman in tackling migrant workers from exploitation?
Yeah, Senator, in terms of the responsibility on tackling these issues, I think everyone has to bear responsibility. And you know, we've certainly reported dodgy contractors to the Queensland and Victorian labour hire licensing authorities, and they at that point were the most appropriate and had the powers to assess the allegations which were being made against their powers, and then work with the Fair Work Ombudsman to do that. So I suppose what I'm pointing to is the Fair Work Ombudsman has a clear role and responsibility, but the Department of Home Affairs has also a range of powers with regard to visas. The states increasingly, hopefully, will have powers with regard to labour hire licensing. So it is a very difficult thing to measure. And, you know, regulators aren't responsible for just one element of any particular, or one industry, if you like. And we have been calling for increased funding, which I think the government has implemented in MyEFO as part of the agriculture visa funding, which we're very strongly supportive of. But also we've had conversations with retailers, and we've briefed retailers on issues and working with them on their ethical sourcing initiatives and arrangements to ensure that that the whole system, if you like, is working towards excluding unscrupulous operators from the system. That more and more that there is not a way for them to continue to operate. So we would certainly support additional funding to the Fair Work Ombudsman, Department of Home Affairs, and others around these issues. But they are significant issues, and I think this bill again goes some way to strengthening the consequences for someone doing the wrong thing, and gives the regulators more power. So,
are there any recommendations from the Migrant Workers report back in 2019 that you'd like to see incorporated into this bill?
Look, Senator, from our perspective, I understand that you've heard evidence today from a number of parties which say that more can be done, and we'd certainly support that in the broadest sense. What I'd say in terms of what we're considering today is that what's been proposed in the bill and what's proposed to be taken forward is a very good step, and that we support the bill going forward as it is, and implementing it in a way that demonstrates improvement, creates change, and that's not to say that further improvements can't be made. From our perspective, we support this step-by-step approach of improving things. Sometimes trying to fix everything all at once becomes quite difficult to do. So I hope that answers your question.
Yeah.
Don't for 1 second suggest that more can't be done, but we think that the bill is a good step.
Yeah, and I think I do note your support also for a national labour hire scheme as well too.
Yes.
In terms of your membership and the, no doubt the use of the PALM, or seasonal worker program, the PLS previously as they were known, how do you see this bill interacting with the safeguards with those schemes?
Yeah, so I think from our perspective, there has been a very significant increase in the number of people employed under the PALM scheme, particularly during COVID, which is a very positive development. There are a range of difficult situations in the Pacific program where visa holders haven't been able to go home, and there's a range of issues that government, industry, and the sending countries need to work through. I think this bill goes to the issue where someone intentionally approaches Pacific workers, for example, and encourage them to work in breach of their visa conditions. This bill increases the penalties and discourages people from doing that, and provides real consequence, and demonstrates that you simply can't do that. Otherwise, you'd be a prohibited employer, or whatever relevant measures may apply. So from our perspective, it provides more teeth, if you like, to the broader enforcement around visa arrangements, including the Pacific.
I note on your page 3 to 4 of your submission, you comment on the impact of COVID and on the employment of a number of workers in the industry, particularly the working holiday makers, as well as the reliance on the PALM. Just was hoping you might be able to expand a bit further on the shift from temporary migration programs, and is such a shift beneficial to the industry or its workers, or is that something, once we get out of this pandemic, that you'd see that the industry going back to its old ways of doing business?
Yeah, certainly. I think what we found through COVID, and we're looking to embed that as part of our approach to a productive returning workforce, is that workers which return year on year to the same farm or the same employer often build strong relationships with that employer, are well supported, are familiar with the work, they have good earnings, and they're supported. And so what we're finding is that where workers return year on year to the same good employer, that there are great outcomes for both the employer and the workers. And that's something that we're really very keen to support and continue over the long term. I think we have to acknowledge that the number of backpackers or working holiday makers declined significantly and obviously felt very acutely by the tourism sector and others, but also had a significant effect on our industry. What we're working on as a sector is continuing to focus on these are programs and arrangements which build a productive and returning workforce. And a working holiday maker performs a role, and I expect that there will be opportunities for working holiday makers for a long time to come, but it will probably, hopefully, be reduced. And because those workers, you train them, they're here for a holiday, they might go back to their home country and start their new career. And so there's not that ongoing relationship. So to answer your question, yes, working holidays were declining. The Pacific programs have been running for about 10 years, and we have been building into those programs, and I think COVID has accelerated that. And from our perspective, that's a very positive development, and we look forward to that continuing.
Thank you, Mr. Rogers. Chair, I'm happy to hand back to you if you've got some questions.
Thank you very much, Senator Kiney. Mr. Rogers, could you just explain in summary the reasons that you support this bill?
The reasons that we support this bill is that it will provide stronger consequences for people doing the wrong thing, and it will protect good employers from being undermined by those same workers. So we're strongly supportive of that bill because industry is fed up by the small number of poor employers who seem to be intent on doing the wrong thing. So we're, Chair, yes, we're strongly supportive, and I hope that summarises our position succinctly enough.
To what extent do you as a sector rely on migrant workers, and what is the, I guess, the anxiety about ensuring that you can secure as many migrant workers as possible, and also, of course, engage them in a manner which is fair, which is in accordance with Australian law, and which, of course, combats any form of exploitation?
Yes, so because of the nature of our work in horticulture, it being short-term and often people have to move to follow the work, the harvest trail, as we know, which has some negative implications for some people, but it's a reality for our sector that we aren't in one place for 12 months of the year. So migrant workers are very important to our sector, and we expect will be continue to be very important for our sector. In terms of the number of workers, I think the perspective in the industry is changing on the number of workers. If we focus on a productive and returning workforce, and that is training people, supporting them, ensuring that they are comfortable and able to perform the work, the productivity actually increases and they're more comfortable. Some of the challenges with working holiday makers were they would work for a relatively short period of time and they weren't familiar with the work. And so what we're seeing is that those people that are returning, we're seeing a stabilisation in the numbers. It's not an ever-increasing number of people, which is good for the employer. It's good for occupational health and safety. It's good for earnings, and it's good for the workers. So what we're seeing is a continued development of the workforce, continued change and adjustment, and why we support these measures is, again, these measures support the direction of industry of moving away from just large numbers, very large numbers of people at different times, to people who are effectively familiar with the work, enjoy the work, and supported to do that. And that works for both the worker and the employer. So, again, Chair, I hope that answers your question.
Thanks, Mr. Rogers. What do you say to those witnesses today who've expressed concerns about migrant workers not wanting to speak out about exploitation because of the fear that they will simply just be sacked, penalised, and then lose their visa? What do you say to those concerns?
I understand that people may have those concerns. In our experience, particularly over the last couple of years, government agencies do go a long way to try and create an environment where people can report anonymously. And I think what we need to do is encourage more reporting, because more reporting from workers and from other employees and that sort of thing, because it gives more information for the regulators to consider. And very sensitive issues, obviously, but it's important that workers do report, and if not to a regulator, a Pacific worker can report into the PALM scheme or to the High Commission. Some of the challenges that we have at the moment is the retailers have reporting mechanisms, the regulators have reporting mechanisms, the unions take complaints, but we need those allegations to be referred to a regulator to be investigated. And sometimes there's a mismatch between that. And if the outcome that we're seeking is a reduction in poor employers, then we need to report. So I think maybe we need to consider further how workers might report where they are genuinely concerned. But again, the employers that we have raised issues with, if there's a rumour or something circulating, people are focused on addressing the issue. If it's genuinely poor employers who then threaten the workers, all the more reason to take those even more serious allegations and prohibit, the employer or something of that nature under this bill. So we have to find ways to move forward, support the workers to report, and ensure that we are removing poor employers. But if we don't report, how do we do that?
So with respect to your members, what do you do to ensure that they are fully aware of their requirements under the law, the need to be compliant at all times, and the need to take this issue very, very seriously?
Yeah, so we have a number of arrangements in place. We're a relatively new organisation. 3 years ago we formed. We made public commitments around that each member would support their workers and pay them ethically and legally and those sorts of things. And that was a public commitment and demonstration of the commitment of members to move forward. We have a human resources reference group which comes together and talks about the issues broadly in employing in our sector. It considers information, new developments, issues such as this bill, piece rates, all those sorts of things. So we're actively involved. Agriculture visa, Pacific, changes to the Pacific programs. So we are actively engaged with the policy development process and the regulatory arrangements, involved in the Fair Work Ombudsman Horticulture Reference Group when that was running, and understand it will meet again soon. So as a membership, we're also doing that, and our members also work with 1,500 grower suppliers. So they're sharing that information. Some of our members are making arrangements whereby their growers can be registered on the SEDEX platform as part of a supply arrangement. So there's a whole range of measures. It would be unfair to call out any single measure, but I hope that gives you a sense of the proactive way in which industry is seeking to work on a whole range of issues to address the problems and move our industry forward.
And Mr. Rogers, just finally, what would be your message to rogue employers who are or who intend to exploit migrant workers?
It's time to leave the industry. It always has been, but there is going to be no room left. There's commercial arrangements. The legislation is getting stronger, and the enforcement will continue to get stronger, and there's simply no way for them to operate anymore. So shut down the business and go and do something else.
Mr. Rogers, thank you very much for your time and for your evidence today.
Thank you, Chair.
Thank you so much. I'd now like to welcome representatives of the Australian Chamber of Commerce and Industry and the Australian Industry Group. And for anyone listening today who is going to give evidence, we are moving our program forward a little in time. We are now endeavouring to try and finish by 5 o'clock this afternoon. Thank you so much for your time in giving evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. The committee has received your submissions as submissions 16 and 18 respectively. For the Hansard record, could you please state your name and the capacity in which you appear, including whether you wish to make any correction to your submission?
Thank you, Chair. Scott Barclam. I'm Director Workplace Relations with the Australian Chamber of Commerce and Industry, and we don't seek any changes to our submission.
Thanks, Mr. Barclam.
Jenny Lambert, also from the Australian Chamber of Commerce and Industry. I'm the Director of Economics, Employment and Skills. Thank you.
Thanks, Ms. Lambert.
Thank you, Chair. Nicola Street, appearing for the Australian Industry Group, National Manager of Workplace Relations Policy, and we do not seek to make changes to our submission. Thank you.
Thank you so much. Well, now, if you're invited to make an opening statement of no more than 3 minutes, would anyone like to make an opening statement?
Thank you, Chair. I might go first, and we thank the committee for the opportunity to appear today.
Thanks, Mr. Barclam.
ACCI recognises the intention of the government to give effect to the various recommendations of the Migrant Worker Task Force to further bolster the integrity of our migration system. ACCI appreciated in particular the manner in which these changes were developed. The exposure draft process worked well and improved the bill prior to its introduction. Our guiding principles or expectations as employers in approaching this bill are threefold: ensuring the integrity of the migration system, improving perceptions of the system, and in particular employer confidence to employ migrants, and balanced and practical change that adds to or does not detract from the accessibility of visa work. We stress the particular importance of employers being confident to use the migration system and to employ non-citizens. It is critical that we approach the challenges Australia faces with a labour migration system that works and that employers and migrant employees can have confidence to use. At paragraph 4 of our submission, we give a sense of the really pressing challenges of early 22, skills shortages, navigating uncertainty and recovery in particular. These challenges underscore the essential role Australia needs migrant workers to play, now and in the future. ACCI makes 13 recommendations for practical changes to the bill, within an overall position that the changes in the bill are generally well executed and balanced. We commend our recommendations to you, highlighting 3 in particular. The first is an appropriately precise approach to any extension of criminality to reckless conduct. That's our recommendation 2. The second is ensuring obligations for VIVO checking are based on reasonableness, our recommendation 4. And the third is a basket of recommendations, 6, 7 and 8, also in relation to VIVO. And they address the clarity and consistency in any class-based requirements to use VIVO, which have the effect of divorcing additional requirements upon employers from actual demonstrated non-compliance by that employing entity. We see this as an area requiring particular caution and clarity. With that, Chair, thank you again for the opportunity to appear. We look forward to Senators' questions in due course.
Thank you very much, Mr. Barclam. Any other opening statements?
Yes, thank you, Chair. AR Group thanks the committee for the opportunity to appear this afternoon in relation to the Protecting Migrant Workers Amendment Bill. We acknowledge the bill's broad purpose to strengthen migration laws to reduce opportunity for the unscrupulous exploitation of migrant workers. To this end, it is important the bill appropriately targets exploitation of migrant workers rather than unintentional non-compliance with workplace laws. AR Group has identified a number of key issues with some of the bill's provisions, and we have suggested some constructive amendments to remedy these while still seeking to preserve the bill's intent. These are concerned with the framing of the two new offences at sections 245 AAA and 245 AAB and the operation of the prohibited employer sanctions. In respect of the offence at 245 AAA, we consider this to be cast in terms that are uncertain in its adoption of broad concepts of coercion and undue pressure, whilst departing from the Bill's existing defence arrangements of reasonable steps, and we've suggested an amendment to remedy that. In respect of 2545 AAB, we have concerns with how that offence has been drafted in respect of ensuring the offence does not inadvertently capture employers who seek or engage in a work arrangement to comply with visa requirements. Again, this has been addressed in our submission. In respect of the prohibited employer provisions, we are concerned that there is no distinction in the bill with respect to a wage-related contravention that is a serious contravention and a ordinary contravention, and this distinction is made in the Fair Work Act. And we would seek that the serious contravention provisions in the Fair Work Act be identified as the relevant contraventions that may give rise to a prohibited employer declaration. Finally, we've some concerns about the ability of the prohibited employer provisions to be used retrospectively over what looks like an undefined period of time, and we would suggest that this be amended to capture employer conduct occurring after the commencement of the amendments. AR Group welcomes the use of the compliance notices and enforceable undertaking provisions, and we consider these to be effective measures of intervention and enforcement in avoiding the need for formal prosecution and achieving compliance. Overall, Chair, AR Group is supportive of the intent of the bill, and we make these suggested amendments as part of a constructive engagement process with the making of this bill, and we would be happy to answer any questions from the committee. Thank you.
Thank you very much, Ms Street. I will now go to questions from senators, and we'll give the call to Senator Ciccone.
Thank you very much, Chair. Look, just a couple of questions to both ACCI and AI Group. You suggest several amendments to the bill. Which of these do you consider essential in order to improve the effectiveness of this bill? Are there any particular amendments that you think are pressing and urgent that we should consider as parliamentarians for it to be passed?
Yes, Senator, I'm happy to answer that one, particularly in relation to 245 AAB. There appears to be a phrase of work arrangement that's used in the context of that provision that does not seem to have a qualifier linking it to a work arrangement directed at unlawful conduct or something that would be improper. We don't want the employers engaging in lawful conduct to be inadvertently captured by this provision. I don't believe that is the intent of this particular provision, and we support the examples that are used in the explanatory memorandum, but the drafting of that particular offence we think should require further amendment as we suggested. Thank you.
I don't know if ACCI wanted to add anything there.
Apologise, I was unmuted, then remuted. Apologies, Senator.
That's all right. That's the story of the last 6 months, isn't it?
Exactly. I think it's in particular, looking at the 13, we restrained ourselves. It's always tempting to try and entirely rewrite anything you're shown, but we were trying to be fairly disciplined and constructive, as I said, within a bill that we think was quite well refined by the exposure draft process. I think the distinction I'd draw is that in the Part 2 and Part 3 on VIVO, on the prohibitions, they are really the sharpest areas where we think the changes we're commending to you are most important. We, like our colleagues from AI Group, we're actually quite supportive of the option of compliance notices and enforceable undertakings. So we have some constructive input there. We think it'd be useful to know which provisions of the Act you're being asked to enter an undertaking to not breach. So there's a bit more exactitude there that could be required. and we would like coordination between the Fair Work Ombudsman and the enforcement authorities in migration. But the more important thing is to get this idea of the VIVO extension to classes of employees correct. And as I join my colleague in the concerns about the prohibitions on employers, and in particular for us, this idea that you can commit a criminal offence through reckless actions, we think we've got a more precise set of wording to give you for the intent. So we take that quite seriously as well.
Okay. Because you able to speak further on the likely impact of the bill on employers of the migrant workers, particularly these new obligations and I guess the accompanying penalties provisions? Are there aspects of those that you'd like to see changed?
I might go in first, and my colleague Ms Lambert or my colleague Ms Street from AI Group might want to add. We see the primary value, or the primary measures are the advice that our organisations provide to our members to comply with the law. So we're in the business of advising people to get it right, not to see themselves in a position where they get it wrong or they're occasioning these penalties. So the penalties are important, and we indicate in there that needs to be an awareness of these new obligations, and we're certainly offering the assistance or the constructive engagement of our members to promote changes in these areas and an understanding amongst employers. But the power doesn't necessarily lie in the punishment. The power lies in the information to comply and the efforts of employers to support compliance. At a certain point, excessive punishments don't work, and we've seen considerable increases in the levels of penalties for underpayments in the past 5 years, quite considerable increases in the levels of penalties for underpayments in the past 5 years. And that has had some effect, but of equal significance is clarity and reform in the nature of the obligations in the area of workplace relations itself, and ensuring employers are as well informed as they can be on what they must do, rather than looking to punish them when the wrong thing is done.
Just before we go to Ms Street, I do note you do raise concerns with Part 3 of the bill, especially about the VIVO requirements, and you make comments to the effect that the bill does nothing to increase certainty or to lessen the disquiet that VIVO obligations can create for employers or the perceived risk of incurring substantial liabilities. I was hoping you might be able to expand on that point just a bit further, and what your concerns are, and if you've got any specific amendments you'd like to suggest to the committee.
What I might do with my colleague Ms Lambert, who has more experience with the VIVO system than I do directly, might like to speak to that. And then, Jenny, if you want to throw back any of the specific amendments, we've certainly outlined those in the bill which we propose.
Yes, thank you, Scott, and thank you, Senator. There is a history here of ongoing discussion with the Department of Government over the VIVO system, not in terms of its very useful tool that it creates. I mean, the ability to access information is very important. But in the context of about a decade ago, when there was changes to the Migration Act in relation to illegal workers, it was a very grey area, or a lack of clarity about the extent to which every single recruitment would require an employer to check a worker's status, and the idea that the millions of people who are recruited are going to be subject to that may create question marks over whether employers are being asked to make assumptions about whether people are citizens or not on the basis of appearance or otherwise. So, in reality, the intention is always to add these regulatory obligations to a basket of enforcement actions that both Border Force and the FWO can take. So in that sense, in that context, as a basket of enforcement actions, it can work quite well. I think if you actually looked at the VIVO requirements or the regulatory requirements standing alone, you'd say, well, what likelihood is there going to be that people are going to check every single recruitment to see that an employer has checked a visa status? I mean, because the vast majority, overwhelming majority of the workforce are Australian citizens. So, vast majority of recruitments occur absolutely irrelevant to the migration provision. So that's the context of the comment. I mean, it's been, it's been a long-standing, a decade-long discussion about this area. In practice, it's proved not to be an issue because, as I say, as part of a basket of enforcement, the migration officials and enforcers, add it to what they're looking at, where there are employees at risk or where they've got concerns. So, that's really if you like, an extension of the comments that were made in the submission, just to acknowledge that there is a long-standing issue around what the expectation is of government, that every single recruitment and every single employee or job seeker will be checked. Thanks very much.
Yeah. Ms Street, did you want to add anything on that point?
Thank you, Senator. I think your question referred to the civil penalty provisions and enforcement measures for compliance. Just to echo the comments of Mr. Barklam, Ms. Lambert there, AI Group, like many other organisations, industry associations, provide comprehensive compliance support, assistance, advice for our members to see that leads to maximise compliance to avoid falling foul of any industrial instrument or laws. It's our preference always that civil contravention processes are in many ways more worker focused than that of criminalising processes against employers by way of practicality in terms of how criminal processes and proceedings are generally given priority in our legal framework. And that's something that we have raised concerns about in the broader wage theft debate. That is this about punishing employers or about remediating employees and getting their money back? So the civil contravention process is one that we've viewed is the preferred method for enforcement and compliance, where all those other mechanisms of enforceable undertakings, prohibition notices, etc., have not worked.
Yeah, thank you. And look, Chair, just last question for Aki. You call for a staggered commencement of the bill. Why do you consider staggered commencement and a staged implementation approach is necessary?
Thank you, Senator. That is no more or no less than a recognition of the uncertain times in which we live. Uncertainty of recovery, and as we speak now, geopolitical uncertainty. We merely made the observation that it struck us as very bald that the commencement arrangement from a single date was a very switch on, switch off for the whole thing, that there might be consideration of the prospect of some parts of it being phased in. That was merely to give the government options. There was no intent, we had no specific intent of asking that any particular bit be delayed or brought forward or brought backwards. It was just to give the government options for the commencement during coming months.
All right, thank you. Thank you, Chair.
Thank you very much. Sorry, just making sure I'm on, not on mute. Thank you very much, Senator Ciccone. Just a couple of questions from me to both the AA Group. Just wanted to expand a little on your proposed amendments to the bill, particularly in relation to this issue of the threshold by which can be found guilty of a criminal. You've raised concerns about the term recklessness, and you're seeking that be amended to, short way of saying this, to a higher threshold. Can you expand on your concerns?
Thank you, Chair. And apologies, you've just broke up a little bit there, but I think I very much got the tenor of the question as you went.
Sorry about that.
That was particularly our submission to bring that forward. We didn't want a higher bar, we want a more precise execution of the concept. Or should I say, firstly, the criminal law, let me perhaps go through it logically this way. We don't think the criminal law should attach in the employment context without an intent to defraud, deprive, do the wrong thing, without knowledge. And we actually, in the submission, go to the references in the Migrant Worker Task Force recommendations to their specific recommendation 19 was developing legislation that a person who knowingly unduly influences, and there are various references to deliberate actions in what was recommended to the government. We are always concerned about any notion of a criminal law in employment picking up anything other than direct intention. But we do want to note that in that part 1 of our submission, we took some of the wording that was actually used to elucidate the concept in the explanatory memorandum, which was willful blindness or reckless indifference. That was the explanation behind the intention of recklessness. And it was like a little light bulb went off for us, and we thought, well, actually, why don't you use that? That's far more precise as to what you're getting at. So we don't say that an employer should be able to stick their head in the sand like an ostrich to absolve themselves of responsibility. But there's an awful lot that can, as Ms. Street will validate, there's an awful lot that can go wrong in employment law with the complexity of the way we regulate work in this country without any intention, or where there's ambiguity or best efforts haven't fully met compliance. It's a very, very complicated system, absolutely littered with potholes and tripping over points and scope and ambiguities and scope for error. So if the government is of a mind to move beyond specific intent and deliberate actions, we think actually within it, the fantastic analysis and elucidation from the AG's department, there's the kernel or the actual execution of a more precise form of words there.
Look, I just raised this particular concern because your recommendation criminality is dependent on migrant worker showing that an employer, knowingly unduly influences, pressures, coerces, etc. It's very hard to prove knowingness.
Well, yes, thank you. I'm sorry, Senator, for any awkwardness. I'm only getting every 4th or 5th word from you. I don't know whether others are experiencing the same problem. And
I don't know whether the Secretary could just advise me whether my audio is coming through loud and clear.
Chair, I think your internet is breaking up.
Is it?
Yes.
It's not too bad, but we also get the noise from the room. So I think that sometimes your audio is cut into when there is noise in the hearing room. I think that's where part of the problem is.
Do you want to try without the video, Sarah?
I was going to say, maybe broadcast and mute us.
Well, I try.
I think they can.
In the spirit of moving on, I think I did understand the question, Senator. Yeah. Thank you.
Let me just put this to you. Recklessness is a standard term in migration law, and what you're proposing for a migrant worker to prove knowingness is a very, very high bar, and we're talking about serious cases here. So we're not talking about industrial relations law. So in migration law, recklessness is a commonly used term in relation to a variety of matters.
Well, we'll go away and look at that further, Senator. But our comments were particularly directed to the criminal element of the offences. So recklessness absolutely should occasion significant civil penalties potentially, but to actually be incarcerated for something and have a criminal record, in a case of a lot of employers lose your business, you lose your licence if you're undertaking a licensed undertaking where you have to be of good character or standing to do the business, they are massive penalties. And we understand a fundamental tenet of the criminal law to be one of intent to commit a crime. Now, we have, as we discussed in the first question, we're not saying it's a black and white either or, but we think there's a more precise execution of recklessness. So perhaps if we can, without being semantic, package it up this way. If the government's intention is to extend it to reckless conduct, then we say that should be executed by a form of wording based on willful blindness or reckless indifference. We think we're getting a far more precise test for what we're talking about, which is not restricted to deliberate intention to deprive or to do the wrong thing.
Well, the criminal law, we won't debate the criminal law and the relevant thresholds which do apply. Doesn't, people can be guilty of a whole range of different criminal conduct, including criminal negligence and the like. So, look, I would appreciate if you could go away and consider these matters further, because I think what you're putting forward is setting a very, very high bar for any prospective migrant worker to have to prove. To prove knowingness is a very difficult threshold. So, look, that would be helpful if you could perhaps take that question on notice, and just having regard to the way in which recklessness is a feature of migration law, if you could, and of course we're talking about the intersectionality between IR law, in Fair Work, migration law. I mean, a lot of different laws are coinciding here, but if you could take that away and have a further look at that, I'd be most grateful.
Thank you.
Just stepping back more broadly for both ACCI and the AI group, you've made obviously a number of recommendations, but in general terms, why do you believe this bill is so important?
Perhaps I will look at that in the terms of broader migration policy. One of the most fundamental tenets of migration policy is confidence and integrity. That is the very basis of which you can garner community support, and you can make sure that the stakeholders in the system, including both the workers and the employees and government, all have confidence in the system. So it is important that the government continues to regulate the migration system in a way that meets communities' expectations about what is required of a sound, progressive migration system. So, a system of which there can be high confidence, and the integrity of the system is important. So, therefore, it is of concern to every employer in the context of our own, representative role as of employers, that the rest of the community has confidence in a system that they think is absolutely essential. As a migration program, as an important complement and supplement to our workforce needs in the country, and therefore, when there are publicity around whether it be underpayment or exploitation of workers, that undermines that confidence. So this bill is obviously part of addressing that need to ensure confidence. And although we've raised a number of recommendations of how the bill can be changed, that doesn't that is not in any way a contradiction of the importance of effective enforcement of the migration laws, and this bill is certainly seen as part of that.
And Ms. Street, your response?
Yes, thank you, Chair. As I mentioned, AI Group supports the intent of this bill. We acknowledge that temporary migrant workers are extremely vulnerable part of the population in the Australian community, and that these laws serve as a robust safety net for their protection. To echo the sentiment expressed by Ms. Lambert, industry invests and has been investing very heavily in compliance in all parts of business, particularly workplace laws and labour practices. And we think that this bill supports industry heading in that direction. As I mentioned, we had identified a number of issues with the drafting of the bill, which are set out in our submission. However, that does not detract from our broad support for what this bill is trying to do. Thank you.
And just a final very brief question from me. What are you both doing, both of your organisations doing, to properly inform your industry members about their obligations under the law?
I might go first on that.
Insofar as the employment of temporary migrant workers.
Thank you, Senator. First and primarily in relation to workplace relations, it's the job of ourselves, of Ms. Street's organisation, of all of our members, to provide compliance information in workplace relations. So we talk a lot about underpayment, and then you've got the more emotive subset that you could that some people characterise as wage theft, and that is all about intent in our view. But our job is to help people get it right. So we have phone rooms in our member organisations, the larger ones, which they sit there all day and answer telephone inquiries. What do I need to pay a so-and-so doing such and such a job at a certain time of the week and a split shift across this time to that time? It's our job to help navigate the uncertainty or the complexity of the Fair Work system and the instruments that are made under it, and help people get it right. That's the primary effort.
Yep.
On migration, a number of our members would have assisted and advised in and Jenny, jump in here if I don't characterise this correctly, but some of our members will have assisted in the migration compliance and navigating that system and be advising employers on what they've agreed to in bringing on a migrant worker. In other areas, those services will come from outside our networks. So people will be seeking independent advice in that half, to which we complement the pay and conditions half to see that that is correct in their day-to-day application. So really, primarily, our job is to help people get it right.
Okay, thanks, Mr. Buckham. I'm going to just try and keep to time as much as I can. And Ms. Lambert, did you want to add anything to that just briefly?
Only just to say that in addition to our normal or industrial advice and migration advice that many of the members would be undertaking, even the consultation on the bill and even in the information, we involve our members completely in making them aware of the proposed changes and seeking their input, and that also will create an educational opportunity between us, our members, of which we have over 80 associations and chambers as members, who then in turn will promulgate it throughout their network. The educational side of this and the awareness raising is absolutely fundamental to improving the integrity of the system. Obviously, it's prevention, not cure, that we're trying to seek here.
Okay, and just very briefly, Ms. Street.
Thank you, Chair. Our compliance with all workplace laws is a bedrock service for AI Group. It's one of our most used services from employers across all industries. Again, we would be absolutely promoting the provisions of this bill as a reminder, as we do for any change in workplace laws, whether it's to rates of pay, award changes, legislative changes. It's something that we take very seriously, and our members take seriously too, is to ensure compliance. We offer a range of services, precedents, template documents to ensure businesses have a system in place to ensure that they're not inadvertently falling foul of the law or appropriate standards, and that's something that we would certainly seek to build on with the passage of this bill. Thank you.
All right, well, look, thank you very much. Look, that brings to a conclusion the committee's examination of both the AI Group and ACCI. So thank you very much for your time, for your submissions and for your evidence today.
Thank you, Chair.
Thank you very much. Thank you, Chair.
Thank you.
Thank you.
For those who are listening, we are moving our program forward. We are actually hoping to finish our program by 4:45 today. So if everyone could bear that in mind as we try and bring the program forward over about 45 minutes. We're now going to welcome the Fair Work Ombudsman. Thank you so much for taking the time to give evidence today. Information about...
Sorry, Sarah.
Yes.
I'm just advised by the Secretary we might need to suspend just for a few minutes whilst the agency connects online. They're just having a few issues at the moment. So could I propose that we suspend just for a couple of minutes while they come into the building?
Yes, absolutely. We'll suspend and we'll resume in 2 moments.
Thank you very much, Chair.
Executive Director of the Engagement Branch, Fair Work Ombudsman.
Thank you, Ms Peters.
And Senator Mark Scully, Deputy Fair Work Ombudsman, Compliance and Enforcement.
Thank you very much, Mr Scully. Look, I will kick off with just a couple of questions for you. I would just be interested, particularly given the importance of your work in protecting migrant workers, could you please provide your response to the importance of the bill?
Thank you, Senator. I might take that one. We were a member of the Migrant Worker Task Force. This bill is obviously aiming to implement 2 of the recommendations from the Migrant Workers Task Force report. We were supportive of that report and have worked collaboratively across government to implement and support other agencies in implementing recommendations that they may be responsible for. So in that regard, we are supportive of the bill.
So what gap is this currently fixing? Could you just explain why this bill and the important provisions and purpose of the bill, and why do you believe this is required?
That's probably more a sort of a policy legislative question, which might be better directed at our policy agency, the Attorney General's Department, who I believe are on after us. From our perspective, obviously the impact of the bill won't be known until it's implemented, if it is implemented. But our sense is that strengthened penalties and things such as the prohibition on employers could serve to have a deterrent effect on employers who may be inclined to do the wrong thing.
Senator, if I might add also that
Mr. Scully.
That the migrant workers and visa holders are what we call vulnerable workers, together with aged young people, non-English speaking background, and that is an enduring priority of the Fair Work Ombudsman. So each year, the Fair Work Ombudsman sets its priorities, strategic priorities, and for this year that includes corporate underpayments, horticulture, the fast food, restaurant and catering industry, sham contracting, franchising and contract cleaning. But underpinning those, we have enduring priorities, which is small business, business employers and employees, as well as vulnerable workers.
And how do you believe that this bill, if passed, will assist you in your work in the protection of migrant workers?
Largely, as Ms Peters indicated, that increased penalties can have a deterrence effect on the industry, but also anything that goes towards reducing the exploitation of vulnerable workers and visa holders is something that we support.
Mr Scully, you've made some very big grounds in the last financial year in terms of recouping underpayments. I referred to this, to some of the statistics earlier in the day. Can you describe the work of the Fair Work Ombudsman in combating underpayments and just including describing how that's particularly focused at supporting migrant workers who would otherwise be exploited?
Sure, Senator, thank you. So the Fair Work Ombudsman's approach to its activities is set out in its publicly available compliance and enforcement policy. And so what we do is we have a number of tests and assessments of matters that come in. So this is our approach to compliance. So we aim to ensure that our resources are used in an efficient, effective and ethical manner, but also take into account public interest tests. So when we receive a request for assistance, for example, we apply initial test as to is it some of our priorities, does it involve vulnerable workers and the like, and then the basis of our investigation and our enforcement outcome, again, it depends on the public interest factors and the scale or impact of the underpayment, the people that are affected by the action, those vulnerable workers, for example, the available evidence and the like. In the last few years, we've taken a tougher approach to enforcement, in that we've moved more to a enforcement outcome approach, which has involved increased use of compliance notices in particular. And if you look at some of the historical outcomes of the Fair Work Ombudsman, you will notice that in the last couple of years and continuing into this year, there's been quite a significant increase in our use of compliance notices.
Mr Scully, for a migrant worker who is being underpaid, how can they raise the alarm bell without putting their own livelihood and their own visa conditions at risk? I mean, what's the mechanism by which they can seek justice? Because this is an issue which has been raised throughout the day, the risks to migrant workers if they do raise complaints or report employers.
Yes. Thank you, Senator. So I might go to Ms. Peters in a moment around the assurance protocol we have with Home Affairs, but we have facilities where people can lodge anonymous reports with us, and we have in language anonymous report facilities. So a visa holder can come to us and lodge an anonymous report. And in the last financial year, we received something like 14,000 anonymous reports, and we use that as part of our intelligence to either react in terms of commencing an investigation or using it to inform our proactive activities, or use it for general intelligence about compliance across the industry. But Ms. Peters, I was wondering if you would like to talk about the assurance protocol, please.
Yes, certainly. Senator, so all workers, anyone working in Australia can come to the Fair Work Ombudsman for advice and assistance relating to workplace matters, but we do understand that concerns around someone's visa may be a barrier to them seeking our assistance. That is why we have agreed with Home Affairs the assurance protocol. That protocol basically provides that if a worker comes to the Fair Work Ombudsman and they are in breach of their visa conditions, with their informed consent, of course, we can provide their details to Home Affairs, and their visa can be protected, basically. To date, 100% of workers that have availed themselves of that assurance protocol have had their visa protected. So I do believe it is an important mechanism. I heard earlier today in evidence as well, also workers being concerned about having their employment terminated if they make a complaint against their employer. And also just to reiterate that the Fair Work Act applies to those visa holders in the same way it does to all workers in Australia, and there are protections under the Fair Work Act for adverse action if someone does take action such as terminating employment because they've made a complaint about their workplace conditions.
So you're saying that 100% of workers, when you've invoked the assurance protocol, have been appropriately protected. How many workers are you talking about?
There have been 77 up to the end of last calendar year.
77 workers.
That's correct.
And do you think that's reflective of the number of migrant workers who are wanting to raise concern? That does seem like a low number of workers.
Yeah, the number may seem low, Senator, but I guess just to clarify that only those workers who are in breach of their visa conditions have need to access the assurance protocol. Other visa holders that come to us, we assist, and we have no need to invoke the assurance protocol because their visa is not in jeopardy. It's not at risk, if you like. So the number of workers that we do refer under the assurance protocol is not reflective of the number of visa holders that we assist. And even then, when we report on data in terms of the number of migrant workers we provide advice and assistance to, that's also probably likely underrepresented. We don't require workers to provide us with their visa status. We know, again, that could be a barrier to people seeking our assistance. Sometimes they volunteer that information to us. Sometimes they volunteer information to us about being in breach of their visa. But unless they do that, it makes no difference in terms of how the Fair Work Act provisions apply to that worker, so we don't necessarily seek that detail from them.
And Ms. Peters, sorry, when the assurance protocol is activated, and so therefore there is no, if there is a technical breach, then it's not acted upon by Home Affairs, what can happen? For instance, if someone's been forced to leave their employment, they're in breach of their visa, can a bridging visa be awarded? How are these workers protected?
That's probably a question for Home Affairs. The decisions to sort of grant, cancel or change visas is a matter purely within the remit of Home Affairs. The FOI's role under the assurance protocol is to engage with the worker in relation to their workplace rights concerns, establish if they're eligible for referral, and then pass those details to Home Affairs for their consideration.
Yes, but you want to make sure that when you're looking after a worker that they're still here in the country. So I assume that you're safeguarding their rights with respect to ensuring that they are able to continue prosecuting their complaint with you under circumstances where they're in a safe environment and that they're no longer at risk of exploitation?
Certainly, Senator, that would be a concern. However, again, it's probably a policy issue for Home Affairs in terms of what additional protections may be available to that visa worker. I would also note as well that workers being outside of Australia is not an impediment to us continuing investigations or court action in relation to workplace relations non-compliance. We have run court cases, for example, where visa holders have returned back home.
And so you've had 14,000 anonymous reports, and that's over. Can you clarify over what period of time have you received those reports?
So that's for the financial year ending 30 June 2021, Senator. So it's for the last full financial year. What I can't give you, unfortunately, is a breakup by language. I've just got the total number with me at the moment, which is, as I said, I think it's around 14 in language offerings that we have for the anonymous reports, but I only have the total with me.
And how many adverse findings have you found against employers across the country as a result of complaints by migrant workers?
So, Senator, in the 2021 financial year, that is the year ending 30th of June 2021, excuse me, we finalised around 630 complaints, formal disputes that related to visa workers, and that is, and in addition, we recovered around $824,000 for those people.
And of the 14,000 reports, which obviously is a significant number of reports, are you satisfied that you've been able to examine all of those reports and assure yourselves that there is no outstanding cases where people are being exploited and not getting justice?
I believe so, Senator. We have an intelligence team that receives and analyses the anonymous report. The anonymous report is only the anonymous report channel is only one source of intelligence that we use to inform our activities, particularly our proactive activities. So we're receiving intelligence from a number of means, from other government organisations, for example, and we collate all that and come up with an annual proactive work plan, as well as some areas of focus for specific targeting based on the intelligence that we receive.
I mean, there's obviously been a number of very high-profile cases involving large corporations which have underpaid their workers. So it certainly seems the message is getting out there, and a number of corporations have in fact self-reported.
Yes.
This is an area that you're taking very, very seriously. What would you say to employers who are currently or who intend to underpay their workers, but with the focus, of course, on temporary migrant workers?
So we would say that all workers of Australia have the same rights and protections under the Fair Work Act, regardless of their visa status, and that this is an area of strategic priority and focus of the organisation in both our reactive as well as our proactive work.
All right, thank you very much, Mr. Scully. I don't have any further questions. Thanks, Ms. Peters. I will now hand over to Senator Ciccone.
Thank you very much, Chair. Just following on from some of the questions from the Chair, in your 2020-21 annual report, I just note that the Fair Work Ombudsman used enforcement tools to deal with the most serious case of non-compliance against migrant workers. You've recovered $824,443 in unpaid wages. The wage recovery for migrant workers by the Ombudsman is, I think, relatively modest, but how many migrant workers had wages recovered by the Ombudsman? Are you able to provide a breakdown? How many of those people are migrant workers? So I think you're on mute, Mr. Scully.
I beg your pardon.
That's okay.
I actually don't know if these numbers add up. I haven't calculated, but the high level number that I have is it was 437 employees that were paid.
And were they all migrant workers, or are they?
That is under the category of visa holders. So yes.
I don't know if you're able to provide a breakdown a bit further. You take that on notice. And what's the
I might take that
total?
on notice.
What's the total
Yes,
number?
I might take that on notice because the numbers that I'm looking at, the schedule doesn't quite add up to what I expected to add up. So I will take that on notice.
All right. I'm also interested to know how this compares with the Ombudsman's estimate of prevalence of wage theft amongst migrant workers as well too.
So, Senator, I think the Fair Work Ombudsman, Ms Parker, has reported at Send Estimates that we don't do estimates of total underpayments because extrapolating our view, and we're not trying to be difficult at all with this, but our view is that our activities are focused on areas where we know there are underpayments and contraventions of the Act, and any extrapolation of those results would give a misleading picture. So we don't do any analysis or estimates of total underpayments across any particular sector or industry.
In the report too, I know that the vast majority of recovery for wage underpayments is driven by employer self-reporting. How many of these employees in your annual report, and I think you make reference to 49 matters that were self-reported, which resulted in a back pay of over $100 million in total, covering more than 54,500 employees. How many of these employees received back payments were migrant workers?
We don't have that information, Senator, because as Ms Peters indicated, we don't ask for that information, or we don't require that information from workers, and also we don't necessarily ask for detailed analysis of the amounts repaid by organisations that self-reporting. I mean, we get a listing of names and amounts and details of the contravention that resulted in that amount, which we would obviously check to be satisfied that it is correct, but that doesn't necessarily extend to the visa status of those employees.
I mean, wouldn't that help, I guess, with your policy decisions? I mean, not just for your agency, but also for the department as well too. I'm just surprised that you just wouldn't collect that type of data. The more data we have, the better, I guess, picture that we can then tackle the issue.
Yeah. So the question is it available? And in some cases it probably is, in some places it probably is not. But also for the Fair Work Ombudsman ourselves, there are some privacy concerns and issues that we just need to be really mindful of in terms of the data we collect and what we actually need for our activities.
But do you have any? I just want to quickly turn to some of the text in the bill. I think Part 1, Clause 4, it's under Section 245 AAA and AAB. Comes under the header of new employer sanctions, and it includes some text which in its current form encompasses all persons and not just employers. So for instance, you might have a case where a temporary visa worker suggests to another temporary visa worker that they should engage in more hours and therefore breaching their conditions. Do you think they, or that scenario, they should be subject to the, I guess, potential penalties of a 2-year imprisonment?
Senator, unfortunately, I don't have a copy of the bill.
No, I accept that.
Anyway,
yeah.
But I think, again, that's probably a policy and legislative question that's best directed at the Attorney General's Department and Home Affairs.
Okay, I mean, does your agency or has your agency been asked to express views about the drafting of this bill?
The Migrant Workers Interagency Group, which was the cross-government group that was established to implement the Migrant Worker Task Force recommendations, was consulted on the bill, and we've also been consulted through the Attorney General's Department as the responsible policy agency.
And as part of that, what has the Ombudsman's, I guess, provided the department in terms of its advice?
I'd need to take that on notice, but I believe our feedback and input went primarily to Fair Work Act provisions that would be included, and matters more directly related to our functions.
Are there any gaps in the current Fair Work, I guess, framework that you'd like to see fixed that goes to the issue of exploitation? Are there still, what are the gaps from your perspective?
again, that's probably a policy question, Senator. I'm not, sorry, I feel like I sound.
No,
like
and I get that, but as the
regulator,
agency
so
that's, I guess, got the power to enforce the rules, surely you've got views
Senator
to...
Ciccone, it's just to remind you that Ms Peters is limited in giving opinions on matters of policy. So
No, and I accept that, Chair, but the agency must also provide advice to the relevant, I guess, departments that develop the framework. Surely the agency has provided advice or feedback back to the department.
We liaise closely with the Attorney General's Department, obviously, in terms of our actions, and I think what I would say is that we use what we've got available to us in terms of enforcement tools, resources, whatever that may be, and the framework, and try to apply our efforts in a strategic way so that we can have the greatest impact with those.
But the Ombudsman does go back to the department with, views or feedback about current legislative frameworks. Do you not?
We are occasionally asked for input on things as such as these bills, which that input, again, as I said, normally goes to our experience, things like our data, our compliance and enforcement figures and the like.
So was input sought then about this particular bill?
Yes, I think I noted, Senator, that we did provide some feedback on the bill through the Attorney General's Department relating to the Fair Work Act provisions that are noted in there.
Senator, maybe that's a question for the department who are coming up next too, because I think Ms Peters and I don't have that level of visibility about the input that was provided by the organisation. The department would be well placed to respond to that, I think.
Yep. Look, just one other question I want to ask you too. I note that so the Ombudsman obviously has offices in the major capital cities around the country. Do you have inspectors in any regional parts of Australia?
We do, Senator. So we have, and I hope you, we have between 22 and 23 offices. I'm not quite sure just the number, but that includes all capital cities as well as regional locations. And
how many in regional?
I can't tell you off the top of my head the number of people, but I can tell you that we have 46 Fair Work inspectors in regional offices. But if you're asking about the total number of staff, I'd need to take that on notice.
And how many, if you could take on notice, or if you've got this figure available, but how many inspectors total do you have?
176, Senator, as at the 31st of December 2021.
Okay. And then we believe there's around, 40 odd that are in regional?
Included in that number is about 46 in regional offices.
And, all right, if you could also just take on notice, if you're able to provide with a specific figure, if you have to check, that would be great. All right, I might leave it there for now, Chair, unless there's any other senators that have questions.
No, there's not. Thank you very much, Senator Ciccone. That brings to a conclusion the committee's examination in relation to this bill inquiry. That's so Fair Work Ombudsman. I appreciate very much your time and your evidence. Thank you so much.
Thank you.
The committee will now suspend for afternoon tea and resume in 10 minutes. The committee is now in session, and it's my pleasure to welcome representatives of the Department of Home Affairs and the Attorney General's Department. Thank you so much for giving time and your evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. I remind and witnesses that the Senate has resolved that an officer of a Department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. The committee has received the Department of Home Affairs submission as submission 13. Good afternoon to officers. Do you wish to make any corrections to your submission?
Not for the Department of Home Affairs.
Thank you. The committee has not received a submission from the Attorney General's Department. For the Could you please each state your full names and the capacity in which you appear today?
Cheryl Ann Moy, Deputy Secretary, Immigration and Settlement Services Group, Department of Home Affairs.
Tara Kavanagh, First Assistant Secretary, Immigration, Integrity, Assurance and Policy, Department of Home Affairs.
Thanks, Ms Kavanagh.
Ryan Perry, Director of Workplace Enforcement Section, Attorney General's Department.
Danica Yanchenko, Assistant Secretary, Workplace Compliance and Enforcement Policy Branch, Attorney General's Department.
Adrian Breen, Assistant Secretary of the Safety, Compensation and Institutions Branch, Attorney General's Department.
Thank you all very much. Do you have an opening statement before we move to questions?
Not for the Department of Home Affairs, Chair.
Nor for Attorney Generals. Thank you, Chair.
Right, we will now go to questions. Look, I'll kick off with a couple to start off with. I expect that you've heard the evidence this morning and read the submissions, particularly from the various unions, and obviously who've raised a number of deep concerns about the bill. To each of both Home Affairs and Attorney Generals, are you able to respond in general terms in relation to some of the major concerns raised?
Senator, for the Department of Home Affairs, I have seen some of the this morning's broadcast. I have not seen all. Are there particular matters that you'd like us to respond to raised by the unions?
Well, they're obviously also outlined in their submissions, Ms Moy, but they include a range of matters, lack of representation, concerns in relation to a migrant worker not being able to make a complaint for fear of the consequences of losing their visa and deportation. So it's been a broad range of concerns raised, and I'm hoping you might be able to address those.
Sure. Senator, you'd be aware that the bill seeks to implement recommendations 19 and 20 of the Migrant Workers Task Force, which commenced back in 2016. There was a large number of recommendations. 19 and 20 were those to be implemented by the Department of Home Affairs. The implementation of the bill is to actually raise awareness, increase the penalties and increase the new powers for the Minister to prohibit certain employers from employing migrant workers, and that goes to the nub of the issue of anyone who is mistreating employees. In terms of arrangements that currently exist, and many of these have been explored through Senate estimates committees in regard to the PALM program, particularly led by DFAT. And while not talking on behalf of DFAT, I am aware of the enforcement arrangements within those programs, and also the ability within those programs for employees to raise issues in terms of 24/7 hotlines, the seasonal worker hotline, and also to raise issues with their welfare officers who are placed within the program within the areas that these individuals may be working. So there are avenues for people to raise those, and I know that the Fair Work Ombudsman and the department through the ABF have an agreement whereby through an assurance protocol we have an arrangement where individuals can come to the department or the Fair Work Ombudsman and raise issues, and we actually have protocols in place which support the continuation of any of their visas should the matter relate to the employer's issues with the employer and mistreatment. And we've had 77 people come through that program. Not one of them has had a visa cancelled or limited or reduced due to that engagement.
Yes, the Fair Work Ombudsman has just given evidence in relation to the assurance protocol, and that does seem to be working very well. I did ask a question which I'd like to direct to you in relation to where there has been a breach of a visa and the assurance protocol has been raised. The Department of Home Affairs manage the breaches of visas such that the migrant worker is properly protected.
Yeah, so any breach of a visa is dealt with in the first instance through education. So our prime arrangement is to be able to connect the individual back with their employer if it's appropriate to do so, or to look at another sponsored employment arrangement for that individual. So the first premise certainly is not to cancel a visa. We have these visa programs in place for a particular reason, to actually be able to support the industries that make use of these visas. And so our first point of call is education. The only time we would look at cancelling a visa is where a person refused to re-engage with the program, or where they had it had come to our attention that there were character or security issues.
And what do you think about the proposal that there should be a special type of visa, like a justice-related visa, under circumstances where a migrant worker does raise a complaint? Is that necessary?
I think the protections are in place at the moment for employees as visa holders to be able to raise issues with the department, with the Fair Work Ombudsman, with DFAT, as the leaders of the DORF, the leader of the PALM program, for example. So no, I think the current arrangements plus the protections that come with this bill provide individuals with that support.
I just wanted to ask you about the Retail Supply Chain Alliance evidence, and also refer to the submission in pages 8 and 9. The Alliance has raised concerns about the appropriateness of investigation and enforcement powers proposed in the bill sitting with the Department and the Minister for Home Affairs rather than with the Fair Work Ombudsman. What's the rationale for these powers being vested with the Minister when other labour and industrial relations offences are generally enforced by the Fair Work Ombudsman?
The arrangements with these visas as a sponsoring employer, beg your pardon, means that the arrangements are actually part of the migration program. They're actually part of the conditions that an individual signs up to, either as the employee in the arrangement, where they may come in through the seasonal worker program or the PALM program, or as a sponsoring employer, who may be someone in agriculture or horticulture or another industry, whereby they actually agree to certain visa conditions and arrangements under the migration program to support that employee to come into Australia and work for them for a specific period of time. So for that reason, it's actually part of the migration program that this sits under.
Look, I don't have any further questions at this time. I will now hand over to other senators and give the call to Senator Ciccone.
Thanks a lot, Chair. And good afternoon to the departments. Can I just start with the powers? It's been rested. The Chair mentioned earlier the decision to rest the power to issue prohibition orders with, I guess, the Minister or Attorney General rather than the Ombudsman or the Fair Work Commission. Is this consistent with other similar legislation? Just trying to understand the consistencies that we have with other Australian laws. I find it somewhat unusual, that's all. I think that's probably the question that the Chair was also asking as well.
Sure. Look, the question of where that particular power should lay was the subject of discussion through the Migrant Worker Task Force that Home Affairs has been engaged on for several years with our colleagues from Attorney General's Department and the Fair Work Ombudsman. The ultimate drafting of the legislation reflected where that conversation landed was that because the bill seeks to address misuse of visa programs, it was most appropriate for the Minister for Immigration to have that power. It is consistent in that the Minister has a number of powers under the Migration Act. The Act really is drafted with the Minister and his delegations in mind. So that was felt to be appropriate and consistent with the rest of the Act.
Okay. So look, I'm not trying to put words in your mouth, but it's generally not consistent with how we do things generally. But in this case, because it comes under the visa program, the view was to vest the power with the Minister rather than the Ombudsman.
That's correct.
All right. A specific exemption has been made in the bill for domestic work. Why is this?
Thank you. And look, this probably is an area where it would be good to clarify some of the conversation from earlier today. I did hear some of the previous presenters mention that there's an exception for domestic work that, for example, would go as far as covering the scenario of an au pair. That is not the case. The bill is drafted in a manner that is broad enough to cover a wide variety of employer-employee relationships, including a situation where someone has employed an au pair to work in their home. The domestic exemption has been drafted to cover the situation where an employer has engaged in conduct that has resulted in a sanction, has subsequently been prohibited, but then, for example, faces a situation where he or she may need to engage the services of, for example, a tradesperson to fix a tap or a small matter within their own home. The exception is meant to cover that scenario, not ongoing employment in the domestic context.
So the au pairs, like, that doesn't fit into that category, is that what you're saying from earlier today?
No, that is correct. An au pair employment arrangement would be covered by the legislation.
Okay. In the text of the bill, there's that 245 AAA and AAB under the heading of the new employer sanctions, and I've asked the Ombudsman earlier about this, but it includes text which in its current form, I think for me, gives the impression that encompasses all persons. So, for instance, it's not just employers. Is this the intention where you might have a situation of two temporary visa holders working, one suggests to the other that they could do extra hours, obviously then they would be in breach of the regulation, and there might be a potential penalty of up to 2 years imprisonment. Is that the intention of the bill?
No, Senator. I can confirm that's not the intention of the bill. There's no intention to capture a conversation that may be had between two colleagues in the workplace.
So only just for employers then?
That's right. The bill has been drafted to cover employers, but it is a broad definition that we have used, and that is specifically so that we can cover a variety of employment situations. So, for example, the term refers for work would make sure that we are also able to capture the behaviour of a labour hire intermediary, which we thought was very important for this piece of legislation.
Right, okay. How's intended, how is it intended in this bill, if it's passed, that it interacts with the PALM, I guess? And I know DFAT's not here today, but noting, I guess, that there are other standards that employers will have to meet as part of other programs. Is it the intention of the government that the PALM schemes will be superior for attracting these overseas workers, and if they were to come here on an ag visa, for instance? I'm just interested in the interactions between the protections in this bill and other visa programs, such as the ag visa.
Sure. So there are currently already frameworks in place under the Migration Act that seek to ensure lawful employment of migrant workers. That includes the Sponsorship Obligations Framework. That framework currently applies to any visa where a migrant worker is formally sponsored under the Act. That includes the PALM program and a number of other visas. This legislation does not seek to undermine any of those arrangements. It builds upon those frameworks and enhances them, particularly through the introduction of new offences.
So the ag visa, for instance, whatever the framework that we've got now, won't override any of these protections?
No, absolutely not. No. this legislation would enhance the protections already in place.
So the PALM schemes obviously would be whatever arrangements are contained within that program. Does it interact with this, as in it doesn't override the protections within the bill?
No.
Okay.
No, absolutely
Right.
not. No. There's probably no, it doesn't.
Sorry, because I ask, because just to go back to what we were discussing about that 245 section, it talks about all persons. So is it the intention to clarify that particular phrase in the EM or in the bill? Because my earlier, I guess, scenario, how does one, when they look at the bill, when it refers to all persons, how do we get from a situation where it's not about two employees, but in actual fact about the employer? So is there going to be some clarifying remarks or amendments to the bill with respect to those clauses?
The intention would be, I guess, to see any recommendations, for example, that might come out of this process, and it would then be a decision for government.
Okay, but you haven't had any other feedback to date other than waiting to see what comes from this committee?
Look, we have, of course, looked at all of the submissions that have been provided through the legislative process very carefully, and we've already incorporated many of those submissions into the drafting of the bill. As I said before, I think that broad definition that you're referring to has been done intentionally so that we can cover labour hire intermediaries, and that was felt to be a very important objective of this legislation.
Okay. Also, just another few things, a few other questions. The migration regulations variously state that the holder must cease to be employed by the employer in relation to which the visa was granted. Under these provisions, if a visa holder quits their employment because they've not been paid lawfully by their employer, would they be in breach of their visa conditions?
So, Senator, each situation, as you'll appreciate, is very different. If they were a sponsored employee, so they come in as a sponsored employee. If they have an issue with what they're being paid, they have various avenues in terms of Fair Work Ombudsman, talking to their welfare officer. If they quit their program, it goes back to what we talked about a little bit earlier, where we look at, we as in the department, look at talking to them around education of what the issue is, assisting them with where they can report those issues, and then trying to either reconnect them to the employer in a positive way, or looking at a different sponsored program.
Okay, so even if they were to quit, maybe not to do with pay or conditions, but they were sexually assaulted, would they also be in breach of their visa condition?
It's exactly the same issue. We'd be talking to them about where they go to report issues of their pay. A matter of sexual assault, we'd obviously be talking to them about their law enforcement options of where they can report that.
And if they were directed to perform a different occupation or under threat for being deported by the employer, would they also be in breach of their visa conditions? Is this something they can come to the department and talk to you about as part of the protocols or the assurance protocols?
They can come to the department, they can come to the Fair Work Ombudsman, they can come to DFAT, they can call the 24/7 hotline or the seasonal worker line. There's avenues for them to raise those issues so that we can actually look at their visa conditions and regularise them for them by either assisting them with a new sponsored employment process or via reconnecting them to their employer. And that depends on, again, what the individual issue is with that person. But where somebody, as I mentioned earlier, the individuals who would be looking at cancelling their visa or giving them a notice to say that we're thinking about cancelling their visa with an intent to cancel, that's usually related to people who refuse to engage in the program and refuse to re-engage in the arrangement that they signed up for. Because as you'd appreciate, when people come out for some of these programs, the employer pays their airfares, their travel, cash advances, those sorts of things. So the employer recovers those over a 12-week period in agreement with the individual. So depending on where they disconnect from their employment in that process or in a later process, goes to the discussions and arrangements that we have with them to regularise their visa
What I'm trying to
conditions.
understand is the visa holder deemed as the person in breach, or is it the employer, or is it both?
Can be both, and under this Act there's many more protections which allow higher levels of penalty units and cost in regard to the conditions.
So the employee or the worker hasn't done the wrong
for
thing.
the employer.
But they are breaching their conditions of their visa by virtue of the employer doing the wrong thing. Are they in breach of their conditions because their employers acted against their conditions?
So the individual to be in breach of their visa would have to break the visa conditions that they have signed up for. If the employer breaks the conditions, then there's avenues to address that with the employer. There's avenues to address if the individual breaches their own visa conditions. As a general rule, it would have to be a positive breach on part of the individual visa holder for us to be considering it to be a breach of their visa.
The assurance protocol, is that advertised to people once they're on a visa to let them know that
Yes, it is.
this exists? Because I mean, many people have also asked for that firewall between the Fair Work Ombudsman and the department, where they obviously want people to come forward and report exploitation. So, and the figure was what, 77?
77.
And how does that compare to previous years?
So that's 77 in total since the protocol's been in place.
How long has it been now?
I have to come back to you with the actual date, but the Fair Work Ombudsman will generally come to us, or come to the ABF, so, sorry, representing the ABF as well.
Yep.
They will generally come to the ABF and say, we have an individual, this is the situation, this is the issue. The ABF will then look to reconnect that person with a sponsoring employer and look at what their visa conditions are. If that person has been, for want of a better example, threatened or told that, their visa will be cancelled, etc., we can actually look at their visa eligibility and conditions, and in those cases that have been referred to us, 77 people, nobody has had a visa cancelled. So we're actually looking for a positive reconnection to their program or a positive outcome in terms of that person being here for employment.
According to the explanatory memorandum, the bill's intended to implement recommendations 19 and 20 of the Migrant Workers Task Force from March 2019. Just want to know from the Attorney General's Department, can you speak to the progress of implementing the remainder of the recommendations?
Sure, Senator. Thanks for the question. So there's been a range of progress on implementing the 22 recommendations from the report since it all those recommendations were accepted in principle by the government. So the status of those 22, 12 of them are now completely implemented or complete, and 10 are ongoing. So as you'd appreciate, some of those different recommendations raise different levels of complexity in terms of implementing them. So there's been a range of different sort of tracks, if you will, that those have progressed down. The very first recommendation is, as my colleagues from Home Affairs indicated earlier, that we have a inter-agency working group that meets regularly to assist in the implementation of the recommendations. And that has met 8 times since it was first established, most recently yesterday. We've also implemented a range of other measures to support the other 11 of the 12 that are now complete of the recommendations, including enhancing the education materials that are in the domain through the Fair Work Ombudsman, with particular respect to the migrant worker cohorts we're talking about here, and also international students. There's been education materials there with the Study Australia website as well. We've got $180 million since 2016 that the government's provided to the Fair Work Ombudsman, in addition to assist it as the workplace regulator as well. And there's been work undertaken with respect to mapping accommodation exploitation at all levels of government, and that's been provided to ministers as well.
And what about a national labour hire scheme?
Yeah, so thank you, Senator. So work is underway on that as well. Last year in June, I believe, the Attorney General and Minister for Industrial Relations wrote to her state and territory counterparts suggesting that they work together to look at opportunities to harmonise labour hire schemes across the country. I still appreciate that there are currently a couple in place already in some jurisdictions. Last year through September, there was a meeting of ministers at which they tasked officials across all levels, the Commonwealth and the states and territories to prepare a report for ministers on those opportunities, and that report's now been finalised.
There's also been some discussions today about the FEG, or the Fair Entitlements Guarantee Scheme.
Yes.
I don't know if you're also able to touch on that, whether the inclusion of temporary migrants is part of that scheme.
So that's distinct from the labour hire regulation kind of item, different recommendations, Senator,
Yeah.
but I can comment if you like
could,
on
please.
that
Yeah.
recommendation. Yeah, so certainly, as I said, the government has accepted that recommendation, and there's been a report, advice provided to government about it, but there's not been, I don't have any kind of further updates in terms of timing for that.
All right. Chair, I'm just, I've got a few others, but I'm not happy to pass to Senator Van or Senator Kim Carr if he's on the line.
Yeah, I'm there. I've only got one question because I think Raph, you've done a fantastic job with all of this. If I could ask at some point, Madam Chair, I've just one question to the officials.
Thanks, Senator Carr. Yes, you have the call.
Look, I just noticed the extraordinary confidence the officials have in the efficacy of the programs you have in operation. 77 cases of people that haven't had their visas withdrawn is an incredibly small number given the size of the program and given the number of people that I've actually dealt with. I take, for instance, I mentioned before the Warrnambool Meat Works. There were over 90 people there who were stood down, locked out. So on tape, the employer indicated to them that if they didn't do what he wanted them to do, that is when they joined the union, and desisted from that, then they'd be sent home. One of them was actually assaulted, but he in turn was threatened with deportation and claimed that he was the one doing the assaulting. And in fact, the person was under such duress that left the country. And given the power of that employer in that town, you can understand why people were so anxious. I know I've dealt with this case as a constituent issue because those people did come to us to try to seek some relief. And I do want to congratulate the department officials that assisted me in this matter. But there we had a case where the employer was able to go to other employers and say, don't touch any of these people. They can't be, they actually made it very, very difficult to actually get them to find another sponsored employer. Now, there's a case, and I've had many cases like this throughout my time, where the power of the employers in rural areas is such that the individual worker is faced with an incredibly difficult situation to enforce whatever rights they have theoretically at law, and faced with the circumstances where they don't speak the language, they don't have the power networks to be able to counter the influence of a major employer in a provincial town. I'm wondering why we should have confidence that the existing enforcement mechanisms are in fact able to provide any effective defence for individual visa holders.
Thanks, Senator Carr. I just might comment in regard to and recognise those situations exist, and situations are individual all the way from that example that you provide through to groups of people and individuals in different industries. The 77 that were referred to earlier is the total number of referrals that we've had from the Fair Work Ombudsman. So that's people who have gone to the Fair Work Ombudsman, and the Fair Work Ombudsman has engaged with ABF. So of the 77, that the confidence I have in that is that 100% of the people referred to us have not had their visa cancelled. In terms of the, you're right, in terms of the power imbalance, that can sometimes exist between an employer and employee, particularly in communities of perhaps more vulnerable individuals regarding language, etc. I'll just get Ms Kavanagh to talk to that in terms of how this bill is actually built to assist those particular individuals.
Thank you. In terms of the protocol itself, I think it's important to note that it is not simply incumbent upon a worker themselves to report a matter. There's many mechanisms by which these measures already are identified, including through our Border Watch allegation and referral team. Anyone can make a call to that team and provide us with information about a case of inappropriate behaviour towards a migrant worker. And we really would encourage stakeholders to do that. The protocol is supported by a range of information sharing protocols that we have with the Fair Work Ombudsman, but also it is secured within operational policy documents that our staff are trained on and that they follow. I note this morning there was some comments that the department could quite easily implement operational policy in regard to the protocol. I'd just like to clarify that that has indeed already been done. It is secured in a range of administrative documents that we review on a regular basis and which our staff follow. Senator Carr's example that he's just spoken about in regard to a situation of employers, if you like, being threatened with certain actions unless they agree to workplace conditions, is a very good example of how this legislation would assist to ensure that effective action can be taken against employers who do the wrong thing by migrant workers. So it would introduce two new offences. One, it will be an offence for a person to unduly influence, pressure or coerce a non-citizen to accept a work arrangement that would result in them breaching a work condition of their visa. And two, it will be an offence for a person to coerce or exert undue influence or pressure on a non-citizen to accept or agree to a work arrangement in order to avoid an adverse effect on the non-citizen's immigrant status. If I heard it correctly, and the line was a little bit fuzzy, but I believe the scenario that was just outlined would potentially invoke both of those offences, which would then enable us to initiate proceedings against that employer and ensure that appropriate sanctions were put in place so that they could not undertake that behaviour again.
Senator Carr, you've completed your questions.
I said only one question, but it's a remarkably romantic view about how the economy actually works. Thank you.
Thank you very much, Senator Carr. I will now hand over to Senator Van.
Thank you, Chair, and thank you everyone for appearing this afternoon. Wish we had have had you appear first thing this morning. I think we could have saved a lot of people a lot of time during the day. Can Home Affairs confirm which type of offences or contraventions it would give rise to a prohibition?
Certainly, Senator. So there's three broad scenarios where a person could become a prohibited employer. That is where they're convicted of a work-related offence under the Migration Act. It's where they're the subject of a court order for contravention of either a work-related provision of the Migration Act or certain civil remedy provisions of the Fair Work Act, or where they are the subject of a bar as an approved work sponsor under the Migration Act's framework.
So it's clear then that these powers will only be used sparingly and for the most serious cases. Is that the cases of exploitation in effect? Is that correct?
That's right. So two of those scenarios involve there being a court-related decision, which does indicate that it's anticipated they would be used for the more serious range of offences.
And how will more trivial offences be dealt with?
So we at the moment, I should just make it very clear that under the Migration Act's sponsorship framework, there is already the ability for a sponsor to be barred, and I think our statistics show that over the last 4 years, several hundred sponsors have been barred for breaches of their obligations under that framework. So that can continue to be used in the case of an employer who is part of a sponsorship arrangement. But I guess more broadly, where there are sanctions applied in less serious cases, what this legislation does is provide us with a broader range of sanctioning powers.
So those
that
broader
can be
range
applied.
would be compliance notices and enforceable undertakings, that sort of thing?
Exactly. It gives us overall a proportionate, scalable system where we can, in terms of a minor offence, start where some cases start now with education awareness raising,
Yep.
and that can be escalated where we don't see a change in behaviour.
And so that tells me that employers will be given natural justice if something comes up. And would it be fair to say that the impact on the business, on the workers and on the community would be weighed up before any sanction is imposed?
That's right, Senator. The legislation anticipates that natural justice would be applied to a decision to consider prohibiting an employer. There would also be an ability of an employer to seek to have that matter reviewed. But yes, it is anticipated that in making a decision, the Minister would weigh up a broad range of information, and it would be open to the employer to put forward details of the particular impact on them, their business, their industry or their regional area for the Minister to consider.
Thank you. And can Home Affairs explain how this bill will impact those employers that we've heard about coercive behaviour today? Can you talk to how they will be impacted? And I note a couple of case studies in your submission that talk to that.
So the bill recognises that there are some employers who seek to use a migrant worker's visa status to exploit them in the workplace. It allows us, as I stated before, 2 new offences that allow us to take specific action in those cases. Some examples would be, for example, in a situation where an employer was placing pressure on a worker to breach the conditions of their visa. So, for example, threatening a student, they may lose their job if they worked more than their fortnightly working hours. That would give us the ability to take action against that employer. Likewise, the offences also cover the situation of working holiday makers. So the bill covers the situation where an employer not only threatens or applies pressure or coerces an employee to breach a visa condition, it covers the situation where they might apply that undue pressure to get a non-citizen to accept or agree to a work arrangement in order to avoid an adverse effect on their visa, on a future visa. So, for example, that would cover the situation of an employer who says to a working holiday maker, if you don't agree to do additional work or this type of work for this pay, we will not provide you with evidence of work already done in order to help you get your second visa.
Sure.
So we have very specifically tried to draft those two offences in a way that covers the specific circumstances that the task force has identified can arise for temporary visa holders.
Thank you. Earlier on, we heard numerous times people talking about the term reckless. Can you explain what that means in migration law?
Certainly. So I think that was in regard to the fault element for the new offences having been drafted as knowledge or recklessness. The term recklessness has been included to ensure that a person cannot be willfully ignorant of a work-related condition of the visa of a non-citizen they allow to work. In effect, there can't be a defence or a claim that they didn't inquire about the work-related conditions of a person's visa. The term recklessness does lower the threshold below knowledge, but still to a criminal standard, and we feel that that is an appropriate standard. It is consistent with other work-related offences in the Migration Act. I think even more importantly, if the new offences didn't expressly state knowledge or recklessness, the Criminal Code would in any case provide that recklessness would be the default fault element.
Thank you. So, listening to all that, would I be right in saying I'll put this in two parts. This really just improves protections for migrant workers, doesn't it?
That's right. It provides...
It's not intended to or designed to rewrite the whole migrant workers scheme. Is that correct?
That's correct. The purpose of this bill is to increase the protections for migrant workers. The protection requirements have been, I think, laid out over time, certainly through the Migrant Task Force, which produced its report, and 19 and 20 recommendations are specifically dealt with by this amendment. Excuse me. And it is meant to increase the protection for migrant workers and to address the way that we, within the migration framework, can work with employers to improve the position or the conditions that they also work with. So, for example, the enforceable undertakings enables us to have a legal arrangement with an employer who may have not been acting in a totally appropriate way to actually bring them back into a position and a process whereby they can continue to employ workers and continue to improve the arrangements that they have with those migrant workers. And it's legally enforceable, but what it doesn't require is us to go to court and to have infringement notices given upon those employers at the time. So it provides both sides.
Thank you.
If I could add, they complement, the provisions in the bill complement the existing framework under the Fair Work Act and the evidence you heard from the Fair Work Ombudsman earlier in terms of its ability to enforce and so forth.
Thank you. One last question for AGD. Recommendations 4, 5, 6, 7, 10 and 12. What is the government, what actions has the government taken on those recommendations previously?
So, Senator, if I have my recommendation numbers correctly in my head, those were the provisions that were put to the Parliament last year as part of the what's known as the SAGER Bill, Supporting Australia's Jobs and Economic Recovery Bill, and the particular provisions that would have addressed those recommendations were removed when the bill was debated by the Senate.
So, and removed by, I'm going to, not trying to put words in your mouth, but weren't removed by government senators, I'm guessing.
I would have to take that on notice. I don't remember who moved the particular amendments, I'm afraid, Senator.
I think I'm aware, and Raf might be able to help me out on that.
I don't know, Senator, what are you suggesting?
I'm suggesting Labor voted them out of the bill. Thank you very much, everyone.
That question has been taken on notice, so we'll leave it to the department to fill in the gaps there. But thank you very much, Senator Van. Look, just very, very briefly, we are very close to finishing. I just wanted to clarify with the department that in relation to these powers that will be included in the bill, I just want to understand that these powers have been used in other contexts for some time. So for skilled employers, for sponsored visas. So these powers extend existing best practice employers of temporary visa holders. I just want you to clarify that, please.
Thank you, Senator. Yes, that's correct. The measures in this bill complement and help us to lift and better address behaviour that is inappropriate in regard to migrant workers. But we do currently have a number of frameworks in place that are used to ensure that the employers of migrants do the right thing. There are broad obligations on any employer who employs a non-citizen through the Act. There is a sponsorship obligation framework in place which outlines a number of obligations that somebody who is sponsoring a worker from overseas needs to adhere to. That particular framework is supported by a sponsor monitoring unit that sits within the ABF, whose role it is to monitor the behaviour of those employers, work with them in terms of education, compliance with their obligations, and to take sanctioning action against employers when they do not meet their obligations. There is also a paying for visa sponsorship framework in place, which seeks to ensure that a sponsor cannot, for example, demand payment for a visa applicant or visa holder in return for visa sponsorship. Again, that is enforced and monitored by our colleagues in the ABF.
All right, thank you. Thank you so much. I just wanted to raise that issue. Look, that concludes the committee's examination of the Attorney General's Department and the Home Affairs Department. We really thank you very much for your time and for your evidence today.
Thank you, Chair.
Thank you, Chair. Thank you, Senators.
We are now at the end of our program. I am seeking, I'm just now going to put a motion that the committee accepts any tabled documents from the day's proceedings. All those in favour, all those against, that is carried. I also are putting to the committee a motion that the deadline for the return of answers to questions taken on notice is Wednesday, the 2nd of March, 2022. All those in favour, all those against, that carried. I want to again thank all witnesses for their evidence today. I also want to thank Hansard Broadcasting and the Secretariat. Because I'm doing this remotely, I just want to check with the Secretariat that there is nothing else in order, nothing else required. We have the appropriate motions. Speak now or forever hold your peace. Sophie?
All good.
All good? Oh, yeah,
good.
Fantastic.
Sophie's giving us a
Thank you,
thumbs up.
Sophie. I even have broadcasting cut to you looking fabulous, so I can see your thumbs up. Thank you very much, everyone. We really appreciate your time and your evidence today. The committee is adjourned.
Thanks a lot.